Hello and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us today. Really appreciate you guys being with us on a cold winter day here in the United States for most of us. And we are continuing our exploration into the Slender Man stabbing case with Morgan Geyser, Anissa Weier, and Payton Leutner. So, Sassy, good to see you. Kathy, got to fill your thermos today. Good morning to you, Sassy 3 fan. Deviant, good day. Just got in bed. Very good. Jennifer, good morning to you. Bam Bam. Alice, good to see you. Carson, good morning. Crazy Mary Joe. And Barry Adams, good to see you guys. 80s Music Man. Allie B, good morning to you. Sherry, just seeing who was first in chat. Her baby's mom. Selena K, congratulations on 11 months. Joanne Jedi Platypus, good morning to you. You will be lurking for a bit. No problem. Rat, good to see you. Thank you for joining. Joyce, good morning, good morning. Golden Girl, I always watch, just don't comment much. No problem. Thank you for watching. Appreciate that. Just Shamrock, Sweet Vampy, the McCormick family. Iowa Backyard, great show with Rex last night. Thank you, guys. Thank you for watching. Really appreciate you guys watching. Melissa and Angelique, good morning to you. Hector's mom, good to see you. Amy, thank you for joining us. All right. Linda, good morning to you. Marlene, 22 degrees outside with no snow. Yeah, it's chilly here. We hit, we're in the 30s? No, tonight we're going to be in the 30s. Yeah, it's like 44, 42, 43, 44. Yeah, we're supposed to be in the 30s tonight, so time to cover the pipes, bring in the plants, all that good stuff. So, all right, let's continue on with our with this path called the Slender Man stabbing trial. So, we have Payton Leutner. She's the victim. She was stabbed 19 times by Morgan Geyser. Anissa Weier was there, or Weier. She was there. She held Payton down while Morgan did the stabbing. This happened on May 31st of 2014. All of them were 12 years old. So for those that were not with us yesterday, I'm going to tell you a story. For those that have heard this twice now, settle in and hopefully you can gain some new insight from these words. So, Morgan Geyser's story begins years before the 2014 Slender Man stabbing, rooted in profound mental illness and social isolation. From an early age, Morgan experienced severe hallucinations, later identified as early onset schizophrenia. Now, as you guys have seen over the past couple days, and then with Psychosaurus Rex talking with us last night, Morgan said that she made it all up. So we're trying to figure out how can you malinger like that? How can you lie basically for years and years and years? Because she got arrested when she was 12. She spent, I think 2018 was her first attempt to get out. And then it went to 2024 was her second attempt to get out. So she spent years in under psychiatric observation, right? So she described seeing colors bleed from walls and interacting with inhuman figures who spoke to her and appeared as companions. Some hallucinations took the form of fictional characters, most notably Severus Snape, whom she said regularly visited her bedroom at night. Morgan was aware she was perceived as odd by peers and teachers and struggled to connect socially. Now, her and Anissa they lived in the same apartment complex. So that's how they got to know each other. So in 2013, Morgan Geyser and met Anissa Weier, another socially isolated classmate with a long-standing interest in online horror culture, particularly creepypasta stories. Anissa had been reading and discussing Slender Man lore for years and understood it as fictional internet horror, even though she engaged with it intensely. When the girls became close, Anissa introduced Slender Man and related stories into their friendship. Morgan's experience with Slender Man developed differently. Long before meeting Anissa, Morgan had been experiencing hallucinations and delusions consistent with early onset schizophrenia. Remember, she said as early as, her first memories, so she, 3 years old, 4 years old, she talked about this voice in her head called Maggie, and she would see figures. So after being exposed to Slender Man lore, those pre-existing symptoms latched onto the character as a framework. Morgan came to believe Slender Man was real and claimed she had been seeing him since early childhood, interpreting shadows, trees, and figures in her peripheral vision as proof of his presence. Now, she said since early childhood. Keep that in mind, because when does Slender Man come around? If she was born in 2001. No, 2002 she was born. So let's just keep that in mind. So Anissa initially treated the stories as fictional, began to accept Morgan's accounts, and eventually came to believe she had seen Slender Man herself. So there you have that folie à deux, which is what Psychosaurus Rex was talking about, where you have kind of this shared delusion. What began as shared horror fandom evolved into a mutually reinforcing belief system that reframed their social isolation as being chosen rather than rejected. So again, here you have this shared delusion between two young individuals. As this belief deepened, the girls became convinced that in order to live with Slender Man in his imagined mansion in the Nicolet National Forest, they would need to commit a murder as proof of loyalty. They ultimately targeted their mutual friend, Payton Leutner, who went by the name of Bella. During the months leading up to the attack, Payton was increasingly bullied and isolated, though Morgan repeatedly apologized and promised the behavior would stop. In May of 2014, during a sleepover for Morgan's 12th birthday, the girls lured Payton into a wooded park under the pretense of playing hide and seek. There, Morgan stabbed her 19 times while Anissa encouraged her. Believing Payton would die, the girls left her and began walking toward what they believed was Slender Man's home. Payton survived by crawling to safety and alerting a passing cyclist. Both girls were arrested within hours and confessed. Now just imagine that. You're stabbed 14 times in the torso, in the legs, in the arms, and you're able to crawl. It's just amazing. You're just able to find enough strength that you're able to crawl away. Hey, Richard, good morning to you. Allie B, you don't remember when Slender Man became a thing? We'll talk about that in a second. Tammy, good to see you. Skybell, today is your birthday. Well, happy birthday to you, Skybell. Thank you for joining us. Green-Eyed Cat, good to see you. So Anissa was sentenced to 25 years to life in a state mental health facility with a possibility of supervised release. Now we're going to cover, this is the last day of Morgan Geyser, and then tomorrow we're going to pick up on Anissa's story. So definitely stick around for that. Morgan Geyser received a maximum sentence of 40 years to life in a psychiatric institution. So Morgan pled guilty. So she was guilty, but then it was not guilty by reason of insanity or guilty by reason of insanity. So that's why she was sentenced to a psychiatric institution, which is known as Winnebago. We heard them mention that many times in the past 2 days. And we'll hear that again today. Over the following years, Morgan petitioned multiple times for conditional release. That's what we're in the middle of right now. We've gone through two. We're in the middle of the second one, and then we'll see a third one. So we've already seen 1.5 petitions or hearings, if you will. She asserted that she had learned to manage her illness. After 3 denials, she was granted conditional release in 2025 and placed in a supervised group home in Madison, Wisconsin, with strict conditions, including a GPS monitor. We'll also cover this as well today. We're going to get to this towards the end of the day. Less than a month later, Morgan fled the group home with the help of a 43-year-old acquaintance, Chad Charlie Mecca, after claiming she feared punishment and loss of visitation. There's no evidence those fears were grounded in reality. So we're in the middle of them talking, the experts, the doctors saying she's gone as far as she can at Winnebago. She has as much access, as much privileges as she can. She's stunted in her educational growth. She needs to be around peers. She's with adults right now, basically. Hey, JMS, good to see you. So we're in the process. The hearing that we're going to pick up on, we did half of it yesterday. We're going to watch the rest of it today. All the experts several of the experts that said no, she should not be released years ago or a couple years ago now are saying, yeah, she's hit the threshold. She's ready to be released. So the escape was poorly planned and quickly unraveled. After leaving the group home, Morgan met Charlie at a church parking lot where the two boarded a bus to Chicago. From there, they transferred to another bus and began traveling south, telling authorities they were attempting to reach Nashville, though no clear reason for the destination was given. Despite having nearly a 9-hour head start before local police were notified, the pair ran out of money after the second leg of their trip. Now, also keep in mind, she went missing around 9, and then, hold on, I have those notes, because I looked this up, because this was very important to me. So, November 22nd, 2025, she left the home around 8 p.m., and I think they kind of discovered her, or no, they alerted authorities, I think around midnight maybe, but she was arrested the next day, November 23rd at 9:30 p.m., so over 12 hours. And then Payton wasn't notified. Her family wasn't notified, I think, until 6 or 7. So it was about 12 hours, maybe 8 o'clock. It was about 12 hours before they alerted Payton and her family. And that they're going through a whole thing now. I think three staff members were on leave, administrative leave, because of what happened. So they're looking into why did it take so long to alert the victim of a violent crime. Why did it take 12 hours to alert that person? Was it because it was overnight? Possibly, but we're gonna try and figure that out, or they're trying to figure that out. Unable to continue, Morgan and Charlie spent the night sleeping outside of Thornton's truck stop in Dwight, Illinois, which is a well-lit and highly visible location that quickly drew attention. Right, so they were arrested basically for loitering, and then Morgan didn't give her name, and we'll see that. We have body cam, and we'll show that. When officers made contact, Morgan attempted to deflect assistance, declined offers of a warm place to stay despite freezing temperatures, and provided inconsistent information about her identity, age, and lack of identification. These inconsistencies raised red flags for officers who began to suspect that the visibly younger woman may be a runaway or endangered person traveling with an older adult. Now remember, Lori, we don't know yet. We're going to find out. We don't know that yet, so we'll find that out. Did she get more time added to her escape? We're going to watch that hearing. That hearing was December 23rd, so we're going to watch that. That'll be one of the last things we watch today. And then don't forget that Morgan had a relationship while she was at Winnebago with a 63-year-old gentleman via phone and letter writing. So Morgan, even though the experts want her to be with her peers, it seems like she is attracted to older men. That's just the way it is, right? Hey, JP Rabbit, good morning. I was doing the rewatch, but we'll jump into the live and do the rewatch later. Very cool. Little Lulu, good to see you. Would the person she was with in trouble too for helping escape or no? Yes. He has he, she, they. Charlie is trans, so they have a hearing January 15th or 16th. So we'll get into that, Allie. We're gonna cover that. We have news on Charlie, and we'll get into that later. During questioning, Morgan struggled to provide basic personal details and gave conflicting answers, ultimately leading officers to identify her as a missing individual on conditional release. Both women were taken into custody without incident. Charlie Mecca was later released with the citation and a court date set for January 15th, 2026. There we go. Wisconsin authorities have since moved to revoke Morgan Geyser's conditional release, a decision that could return her to institutional care and expose her to additional charges related to the escape. Now, we were talking about this yesterday with Rex and also throughout the chat the last couple of days. And Northwest is the one that keeps reminding me. Dreamhorse, good morning to you. Snow Caddish, good to see you. That she's already been adjudicated not guilty. So she cannot go to jail, right? She can't go to prison. So she's either going back to this institution, to Winnebago, or she's going back to in Winnebago, I think. And I think Rex was saying she basically goes back to square one. They're going to send her back to square one, and they're going to reevaluate her and all this stuff, because clearly she's not following rules. All right, now let's get into the definitions. Creepypasta is a genre of internet horror made up of short fictional stories designed to unsettle or scare the reader. The term comes from copypasta, slang for text that is copied and shared repeatedly online. Creepypasta stories are typically circulated on forums, blogs, Reddit, and YouTube and often feature unsettling themes such as supernatural entities, psychological horror, urban legends, or corrupted versions of familiar characters. We all grew up with urban horror or urban legends, right? Everybody knows the urban legends. Many creepypasta stories are written in a realistic tone, such as journal entries, eyewitness accounts, or found footage narratives. And I say this every time, think Blair Witch. For those of you that have seen Blair Witch, that's like a perfect example of found footage. And also those paranormal, there's like 4 of them or something. Now, these narratives can blur the line between fiction and reality, especially for younger or vulnerable audiences. Well-known creepypasta characters include Slender Man, Jeff the Killer, and other fictional figures that originated online and evolved through collective storytelling. Over time, creepypasta became a major part of internet horror culture, inspiring fan art, videos, games, and adaptations, while remaining entirely fictional in origin. So, creepypasta evolved from chain emails in the 1990s and early 2000s. Now, Morgan was born in 2002, I believe. Let me just get her exact. She was born, May 16th of 2002. Payton was born May 30th, so that was her 12th birthday of 2002. Anissa was born November 10th of 2001. So Anissa's a few months older than Payton and Morgan. Let's see. So 4chan. This is widely considered the birthplace of modern creepypasta. Around 2007, users on a paranormal board would share short, scary stories designed to feel like found accounts or leaked secrets. Now, remember, Morgan said that she found Slender Man as a young adult. So if she was born in 2002, something awful. This forum birthed one of the most famous icons, Slender Man, during a 2009 Photoshop contest to create paranormal images. So she was 7 years old when Slender Man was birthed. So 7, 8, she probably came onto it maybe when she was 7, 8-ish. Reddit, created in 2010, this community popularized the everything is true here rule, where authors write in the first person and readers act as if the story is real. So Slender Man specifically is a fictional supernatural figure that originated on the internet in 2009, as we just noted. He was created as part of a Photoshop contest on the Something Awful forums, where users were asked to invent paranormal images and backstories. Slender Man is typically depicted as an unnaturally tall, thin humanoid wearing a black suit with a featureless white face and elongated limbs. In online stories, Slender Man is portrayed as a stalking presence who appears in forests or near children, often lurking at the edge of perception, rather than confronting victims directly. Common elements of the mythology include mind control, inducing paranoia or hallucinations, abducting children, and exerting influence through dreams or intrusive thoughts. The character evolved through collaborative storytelling, known as creepypasta, and has no basis in folklore, mythology, or reality. Despite its entirely fictional origins, Slender Man became a prominent figure in internet horror culture, inspiring stories, videos, games, and fan communities. The character is not real and was never intended to be perceived as real, though its ambiguous, documentary-style presentation in early stories contributed to confusion among some readers. So now let's get into some definitions. Schizophrenia. It's a chronic and serious mental health disorder that affects how a person thinks, perceives reality, feels emotions, and behaves. It is characterized by disruptions in perception, thought processes, and the ability to distinguish what is real from what is not. Common symptoms fall into several categories. You have psychotic symptoms, which are hallucinations, such as hearing voices or seeing things that aren't there, and delusions, strongly held false beliefs that persist despite evidence to the contrary. Then you have disorganized thinking and speech, difficulty organizing thoughts, speaking coherently, or following conversations. You have negative symptoms, which is reduced emotional expression, social withdrawal, lack of motivation, and diminished ability to experience pleasure. Then you have cognitive symptoms, such as problems with attention, memory, and decision-making. And then finally, schizophrenia usually develops in late adolescence or early adulthood, though early onset schizophrenia can occur in children. The exact cause is not known, but it is believed to involve a combination of genetic factors, brain chemistry, differences in environmental influences. So we heard yesterday that Morgan's father has had multiple instances of schizophrenia of his own, and he passed away April of 2023. Morgan also says environmental influences. Morgan also has said that her father abused her as a child multiple times, watched her take showers, that kind of stuff. So she has the genetic factor, she has the environmental influences. Schizophrenia is a lifelong condition, but with proper treatment, typically including antipsychotic medication, therapy, and structured support, many individuals are able to manage symptoms, maintain stability, and lead functional lives. Importantly, schizophrenia does not inherently make a person violent, and most people with the disorder are far more likely to be harmed than to harm others. So we also heard over testimony the last couple of days, Morgan was weaned off of her psych meds from October to December of 2022. So she's still on anti-anxiety and social anxiety disorder, she says, and she's depression and anxiety. Those are the two disorders that she still maintains that she has. But she has not been on psych meds for 3 years now, and literally 3 years. And as we were talking to Rex yesterday, schizophrenia just doesn't go away. You have it for life, and if anything, it gets worse if you don't treat it. So that's where we stand with all of that. All right, you guys, what are you guys talking about before we start? Let's see. Sweet Vampy, you got scared of Halloween costumes because of my aunt wearing Tales of the Crypt. Nice. Allie B, imagine having those visions at 12. Yikes, I mean, my age would be tough, but at that age, you are moldable. Linda, it's very sad to be born with such a brain disorder. Let's see. Yeah, Lori, how old? I see people are, they were 12. Yeah, they were 12 when this happened. So I see people have answered that. Allie B, I wonder why they would take her off. They felt that she was I guess they felt she was improving. That she was improving and she didn't need them anymore. I don't know. That's a great question. That's a question that we were talking about with Rex yesterday and during Cross. Like, why did you guys take her off the medication? Sherry, she should not have been taking off her psych meds. Yeah. All right, you guys, let's get started. So we're going to pick up on the second half of yesterday's hearing. Let me just let me get us over here. And we broke at lunchtime. So this hearing is from sorry, my mouse is acting up. All right, this hearing is a continuation of January 9th, 2025. So let's see. Hearing from January 9th, 2025. And I shall pin this and pull it up here. Okay. All right, so let's continue on. Just pop this up here.
All rise. Okay, thank you. Please be seated. We'll call a record again on State versus Geyser, same case number and same appearances. We last ended before lunch with the Attorney Cotton being prepared to call an additional witness. And I'm assuming that was Ms. Portman?
Yes.
And so she's prepared to testify at this time?
Yes.
All right, thank you. Ms. Portman, has she been called through?
I'm going in there now. She's fully connected.
Okay, Miss Lisa Portman, are you with us? Hello, Ms. Portman, are you there? You're muted.
Okay, is that better?
That is terrific. Much better. I can
Okay.
hear you and I can see you. So thank you. Now you're being called as a witness today, so I'm going to ask you to stand, raise your right hand, and our clerk will swear you in. Raise your right hand, the clerk will swear you in.
Do you swear that the testimony you're about to give in this matter before the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, thank you. You may be seated. And then if you'd, once you're seated and comfortable, state your full name and spell your last name.
Lisa Portman, Portmann.
All right, thank you, Ms. Portman. Then I'll turn to Attorney Cotton.
Thank you. Good afternoon, Ms. Portman. Thank you for being here.
Hello.
What is your job at, where do you work?
Winnebago Mental Health.
What do you do at Winnebago?
I am a treatment social worker.
What is a treatment social worker?
I am a master's level clinical social worker who provides treatment to patients who are civil and forensic patients at the facility,
So you
both individually and in group sessions.
Okay, so you have a number of patients you work with.
I do.
Are you familiar with Morgan Geyser?
I am.
How are you familiar with her?
She is one of the patients assigned to me for individual therapy.
And so you work with her. Is it fair to say that you're her therapist?
I am.
How long have you been providing therapy with Miss Geyser?
I started therapy with her in, I believe, March of 2024.
Does it continue to this day?
It does.
And are you a one-on-one counselor with her, or is this a group setting, or is it both?
I do both.
So Morgan, is this a requirement of hers that as part of her treatment plan at Winnebago, she's required to participate in therapy?
She has a treatment schedule for group therapy, group treatments. That is typically a requirement. Individual therapy is assigned as needed, as desired.
Okay, so as the patient wants to do it, he or she can do it.
Yes.
So since you've been working with Morgan, is she an active participant in group?
Yes.
What is she like?
Morgan is very outgoing in group. She's engaged. She's supportive. She's inquisitive.
How many people are in a group treatment setting? Is it just 2 people, 5, 10, or does it really vary depending on the day?
I would say it varies. At least 4, could be up to 10 or 11.
And are people encouraged to discuss their own personal issues in group? Is that the idea behind it?
Yeah, each group has a different theme, a different direction, a different directive for the group. So different skills that are worked on, and each patient, I would say, is encouraged to apply the information that they're getting or share personally or apply it to themselves to their comfort level.
How long have you been employed at Winnebago?
I've worked at Winnebago since June of 2011.
Okay, so about 13 and a half years there. Okay, and in that whole time you've been employed there, have you been a therapist or a treatment social worker? Has that been your role there?
I've done treatment in my role. The title of treatment social worker started in October of 23. However, treatment has been part of the role. I'd say primarily before the treatment social worker title, I would go with a case management title.
Okay. When you see Morgan in group, does she attend on time?
Yes.
Does she get along with her peers?
Yes.
Would you say that she supports her peers, meaning does she provide constructive feedback or thoughts?
Yes.
What about completing her assignments? Does Morgan get assignments and complete them?
Yes, she does.
What about tense moments that arise in group? Are there ever tense moments in group therapy?
Yes, there are, and she navigates them safely, appropriately, successfully. There's never been any concerns with her.
Do you have any concerns more broadly about Morgan's ability to navigate stressful situations as you've interacted with her over the last 10, 11 months?
No, I would say she's highly capable of navigating stressful moments that come up quite frequently in the Winnebago environment. So she navigates them, she processes them in individual therapy, and she can compartmentalize what is happening, bring that to therapy, process it, and adjust as needed if she feels the need to do so.
Thank you. And you provide individual therapy to Morgan as well, so one-on-one?
I do.
Do you feel that Morgan is open with you when you have your one-on-one sessions, or is she more of a hold back, closed down kind of person?
No, she definitely is very, very open. She uses a therapy session really well as a place to open up and process and cope and get information. She really takes full advantage of the individual session to do the work that she needs to, coming to therapy prepared to work, and does her work there.
Do you feel that Morgan is, when you contrast her against other people who are at a mental health facility, do you feel that she's more of an independent person or the opposite of that?
She independently did quite a bit of work and would bring the effects of that to therapy. So I would say she independently had the insight to know what she needed to work on, so yes, I would say she's pretty independent and capable.
Have you seen any in the time that you've worked with Morgan, specifically since March of 2024, have you seen any signs of violence by Morgan?
No.
Has she expressed any violent thoughts or ideology to you?
No.
And just so the record is clear, Ms. Geyser has given you permission to speak about her medical treatment that you're providing, okay?
Yes.
So, and I know these individual sessions are private sessions. It's almost akin to a doctor-patient privilege setting, isn't it?
Yes.
And in those private sessions, do you encourage Morgan to open up with you in those private sessions?
Yes.
About any thoughts or fears or concerns that she might have that it's within her head?
Yes.
Has Morgan expressed anything that's raised alarms at all with you during the time that you've treated her, about being violent towards others or self-harming herself?
No.
What about damage to property? Do you, obviously, well, let me take a step back. When you're working with someone in a one-on-one setting, you're listening to what they tell you, but you're also looking at the visual cues that you observe, aren't you?
Yes.
whether a person is smiling or crying or having a panic attack, you're trained to look for those things, aren't you?
Yes.
And when you work with Morgan in treatment, does it seem that she has do the two of you ever discuss her plans for the future?
Yes, not in specific detail, but just ideology, like what might it look like, or what might be problems she might face, or what resources, where would she go if she ran into struggles, just kind of general information, or extrapolating the experiences at Winnebago and how might we run into this in the future and what might we do. So that type of planning, not specific detailed planning.
Okay. Does Winnebago have conditional release teams?
Yes.
What is a conditional release team?
Well, I would say it's the treatment team in general that she already works with. That's who would be on her conditional release team. That team would connect with the outside team, the team in the state of Wisconsin, who are there to work together, to collaborate, to put together her plan.
So the people who know her best on the inside, the treatment team, will work with the outside resources for conditional release purposes. That's the idea?
Correct, yes.
And you, as somebody who's been employed at Winnebago for going on 14 years, have you been involved in conditional release planning before?
I have.
For clients or patients, if you will?
Yes.
And that's common, isn't it? That you because you work with a person, that you would be assigned to their team to help facilitate community integration.
Correct, yes.
There's been some talk in this hearing, ma'am, about treatment homes or group homes. There are group homes in the state of Wisconsin. Is that fair to say?
Yes.
And is it fair to say that you and Ms. Geyser have discussed, as part of the advanced planning, what that might look like, her living in a group home and her relying on her therapists as future resources?
Yes.
Do you find that Morgan exhibits resistance to the idea of moving into a group home, or does she seem to understand that that's a logical next step?
I believe she understands it's a logical next step.
And hypothetically, if Judge Boren were to approve conditional release, what would you and the conditional release team do once you receive once you receive the green light, so to speak? What would be the next step for you guys?
The next step would be a meeting would be scheduled with her treatment team at Winnebago and the outpatient, the resource, I believe the agency is called WCS. We would schedule a meeting to sit down and discuss what are Morgan's needs, what are Morgan's recommendations, what does she need, what is our opinion of what she needs to be successful in the community. And that would start the conversation, and they would get together and start working on a plan for her.
And when you've been involved in this in other cases, does Winnebago identify the specific group home before conditional release is approved, or do you wait for conditional release to be approved, then you seek out the group home?
We don't actually seek out the group home, the WCS would, and it's not until conditional release is granted that we're able to start that process of planning.
Okay, so once approval is given for conditional release, then you coordinate with WCS and the other resources in the state to make sure there's a suitable facility.
Yes.
And does that get presented to the judge, as you understand it?
Yes.
Okay, so then the judge decides whether or not that it seems suitable in his opinion.
Correct.
Since you've worked with Morgan, strike that 1 minute, please. Just a couple more questions, Ms. Portman. You're aware of the fact that Ms. Geyser sought conditional release 6 to 8 months ago, are you not?
Yes.
And you were her therapist at that time, right?
Yes.
How did Ms. Geyser process the rejection, if you will, or the denial of her conditional release?
She accepted this is what she has to do. She has to continue to move on. And she brought it to therapy, and she held her head up, and she continued to move forward and say, I just have to keep doing the next right thing. Really, she handled it very well.
Those are all my questions. Thank you, Ms. Portman.
All right, thank you. Cross-examination.
Ms. Portman, you'd agree that Morgan's very intelligent, correct?
Yes.
And you did not work with her prior to March of 2024?
I may have had her in group sessions. I did not work with her in individual therapy before March of 2024.
That's all. Thank you.
All right, thank you. Any further direct?
No, Your Honor. She's not under subpoena.
All right, then, Ms. Portman, thanks for being here to testify. That'll complete your testimony then, so have a good day.
Thank you.
All right, then we'll end the Zoom contact. Then, Attorney Cotton, further witnesses?
No, Your Honor.
Does Ms. Geyser's arrest then?
Yes.
Okay, does the state have any rebuttal evidence or testimony?
No, Judge, no rebuttal.
All right, then all evidence is closed. Everything is in. The exhibits have been received. The exhibits are the CVs and the reports of each of the three doctors. The one item that's been referred to is the November 7, 2024 letter from Ms. Parnell. It's not an exhibit, but it's been referred to, so I have it and I've read it. So it's just clear that what the status of that is. So that means we're at the stage to proceed to argument. How do the parties wish to proceed today? I'm prepared to hear argument this afternoon.
Okay.
So do you need a little bit of time to?
I'm prepared to go forward, Judge.
All right, Attorney Cotton?
Yes, we are too.
All right, well then, let's go forward. And I'll hear from attorneys and appellants. Keeping in mind the state has the burden of proof.
Judge, I guess I'm fairly easily prepared to go forward because...
Could you use your microphone, please?
Sure. Is that better?
It should be, we'll see.
I'm prepared to go forward because preparing my argument was really pretty easy. I have in my hand, Judge, a transcript of your decision the last time we were here, and I have the Randall case. And that's really my argument, Judge. I think in looking at the court's analysis of this back in April of 2024, there's not really anything different here, in my opinion, in terms of how the analysis comes out. And I mentioned the Randall case, obviously, because what is different now, we do have three doctors all saying that you should grant conditional release here, but as the court pointed out last time, and as Randall indicates, the court is not bound by the conclusion that the experts have reached, even if those opinions are uncontroverted. So certainly the court has to make up its own mind as to whether or not the evidence at this point indicates a substantial risk of bodily harm to herself or to others. And last time, Judge, you started your analysis looking at the factors as they're set out in 971.17 sub 4 sub D. And after it indicates the court shall grant the petition unless it finds by clear and convincing evidence the person would pose a significant risk of bodily harm to himself or herself, the statute indicates the court may consider without limitation because of enumeration. Number one, the nature and circumstances of the crime. That's where you started your analysis last time, Judge, and It's the state's position that this offense alone is enough to demonstrate by clear and convincing evidence that there's a substantial risk here to others and to herself. The court pointed out that this was a brutal attempted murder. The effort to stab somebody 19 times. But then she's not dead, but then they leave. Of course, with the idea or thinking that she'll bleed to death. You know, when I think about this, Judge, I can't help but thinking most people in society are not capable of committing the offense that Morgan Geyser committed. Most people are not capable of taking a knife and plunging it into someone else. One time, Morgan, as we know, did it 19 times. And then left this victim to bleed to death and walked away. So, again, the state's position is the offense alone is enough, Judge, to find that there is a significant risk. I know Dr. Collins indicated that certainly the underlying offense is a factor. I think it has to be a huge factor when you're tasked to consider whether or not she represents a risk of substantial bodily injury. The court then went on to analyze the situation by looking at her mental history and present mental condition. And I think that also is still, Judge, very much up in the air. And I'm not saying it's necessarily up in the air because she's experiencing psychotic symptoms or she's delusional. Those things aren't present. But as the court indicated last time in your decision, Judge, we still don't really know why Morgan Geyser committed this offense. And we've had different reasons provided over the years. The court pointed out the diagnosis initially was, or the rationale was Slender Man. And the diagnosis was schizophrenia. Then we have Morgan indicating at some point that I believe it was shortly before our last hearing in April of 24, sometime in 2023, that she faked all of these hallucinations. Really, as you indicated, really the groundwork for the schizophrenia diagnosis, and she made it up. Then the explanation, I guess, shifts from Slender Man to trauma related from sexual abuse by her father. And the sexual abuse is used, I guess, to go two different routes. One, the trauma from that was such that she lived in this fantasy world, or the trauma was such that she felt her only way out was to commit an offense as horrendous as this and be removed from the situation. We're not really sure which of those two reasons is at play here, but that was the explanation offered, and now apparently she's backed off the claim that she made this all up. And now, again, I think we're in a position where we really don't understand it. In looking at the doctor's reports regarding this, I guess I would first go to page 4 of Dr. Robbins' report, where he tries to address this and indicates in the middle of the first paragraph on that page, I believe the only reasonable explanation is that either, he uses the word either, so The only reasonable explanation is one of two. He offers two. Again, we don't know which it is, but he offers two, indicating that she did experience psychotic symptoms, or much more likely, her fantasy was so powerful, she came to believe it was real. And for multiple reasons, I assume he's talking about afterwards, particularly not wanting to see herself as evil following the events. She had a hard time letting go of it. But it really doesn't offer an explanation about her fantasy being so powerful she came to believe it. I guess that's saying that she really felt that Slender Man was going to get her or her family, and she had to offer up this sacrifice to him. But he also said at the same time it could be that she was experiencing psychotic symptoms.
Now, what page of Dr. Robbins' report are you on?
That is page 4 of Dr. Robbins'
All right.
report, the middle of the paragraph on top.
I see
Not
it.
clear
Very
or
good.
sure which one of those it is. I'm sorry?
Yeah, I see it. I see where you're reading from.
Okay. In looking at page 7 of Dr. Lundbaum's report, and this is the last paragraph at the bottom of page 7, in contrast to her previous self-report, Ms. Geyser denied she ever feigned symptoms of psychosis. So now she's saying she didn't make up these symptoms. But Ms. Geyser says, rather, until my late teens, I thought I could make imaginary friends real. They existed in my mind, but they weren't in front of me. When clarifying her previous statement that she feigned psychiatric illness, she acknowledged that it has been difficult to understand her illness and circumstances due to her age when the index offense occurred, and significant changes in her symptoms/experiences over time. That still doesn't give us any explanation, and it goes on to say, while denying that she intentionally fabricated mental health impairments, again, in contrast to what she was saying in 2023, Morgan said, it was easier to say I was pretending. Part of the problem is how young I was. I didn't really understand the severity of what happened until I was about 14. She made further comments suggesting her difficulty discerning fantasy from reality during her adolescence. In combination with periods of dissociation, she acknowledged breaks in her reality attachment. Again, that doesn't offer, and I haven't really seen anything in the doctor's reports that offer an explanation of what she understands now is the reason for her being involved in this offense. In Dr. Collins's report, I guess, on page 31, in the 6th paragraph that begins, in a meeting with social services staff on July 22nd, 2024, in that paragraph, it's stated, he, now referring to Morgan, given the gender situation, he can recall the fantasy life he used, both prior to and since hospitalization, as a way to cope and manage with reality, but has since come to believe that this was not schizophrenia, but rather a coping strategy used to keep him safe from the external threats in the environment. Ms. Geyser acknowledged the use of the fantasy world to conceptualize his experiences following his psychiatric hospitalization. The social worker wrote, he consistently has been using the therapy time appropriately to process and cope with the stressors and questions and pain and grief. He is doing a great job. But again, there's no explanation offered or no understanding or indication that Morgan understands why this offense happened. On page 37 of Dr. Collins's report, in the second paragraph on that page, Dr. Collins indicates, while it is this examiner's opinion to a reasonable degree of professional certainty that facts weigh in favor of Ms. Geyser's petition and placement on conditional release at this juncture, I also recognize considerations which may give pause. The issue of Ms. Geyser's diagnostic enigma is one such consideration. Ms. Geyser now reports that she has never experienced auditory hallucinations or psychotic symptoms otherwise. It certainly seems, Judge, that prior to our hearing in April of 2024, that perhaps Ms. Geyser felt this court may be more inclined to release her if she claimed she had never had these psychotic symptoms, if she indicated she made them all up in an attempt to convince the court that she was never schizophrenic and therefore she's no longer dangerous. Now, this time, and she admitted that she went through with the hearing last time, even though 2 doctors said no. She went through with the hearing because she wanted to know what the court's position was and why the court might think conditional release was not appropriate. And after getting your decision in April of 2024, we now kind of have her going back somewhat and saying, well, yeah, maybe I did have imaginary friends, and I don't see that she ever comes back and says, I lied about making it all up. But she seems to no longer say that she made it all up. She's acknowledging it somewhat. But again, we don't have any clear answers whatsoever, Judge, as to what went on, why she committed this offense. We have, I believe it was Dr. Lundbaum who testified, and maybe it's in all 3 doctors seem to indicate that these doctors all believe that the schizophrenic diagnosis was correct. But it certainly is unusual that someone who is schizophrenic is taken off of antipsychotic medication and any such psychotic symptoms disappear and have not come back. So we really don't have explanations for any of that. It's all still up in the air. And in my opinion, is additional evidence that she represents a danger to herself and others. And I know that was a large part of the court's concern back in April of 2024. The court at various points touched on her credibility, and at page 125 of the transcript, Judge, you indicated the credibility of the reporter is critical to what assessments are made, how people, how professionals, how mental health professionals make decisions. They're critical to how legal people make decisions. The credibility of the reporter is paramount. And I still think there are large questions of credibility here. The other area the court touches on in its analysis relates to the other factors that are listed in 971.17 sub 4 sub D, considerations revolving around where the person will live, how the person will support him or herself, what arrangements are available to ensure access to and the person will take necessary medications, and arrangements possible for treatment beyond medication. We've heard a lot about, well, we think a halfway house or a group home is the next logical step. And it was testified to by Ms. Parnell, which I found very interesting, when she said that the Department of Health Services and the Department of Corrections, in my opinion, they have this backwards because it's not consistent with the law. The law lists these things as things the court needs to consider in making a conditional release decision. And Ms. Parnell testified that, well, they don't go through all the paperwork to look at various group homes or placements or provide any of that information at this stage because they don't want to put that work in and have the court deny the petition for conditional release. Well, those are things that the law says you're supposed to require or consider. You can't consider those when they're not willing to put in the work to show the court what a plan might look like, where she might live, where she might work, who she might be with, how they're going to provide treatment. Those are all unknown, much as the court pointed out they were unknowns back in April of 2024. I know, Judge, you touched on the Randall decision last time, and it indicates that making this decision requires a careful balancing of society's interest in protection from harmful conduct against the equity's interest in personal liberty and autonomy. We had questions, I think, to all of the doctors. Well, is staying at Winnebago actually harmful to Morgan? And we heard that, in their opinion, maybe it is, but that's not really a factor that the court has to look at. It's a balancing of society's interest and the community's interest in protection balanced against any interest of the equity in liberty or autonomy. You indicated last time, Judge, that when indicating you were satisfied that Ms. Geyser posed a significant risk, that, and this is on page 126 of the transcript, now she works hard, she continues to do what she's supposed to do, but that doesn't change this risk. The community is concerned to a great extent with what happens to Ms. Geyser, but the primary concern and the balancing in the Randall case, they talk about the balancing that goes on in the court's decision. And you cite to the same section that it's a protection of harmful conduct from society against her interest in personal liberty and autonomy. I think for all of the reasons I've pointed out, Judge, the seriousness, the brutality of this offense, the absence of really understanding, and not only Morgan not understanding why the offense was committed, but everyone else not really being able to gain an understanding as to why this offense was committed. Along with the other factors that are just absent in this case, that you should find there's clear and convincing evidence of substantial risk. I know you mentioned right before we took the lunch break, Judge, that there was some statement in the Freeman. We have had conversations with the victim's family, They have indicated they don't wish to address the court, but they wish for us to indicate to you that they are opposed to Morgan's release. That's all I have.
All right, thank you. Then I'll turn to Attorney Cott.
The burden of proof is on the state to show by clear and convincing evidence that the commitment should continue because Morgan is presently a danger to herself or others. It's their burden. Clear and convincing standard means that the evidence is highly and substantially more likely true than untrue when the court looks at the evidence that the state introduced today at today's hearing. The state called as its witness Brooke Lundbaum. That was their only witness to meet their burden of proof. The only evidence they put in was Dr. Lundbaum. And Dr. Lundbaum has a long history with Ms. Geyser. As the court knows, Dr. Lundbaum's history with Ms. Geyser goes all the way back to when she did a competency evaluation very early on in the case before Ms. Geyser was adjudicated NGI. And Dr. Lundbaum, with that very long history, has conducted a number of evaluations and at least 2 conditional release reports, if not more. I think more than that, actually. And last time Dr. Lundbaum testified, the state called her last time as well to meet their burden of proof. She indicated that she did not support release. So what does the state do now in January of 2025? They call Dr. Lundbaum again. And now their witness takes the stand and testifies under oath that based on her deep analysis in this case, understanding the statutory criteria that needs to be considered, she cites it on page 1 of her opinion, the state's own witness testifies in support of conditional release. And I think almost everything Mr. Sapakowicz just said is a red herring. To get this court to be scared somehow into doing what I think is the right thing to do and what the doctors believe is the right thing to do. We can never change the crime. It was a horrible event that took place, a horrible act that Ms. Geyser committed, that she recognizes was horrible. She's talked about it at such length with her therapists and counselors. It's been the theme of constant discussion, and we absolutely have no doubt in this history of this case that there were and was psychotic conditions that she exhibited that explains the behavior. No doubt. Now, and that's because there's a confluence of opinions, a unanimity of opinions among all the professionals who evaluated her in close proximity to this offense who agree on that. They agree on it because including Dr. Lundbaum and Collins and Robbins, because they've been a part of Ms. Geyser's life for over 10 years. And all of them agree, and the state's casting a broad brush here, but I think it's far more nuanced than the way they're characterizing it, frankly. We are dealing with childhood schizophrenia, which is, as every doctor has said, both in their reports and testified to at various times, it's a very difficult condition to precisely diagnose. And they did diagnose it, and they identified it. And there's no question that Ms. Geyser, as a result of those delusions and that trauma, committed this horrible crime. No doubt about it. I don't think the state stipulated to that when they agreed to the NGI finding. And it explains the behavior. The question becomes for this court today, when they attempt to meet their burden of proof, the question becomes whether they've shown by clear and convincing evidence that today, as you look at Ms. Geyser sitting here in court as an individual, whether she still presents that same risk today. She doesn't. She doesn't. Their own witness that they called explained why she doesn't. And what Dr. Lundbaum indicates is that the evidence does not continue to support that conclusion that she poses a risk of bodily harm to herself or others if conditionally released. She offers that opinion to a reasonable degree of professional certainty. Dr. Lundbaum notes that Morgan is 22. She comes to the court still committed to the Winnebago Mental Health Institute, and she describes how since 2021 There has been no attempt whatsoever for Ms. Geyser to injure herself. It was the last one and only time that there was any concern regarding her suicide attempt was October of 2021. And Dr. Lumbaum explains this isn't a situation where this is a wishy-washy doctor or somebody who's not confident or hasn't put a lot of thought or effort into their analysis. This is a doctor who explains exactly why she didn't support it in March, but supports it now. She explains that one concern she had back in March was that there was episodic display of heightened emotional distress in the absence of clear provocation or context. And there were concerns about trauma and intrusive memories. What she noted is that since the last petition, Ms. Geyser has been on the minimum security unit at the facility. She's been consistently placed in the pre-integration phase of treatment since June of 2022, which is the highest level of care available, the highest level of permission available. She's earned all the privileges available to Winnebago mental health patients. She's acquired full escorted liberty privileges in February of 2024. She's participated in staff-supervised off-grounds activities since March of 2023. And all of the available information, she notes, Dr. Lumbaum notes, reflects that Ms. Geyser has demonstrated, quote, consistent rule compliance. Now contrast that just for a minute against Randall. I don't know the case. It was a big case in Waukesha County, as I understand it.
Well, it's still a big case, actually, across the state. But since we're citing it again, it's at 211 WSAP 102. That's the citation to it from 2011. But go ahead, just to put that in context.
It is a big case.
Yeah.
And what I meant by that remark was that it was a Waukesha County case specifically, as I understand it, historically. That was a very big case for the community, and it remains a published decision, as you know. But contrast what I just read in Ms. Geyser's behavior against Mr. Randall, who, while he was at Winnebago, the court noted, I think it was Judge Dreyfus who presided over the conditional release hearing, noted that while institutionalized, Randall was secretive, lied to staff, breaking rules when it situated him, and his behavior while committed mirrored the behavior that he exhibited in the community. And what Judge Dreyfus noted and the Court of Appeals emphasized in the published opinion that Your Honor cited was that Randall's secretive behavior throughout his years of commitment, throughout all those years that he was at Winnebago, included hiding items above ceiling tiles at a bicycle shop at Winnebago, denying that the items were his. The court noted that that was very similar behavior to what he exhibited during his original crime spree, because as I understand it, he engaged in a crime spree where he hid a CPR dummy above the ceiling tiles of a high school during a burglary. And when Randall was confronted about these things, he would become agitated and angry with the staff. The trial court made other findings about rule violations and inappropriate behavior throughout his time at Winnebago, failing to report to the treatment professionals that he had inherited money in a trailer, purchasing real estate for $42,000 with his inheritance without revealing that, hiding illicit items of property he purchased, receiving mail without the approval of his supervisors, maintaining a secret bank account, only revealing ownership interest in a property 14 months after he purchased it because he believed that he had been cheated out of $70,000, lying about turning over his keys to his property, lying to his supervisors about receiving mail about the property, violating conditions of his off-ground work privileges by going to his property in a restaurant without permission, and he was aware of all these rules. And it was based on those findings that were in the record that the state put in, that the court, that Judge Dreyfus could conclude reasonably that Mr. Randall was being devious, secretive, and essentially deciding he'll do the things he wishes to do regardless of the restrictions or limitations of Winnebago. And Randall himself didn't dispute the fact that he violated the rules on innumerable examples. He just argued they didn't matter. They're not significant enough because they don't involve violence. But what the court noted was you just keep breaking the rules, even when you're in the institution. So I think when you're examining whether they've met their burden of proof and they've called nobody from Winnebago to testify at all that Ms. Geyser has been anything other than an exemplary model patient, and our witnesses substantiate that fact and we don't have a burden of proof, it's far different, far different than the Randall case. Now, there is, of course, the principle in the Randall case that Your Honor cited last time, that if 3 doctors or the multitude of doctors support a particular conclusion, this court is vested with ultimate power and decision-making authority. Nobody's harboring any delusion about that fact, Randall's decision or not. But the question legally is whether they met their burden of proof by clear and convincing evidence. And what you have in this record here is an incredibly thoughtful and thorough opinion by Dr. Lundbaum, where she has examined that history at Winnebago with Ms. Geyser, which has been perfect. We know, and you have in personal knowledge, Your Honor, of Ms. Weier's case, the co-defendant, you have personal knowledge in this situation of what happens in conditional release hearings, not just from that one, but from other cases you've presided over, and you know how the process works. Once the court approves conditional release, the facility will have 60 days to put together the plan with the treatment professionals in the community, WCS and DHS. And they'll put together a plan and they will identify the group home for Ms. Geyser to live in. That's what they do for people who aren't going to go home to their parents. Put them in a group home. And you don't have to approve that. You can reject it. You can look at the plan they put together and say, I don't think a group home that they've identified is suitable, and I don't think these conditions make sense, and you can modify that or reject that as you see fit. But to trigger that process to occur requires you to grant conditional release. That's why this is so important. It's important because Ms. Geyser continues to demonstrate throughout her time at Winnebago consistent adherence to the rules of the facility. And as Dr. Lundbaum is noting, and as every doctor notes, and every person at Winnebago noted, that Ms. Geyser will be placed in a group home and supportive environment. She will be closely supervised by staff as she reintegrates into the community. And as you know from Ms. Weier's case, there will be GPS monitoring. She'll be on a bracelet that will undoubtedly be ordered, and it'll be ordered so that Ms. Geyser's whereabouts are known 24/7. So that was the state's expert. The one witness they called to meet their burden of proof testified contrary to the arguments that they're now making, which is that Ms. Geyser should be essentially indefinitely detained in the facility, because it seems to me that none of these arguments will change. That Ms. Geyser herself has truly maximized the services available to her at Winnebago, and she's shown through her performance that she's not a risk. But it's not just Dr. Lundbaum. It's Dr. Robbins, who's the former director of Mendota, and I don't know who the experts were in the Randall case, but you do have to look at you do consider as part of this analysis who the experts are that are called to testify. There's different levels of doctors and professionals and caregivers in society. Some doctors are new, some are inexperienced, some don't do a thorough job, and then there's others that are immensely qualified. There's a wide range, just like there are of lawyers and other professionals. So last time we were here, 2 of the 3 doctors didn't support release, although Dr. Collins was close. She wanted to see additional positive progress by Ms. Geyser. Dr. Robbins, who was the second witness to testify, is the former director of the Mendota Mental Health Facility. And he evaluated Ms. Geyser, he studied the history, and he also supports release. He concludes that she's not a substantial risk to herself and others based on his study of the history. I think probably I hate to rank witnesses, but I think in terms of the length of the report, Dr. Collins' report was certainly the longest. You have personal familiarity with Dr. Collins in countless cases where she's appeared in front of Your Honor, and you do bring that to the table when you evaluate this situation. You consider your life experiences, you consider your history with Ms. Geyser, with the co-defendant, and also your familiarity with the doctors. Dr. Collins is the gold standard, if you will, of psychological evaluations. She has incredible experience, dozens of years working in this field. She runs behavioral consultants. She's the head of the Wisconsin Forensic Unit. This is a doctor who, by all accounts, I think even the state would agree, the state will frequently use Deborah Collins for its purposes. But Dr. Collins endorses Ms. Geyser's release to conditional release. When you read her report, I don't want to belabor it, but we went through it item by item, Your Honor, and Dr. Collins went through the full history of everything that's happened in this case. She went back through the competency evaluations, she went through the medical records, she read the summaries, she talked to the people at Winnebago, and she reached a conclusion that Ms. Geyser is no longer a substantial risk of violence to herself and others. Part of that is, as Ms. Nicolai pointed out when she called their first witness, there are some tests, the HCR test, for example, that they use to help shape their opinions. But it's also, Dr. Collins' opinion is also the product of her long history with Ms. Geyser, interacting with her, talking to her, working with her. And I thought it was significant that Dr. Collins talked about Ms. Geyser's incredible insight that she has into both why the crime happened as well as what her needs are in the future. We cited some of it when we were talking to her on the stand. If you give me a minute, Your Honor. When she asked Ms. Geyser about her symptoms and whether there was any malingering, Morgan said unequivocally that she was delusional and thus psychotic years ago. And whether those symptoms were triggered by schizophrenia or trauma, the way you figure that out is exactly how Kayla Pope, the medical director of Winnebago, proposed addressing it. A person is medicated, they've been stable for a sufficient period of time, and we start to wean them off medication to see whether or not the condition has gone into remission or resurfaces. If it resurfaces, resume the medication. If it doesn't, continue on the positive track that we're on. And that's far different than Randall. Far different, because as I recall the decision pointing out, there was a finding by the court that there was no mental health explanation for any of this. And the crimes weren't even attributable to mental illness, unlike here where they are. And he received no treatment. There's a guy who goes to Winnebago for a decade plus and he gets no treatment. And nothing had changed except the passage of time and repeated rule infractions. And that's far different than Ms. Geyser, who went through a battery of treatment, antipsychotic medication for years, and has been willing to participate and has participated in every interview and evaluation that's taken place to determine what her needs are. And you look at Ms. Geyser's continued performance, unlike Randall, you look at Ms. Geyser's performance of working her job at Winnebago, being honest with the treatment providers. You heard from her therapist, who Morgan meets with in a one-on-one private setting, and the therapist described even in a one-on-one setting, Morgan is highly engaged, she's inquisitive, she asks questions, she works on her assignments, she does the things that she needs to do to better herself. And during the outings that have happened in the community, you have a whole list of infractions by this Randall individual, and the exact opposite with Ms. Geyser. She's going to Target, she's going to Pick and Save, she's going to McDonald's and Starbucks. These are escorted outings, of course, but there's plenty of opportunity. If a person is not functioning properly, plenty of opportunity in these outings for somebody to create a scene, to act out, or to do anything to disrupt the privileges that they have. None of that has happened here. Ms. Geyser's in good, so the question is, the legal question for the court at these hearings is whether the state met its burden of proof with the evidence it introduced today. And it didn't. It didn't, not by a clear and convincing standard or by any standard. The evidence that's come in at this hearing today is that Ms. Geyser is not a substantial risk of presenting great bodily harm to herself or others or property damage. Even after Your Honor denied her release last time, and she was met with the stark reality of the fact that she was going back into custody, back to Winnebago, and had a minimum 6-month period of time before she could even file a petition. She handled that stressful encounter perfectly. She continued with her therapy, continued with her outings, continued working, and worked on her RAP plan, which also demonstrates her ability to understand her condition. You know, when the state argues that Ms. Geyser there isn't an explanation, there absolutely is an explanation, and in fact, Ms. Geyser herself has developed a wellness recovery action plan that she discussed at great length with Dr. Collins. And Dr. Collins noted, she quoted Ms. Geyser about saying that, I acknowledge and understand the gravity of my past actions. This isn't somebody who doesn't appreciate the wrongfulness of what they did. She does. Looking back on it, appreciate that. And she struggled for years to forgive herself for what she did to the, as she put it, the only person who cared about her. And Morgan has completed all of the treatment that's available to her at the institution. There are no greater levels of privileges that she can exhibit. She is a young adult who ought to continue growing in the community. It will make the community safer. It'll make her safer, and it'll make the community safer for her to be out of an institution with acutely mentally ill people so that she can start to grow as an individual. She will be highly restricted, so it's clear. Highly supervised, GPS monitoring, living in a group home. Any misconduct, as you know from your experiences, any misconduct, judge, immediately gets brought back to court. A hold gets placed on her, she goes into custody. If there's even the slightest deviation from the rules and the requirements that are expected of her. But she has shown through her time in Winnebago that she can do everything that is expected of her. She is not behaving violently. She's not injuring herself. She's participating in treatment. She takes her medication. And what Dr. Pope decided to do, I don't know if it's her decision directly or she oversaw it, but the treatment team decision to wean Ms. Geyser off of the medication to see whether the condition was in remission and whether she could be safely supervised without heavy antipsychotropic medication turned out to be the right call, because Ms. Geyser responded favorably to that and continues to respond favorably. Now, do we have 100% certainty? Of course not. That's why the close supervision is important. I would just end by noting that how different this is from the Randall situation in almost every respect. The quality of the doctors that support it, the unanimity of opinions, the thoroughness of the reports, the individual herself sitting here and the things that she's done to prove herself. In the record that's in front of you, the record that the state put in the Randall case showing the pattern of deviousness, dishonesty, deceptiveness that mirrored the crime, justified Judge Dreyfus's decision. No question about it. But this record is devoid of that. Thank you.
All right, thank you, appreciate it. Then Attorney Zapakowicz, do you have a rebuttal argument?
Just briefly, Judge, and I don't think this is certainly a determining factor, but it seems to be fairly easily swept under the rug by maybe the doctors and by the defense here. We had this offense occurred in 2014, and we have her suicide attempt 7 years later in 2021. So a long period of time went by between when she engaged in this violent episode towards the victim and then engaged in what I would describe as another violent episode regarding herself, which by all accounts was certainly a very serious attempt to kill herself. There were 7 years in between those two events, and to say, well, this suicide attempt was a long time ago, it was less than 4 years ago. So I don't think that that can so easily be considered as being so dated that it is not something that the court can consider when assessing whether or not she currently represents a substantial risk. I went back to look at, and I guess I'm unsatisfied, Judge, and I think the court should be as well, from the doctor's explanations of things, because when I look at Dr. Lundbaum's report, and I start at the bottom of page 15 under her analysis and conclusion section, Dr. Lundbaum talks about Dr. Lundbaum's report prior to the hearing in April of 2024, and notes that in that prior report, she raised concerns about Ms. Geyser's remarkably low understanding of her psychiatric illness, especially given her claims that she fabricated psychosis at the time of and for several years after the index offense, in clear contrast to the abundance of evidence available. I noted that the inconsistency in her self-report over time complicated the prediction of her risk for future violence and the ability to create an appropriate supervision and treatment plan. I guess what I'm unsatisfied with, Judge, is there's then no explanation in this current report how that's not still a problem. There's no explanation of how we get past the prior inconsistencies in Morgan's self-reporting and how over time that affects the prediction of her risk for future violence. Dr. Lundbaum just kind of skips over that and goes into, well, she's following the rules, she's doing well, hasn't caused a problem, and therefore, because of all that, I believe release is now appropriate. But again, there's no explanation how we get past that prior inconsistencies in her self-reporting. So that's all. Thank you.
All right, thank you, Mr. Sopakowitz. I'm going to take about a half-hour recess just to review items, and we'll come back. Let's plan to come back about 3:15. So we'll be in recess up to that point. Thank you. Now, the matter is here today after a hearing that lasted most of the day with regard to the petition for supervised release that was that was filed earlier this year. It was filed on October 11, 2024, and then the doctor's reports were received, and we had each of the doctors testify. So the reports that the court received were from Dr. Collins. With regard to her report, she testified. With regard to Dr. Lundbone, she testified as well as her report. And from Dr. Robbins, who testified, and we have his report. All of the reports were received without objection from any of the parties, and the testimony came in smoothly. What's the nature of I went through at the beginning of the hearing this morning what the status of the initial case is from the standpoint of how it came about back in 2014. We're familiar with that set of facts. What the court has to do today is that the court shall grant the petition for release unless it finds by clear and convincing evidence that the person poses a significant risk of bodily harm to herself or bodily harm to herself or to others, or of serious property damage if released. What that sentence takes into account is that the issues of supervised release and not guilty by reason of mental disease or defect takes into account a lot of cases. That we're dealing with an attempted murder case in this matter, but it takes into account many other cases and outstanding criminal matters that are out there that involve property damage, don't involve people at all. So that's why the statute's phrased the way it is. But our focus is on damage, is on risks of safety to Ms. Geyser herself, or the risk to others. And part of that risk is, of course, recidivism, that it happened once, would it happen again, that she'd attempt to kill somebody under any set of circumstances. Those are factors that the court has to look at and decide. Burden is on the state by clear and convincing evidence to establish that the current restrictions and the current commitment should stay in effect. By statute, Ms. Geyser has a right to file for a petition for release every 6 months. So it's not something that, with regard to what the court may or may not do today, if the court denies the petition today, she can come back and file it again in 6 months. That doesn't mean anything other than that's just what the law is. Some of it may have been to address constitutional issues with regard to commitments, but it's certainly part of the system. One thing to keep in mind as well, and that this was a serious criminal case, attempted murder. There are two defendants in the case. Both were children at the time that it happened, 12 years old. The victim was a child. But the case didn't resolve itself per se in the criminal field. It's not a criminal conviction. In this case, based upon the nature of the law and what happened, the court found that Ms. Geyser was not guilty by reason of mental disease or defect. Then that moves it into the commitment field, the civil field that we're addressing today under Chapter 971, in particular 971-17 of the Wisconsin statutes. So this isn't about somebody going to prison, it's about somebody being committed to a mental institution, to a hospital, and how that person functions with that institutional setting. In the statute 971-17 sub 4 sub D provides some factors for the court to look at in deciding how best to look at what the issues are. Factors the court can consider are the nature and circumstances of the crime, the person's mental history, Ms. Geyser's mental history, what her present mental condition is. We've had a lot of testimony about that and a lot of reports written on that topic. Where will she live, what the status is, how the person would support herself, what arrangements are available to ensure that she will have access to and take necessary medications, and what arrangements are possible for treatment other than medications. So some of those factors are clearly pertain to the case, some don't. But I'm going to talk about a number of them as I see the reports and what happened in this matter. A further comment for the court to keep in mind, it was really addresses part of the argument that Attorney Cotton brought forward, and that was the issues in State versus Randall. That was the Court of Appeals decision that was referenced during his argument, and actually referenced by the state at various times as well. In the Randall case, and it's just a 2011 WISAP 102. It's a 2011 Court of Appeals decision. As was noted, Randall is a case that arose out of Waukesha County. It's a Waukesha County case. One of the officers, the wife of one of the officers who was killed, worked here at the courthouse. So it as a case that has deep, if you will, deep roots into the Waukesha County legal system. But it's now somewhat of the stellar case, the keystone case, and looking at issues such as this. But the Attorney Cotton contrasted the conduct of Mr. Randall in all of his situations with Ms. Geyser's conduct, and I think that's a relevant analysis for the court to have heard and for the court to consider. There is a difference between how Randall conducted himself and how Ms. Geyser has conducted herself during the time period that she's been in custody. One of the aspects of the case, and it's apparent, but yet it somewhat needs to be restated, is that the offense in this matter occurred when the defendants and the victim were children. They were 12 years old. The adult offense, no doubt, but still it happened when they were children. It's happened in 2014. It's about 10 and a half years, a little more than 10 and a half years from the date of the incident. So the victim has grown up, the defendants have grown up, things have changed from the standpoint of the chronology and age of the parties. In cases such as this, we never want to lose contact and forget the victim that's involved. This is a terrible, brutal offense. There's no doubt about it. It's a nasty set of situations. I went back and at the time that the court made its initial decision of commitment, the parents of both the father and the daughter of the victim wrote letters to the court that described the status, basically, of what was in existence in February of 2018 with regard to their daughter. And those type of factors are still clear today. It's 10 years later, but I'm sure that the impact on the victim, on her family, and on everybody involved in the case is still very apparent and real. So we want to be sure the court keeps that in mind in deciding how best to proceed. There's been a lot of discussion in the case. In fact, it's a critical part of really understanding and analyzing what's happened in the matter, is that the matter originally came about with the diagnosis of schizophrenia, and that was a lot of discussion at the time of the initial hearings. Childhood schizophrenia is an unusual diagnosis, not common, still not common today. but it still is one that existed, was made, and was clarified and established at the time of the hearing. That was the diagnosis that brought about actually the plea of not guilty by reason of mental disease or defect and the court's ultimate findings. There have been changes in from the Ms. Geyser's standpoint and how she's explained what happened, and that comes into whether the Slender Man, the hallucinations and all that went on with that actually happened, or did she make them up. That's been part of the testimony going back to 2021 and 2022. I'm satisfied that those change in views and circumstances existed, but I'm also satisfied that the treating, and I'm talking about the treating doctors, not the examining doctors, that I'm satisfied that the treating doctors have addressed that issue and have worked with her with regard to that. I'm satisfied that the examining doctors, Dr. Collins, Lundbaum, and Robbins, all address those matters as well. And I'm satisfied through the manner in which they've addressed Ms. Geyser's change in position, if you will, or modification of position is something that's can be reasonably explained under the circumstances. I don't find that she was, from the standpoint, attempting to fabricate a position to get a more favorable position with the court. Now, I raised that issue with Dr. Lundbaum as I wanted to hear what she had to say specifically about that. But I'm satisfied that that is not a factor that I'm considering in deciding how to proceed. I am considering that the diagnosis develops over time, as it does with many people, and I accept Dr. Lundbaum's statements that because of the nature of childhood schizophrenia, it's the nature of the diagnosis, the nature of its history, that it would develop and change over time is not unusual. I accept that. I didn't question was my questions that brought it up with Dr. Lundbaum. I didn't question Dr. Collins or Dr. Robbins about that topic. I was satisfied with what Dr. Lundbaum said with regard to that status, and I'm still satisfied with that. I'm satisfied that one of the interesting, at least I find it interesting and significant with regard to what's gone on in this case and apparently other cases, is that if you're at Winnebago and in a treatment program for a serious offense such as this, Winnebago will only take you so far. And at a certain point, they won't take you any further. Now, it surprised me when this first came up earlier in the case, that I would have thought that the state institution would carry on the treatment and take it to its fullest extent. Whatever the next step is, they would take the next step from the standpoint of improving the mental health of the patient at a minimum, as opposed to public safety, but that's not what they do. At the stage that Ms. Geyser is at, she can't go any further as far as treatment is concerned. And keep in mind that as far as being able to walk around and do stuff, she can walk around at the institution, but if she goes off institution, she always has somebody there, so an escort. Now, to me, in order to be able to really adequately be, if you will, to the extent somebody can be rehabilitated, they have to be able to exist in the community somehow and be able to grow up, if you will. And that isn't going to happen with regard to Ms. Geyser at the Winnebago Mental Health Institute. That's a factor. I don't want to say it's determinative of the decision I've reached, but it's a factor that I've considered as to public safety is really the underlying key to the case, and part of public safety is that Ms. Geyser becomes safe or safer. that was clear in the analysis from the Randall case. It's public safety is tied into the safety of the defendant, of the patient. In Randall, it's clear that Randall never was able. I don't know what his status is currently. He's still in custody. He's still within the program, but that he's never developed that sense when people trust him to be safe. And that's the people that treat them. And that was back in 2011. I'm assuming it's still the case today. That's the factor that I looked at in contrasting Ms. Geyser's situation with Mr. Randall's situation. I looked at Ms. Geyser's her role in working through treatment and supervision at Winnebago, and finally I'm satisfied she's done what she's supposed to do. She appears to have a good attitude. Attitude is important. It doesn't solve all issues, but it's certainly an important part of being able to be rehabilitated and being able to function within the community. Because although we focus on public safety and whether she continues to be a danger, part of that is, if in theory she would be released at some point, she has to be able to function within the community on a safe basis, and people, while she may always be subject to some type of notoriety, there she is, that type of thing, like the scarlet letter almost. And but that there has to be, people have to be able to relax and know that if she walks past them on the street that they're safe. That's what the safety evaluation is, the risk to dangerousness is about in the case, as far as I read it, as far as I read what the statute's concerned. That's because, especially with regard to looking at the Randall rationale, Randall stands for the proposition that I can ignore all of the reports and I can find that she's dangerous simply based upon what happened on May 31, 2014, because of the nature of the offense and the nature of what happened. That's, I can make a decision simply upon that. I'm concerned about making a decision simply upon that because it somewhat flies in the face of what the evidence is with regard to Ms. Geyser's treatment program or regimen, and what I'll phrase it as her success at being treated at the Winnebago Mental Health Institute. One of the activities I engaged in when I took the break was to read my decision from April 11, 2024. I had not read it before. Attorneys at Packowitz referenced it, so I thought I should go back and read what I said back then. And my comments with regard to the nature of the case still to a great extent stand true at this point. However, there have been changes in the case and how I view it based upon what's been presented. And I do rely to some extent upon the reports of Drs. Lundholm and Collins. Dr. Robbins writes a good report, but it's a brief report, and it's almost a flow of consciousness of how he views the case based upon his involvement. Drs. Lundholm and Collins go into more, if you will, more depth, more nitty-gritty of what the situation is and how things developed, how attitudes developed, and what the status of the matter is today. So when I read that and read those reports, it gives me a further insight into what the status is of Ms. Geyser's status with regard to the case. What the record shows that she's done well. She's hasn't had rule violations. Laws are always about rules. Lawyers are always about rules. Courts are about rules. And she's followed the rules. She's done well. Good, I mentioned attitude, positive attitude. Those are all good things to have. Does that overcome what happened back in 2014? It may never overcome what happened in 2014. But the question isn't about what happened in 2014. It's about current assessments of dangerousness to herself, to the public, or a danger to the destruction of property. In evaluating the matter, I take into account, as I indicated at the beginning of my decision, that she's been in custody since she was 12 years old. She's gone through a number of evaluations and treatments. That each one of I think both Dr. Lundbohm and Dr. Collins refer to all of the reports that they looked at. That doesn't always count all of the doctor notes that are involved at Winnebago. To a great extent, the November 7, 2024 letter that was signed by Ms. Parnell summarizes all of those medical records and notes and doctors' notes and observations with regard to Ms. Geyser. So I take that into account in deciding how best to approach the case. The aspect of dangerousness is difficult because we never know. I mean, I could claim to be the smartest person in the world and make decisions, and I don't know what's going to happen with regard to this case or many other cases, or what's going to happen tomorrow with regard to my cold. You just simply don't know. So you have to be cognizant of the if you will, the fragileness of the type of decisions that the court makes and that the court looks at. I note that in Dr. Collins' decision, on she wrote a long report. 37 pages, single-spaced paragraphs, so it's easier to read. But on page 37 of her report, in the second paragraph, and I think Attorney Zapakowicz referred to this during his argument. I'm quoting now, while it is this examiner's opinion to a reasonable degree of professional certainty that facts weigh in favor of Ms. Geyser's petition and placement on conditional release at this juncture, I also recognize considerations which may give pause. The issue of Ms. Geyser's diagnosis enigma is one such consideration. Ms. Geyser now reports that she's never experienced auditory hallucinations or psychotic symptoms otherwise. The etiology of her historic psychotic symptoms remains unclear, especially in light of the fact that she has not been prescribed antipsychotic medication in recent years and has nevertheless not evidently demonstrated a reoccurrence of psychotic symptoms. She warrants ongoing close clinical monitoring and treatment, in part to support her transition to the community through, as importantly, to effectively and efficiently determine and respond in the event of any reoccurrence of symptoms of a major mental illness. I read that paragraph in full because that's an important consideration, and it caused the court pause with regard to how to evaluate circumstances. However, when I read the entire report by Dr. Collins and Dr. Lundbohm, as well as what they testified to, I'm satisfied that those are caveats for the court to be concerned with and to evaluate and weigh with regard to the issue of dangerousness. It's not necessarily a veto over the release on a supervised release petition. So in reviewing all of the reports and the matters, I'm satisfied that under the circumstances that the great court's going to grant the release. I'm satisfied that by clear and convincing evidence that under the current set of circumstances, Ms. Geyser does not pose a significant risk of bodily harm to herself or others, or of serious property damage. Now, when I make that finding, I take into account what happened. I take into account the dangerousness of what happened back in 2014. I take into account, though, what's happened since then, in particular in the last 6 months. I take into account the opinions of the doctors, but in particular, and it's been an important analysis for the court to make, that as the Randall decision talks about, that the ultimate determination of dangerousness requires a careful balancing of society's interest in protection from harmful conduct against the acquittee's interest in personal liberty and autonomy. In looking at the Randall case and of what happened in Randall and what the circumstances were of Randall, when I contrast Randall to Geyser, there's a tremendous difference in the rationale for rejecting supervised release in that case, in Randall's case versus in this matter. When I weigh that dangerousness concept and I come back to what happened and what the progress has been, that Ms. Geyser doesn't fall into the same category as Mr. Randall in his petition for release and the denial of that release. So on that standpoint, I'll grant the petition so ordered. I'll order that the matter be referred to the department. And let me just look at the statute. 971-17 4E. If the court finds the person is appropriate for the conditional release, the court shall notify the Department of Health Services. The Department of Health Services and the County Department in Waukesha County shall prepare a plan that identifies the treatment and services, if any, that the person will receive in the community. The plan shall address the person's needs, if any, for supervision, medication, community support, residential services, vocational services, and alcohol or other drug abuse. The plan shall be presented to the court for approval within 60 days after the court's finding that the person is appropriate for conditional release. Dr. Lundholm, in her report, and I think it's begins on page 15. That begins on page 16 through 17. Lists 11 factors that she'd want considered, and I want those all considered by the department as they determine excuse me, as they determine what the conditional release plan should be. Excuse me, let me just have a moment. In this area, I took into account Mr. Attorney Zapakowitz's argument about what do we know about the future. Well, the way the statute's set up, as I read it, is that the future is determined by the release plan. We only get to the release plan, excuse me, if the court grants the release. For the reasons stated, I've granted it. I'm satisfied now that the fleshing out of what that means, supervised group home, group facilities, that Dr. Robbins discussed and what Dr. Collins discussed as well, are now subject to the state and further subject to my approval when it comes back. So although I grant the supervised release, I did take into account the argument that Attorney Zapakowitz made with regard to what's known and unknown. I'm satisfied that the system we operate under 971-17, takes that into mind and encompasses it in the work that the county, that the State Department does with the county. On that basis, then we'll schedule a hearing within 60 days. My anticipation is that the report from the state, the conditional release plan, will be submitted before then.
Right.
So what I'm going to look is to have let's schedule a hearing within 60 days.
How much time do we need for the hearing?
I'd say an hour. We'll just move other things, just fit it in.
February 20th, too soon?
Excuse me, my coughing here. I want to be sure the report comes in. 60 days would take us to about March 9th. That's maybe at the end of February. Look to have the report submitted within, say, a month of today, supervised release plan within a month, by the beginning of February 9th or 10th.
I have March 3rd at 9 o'clock.
Should we go for that?
I can make that work. I was going to suggest that Friday that week, if that's available for everybody, but I can be flexible.
The 3rd is good for me, better than the 6th or 7th.
Okay, let's just do the 3rd in the morning.
Attorney Nicolai?
That's fine. The 3rd is fine.
Okay, 9 o'clock?
Sure.
March 3rd at 9 o'clock.
So I'm anticipating that we'd have the proposed conditional release plan by, I'll say by February 14th. Now that may change. The state will do what they have to do, but I want to be sure we have plenty of time to evaluate it. With that, then, Ms. Geyser will be remanded to the sheriff to be returned to the Winnebago Mental Health Institute.
Thank you.
So ordered.
I'll be in touch.
Court will be in recess.
Now, what's really interesting is that Morgan is granted conditional release. And this is from January 9th. And as I'm looking through my videos, I'm like, why does she have a conditional release hearing from March 6th of 2025? I'm like, did we do something? Did we get extra videos? What's going on? So I checked that video, and here's the deal. So they're going to get together within 60 days, right? Because we heard all about the Winnebago has to come up with the conditional release plan. They get with her providers and her therapists and doctors and all that stuff. The team gets together. They work out this plan for her so that she can go, be released and go into this group home. And everything has to be reviewed by March 9th. So they set the date for March 30th. The release plan is due February 14th. So then I go over to the description in that hearing, and I'm like, what's going on? All right, but before that, I want to play this news clip, because I'm like, well, maybe this news clip will give us some insight into that. But before I get to that, before I get to the description, here's the news. Let's check out this news clip, see if they give us any insight.
22-year-old Morgan Geyser. 22-year-old Morgan Geyser was granted an early release today. Geyser was just 12 years old when she and Anissa Weier stabbed a classmate 19 times.
They told police it was all to please a fictional character called Slender Man. CBS 58's Jenna Wells was in court today when that decision came down, and she joins us live with what's next for Geyser. Jenna?
That's right. Jessup and Natalie, Morgan Geyser could be released in just 60 days from the Winnebago Mental Health Institute. That's where she's been since 2017. This was Geyser's fourth petition for early release. In the last 3 months, 3 doctors completed evaluations. Today, they unanimously supported her release to a supervised group home, agreeing there's no recent evidence that Geyser poses a danger to herself or to others. Since last May, Geyser has been diagnosed with autism spectrum disorder and gender dysphoria. But doctors say her mental health has been steadily improving, and those diagnoses aren't a cause for concern. Her release will be into a supervised setting. Geyser's attorney, Anthony Cotton, was emotional after the judge's decision, saying Geyser is ready for this next step.
We never know 100% anything, but I think that Morgan really now, with this maturity level, with the amount of treatment that's been done, has really appreciates what her condition and needs are.
Now, Geyser's treatment team has 60 days to draft her release plan. That would include which group home she'll be attending. They then would send that plan to the judge, who has to approve it. There's a court date on March 3rd for that approval. We do also know the family of Payton Leutner, that's the victim in this case, they told prosecutors before the hearing today that they do not support Geyser's release. We've also learned they don't plan to comment now after this decision.
All right. So there's the news. So then we go to March 6th. I'm like, why is there another conditional release hearing? So in the description of this, Slender Man stabber Morgan Geyser is expected to be in court Thursday. This was March 6th, 2025, for a hearing regarding her conditional release. A judge, who we just watched, previously ruled she could be released from the mental health facility she is currently living in, but after concerns were raised over contact she was having with a man outside of the facility and a book she was reading inside the facility, a judge put a pause on her release. Boom. So here we thought, she's going to be released and off she goes into supervised custody. But no, so something happened between January 9th and March 6th. So something happened within that 60-day window that she was having, concerns were raised over contact she was having with a man outside of the facility. Is that Charlie or is that the 63-year-old? Charlie is 43, but identifies as a female. Then this other guy, 63, he's a male, I guess. We don't really hear from him. So concerns were raised over contact she was having with a man outside of the facility and a book she was reading inside of the facility. A judge, meaning Judge Boren, put the pause on her release. So there you go. So that's why we have this. Oh, hi, little Fed. How's it going, my little buddy? I got my little floofy tail. How are you? So now we know why there's this hearing on the 6th. I'm like, why is there a hearing on the 6th? All right, so let's check this out. Maybe they'll explain it within this. I would expect that the state will be like, well, we found this information out. So let's check this out. The saga of Morgan Geyser. Right? The saga of Morgan Geyser. All right. Let me cue us up here. Morgan can't get out of her own way. All right. So this is from, let me change the, so this is from March 6th. It's really cool. I mean, Jenny, I know you said you really appreciate this deep dive and stuff. So do I. This is really amazing stuff. All right, that's my water. Get your face out of there. All right, so this is from March 6th of 2025. So here we go.
All rise.
Thank you. Please be seated. Court will call the matter of State of Wisconsin versus Morgan E. Geyser, case number 14 CF 596. Appearances.
Good afternoon, Judge Abby Nicolai appears on behalf of the state.
Good afternoon, Judge. Morgan Geyser with Attorney Anthony Cotton. She's here in person.
All right, thank you, and good afternoon, all. We're here on the review of the court's petition, the order to proceed with conditional release, and then the petition filed to revoke that order. So how is the state calling a witness? Or how should we proceed?
Judge, given today's scheduling was primarily based around the 3 doctors' schedules, I would suggest that we perhaps start with their testimony, because I know that they were all available today, and I believe they're all on Zoom. And I know that the court had questions for the doctors, so that would be my proposal.
Well, should we introduce the petition, though, of why we're here?
Sure.
We have the petition that seeks to revoke the conditional release.
Right.
Is there a witness here to testify about that?
I have several witnesses on the state's burden, none of which I anticipated including any of the doctors.
All right. Well, I think we should put the petition into the record officially so we can have individuals comment on it. So who is calling to authenticate it?
Well, I have, this afternoon, I plan to elicit testimony from Nicole Whitaker from WCS, who helped author some of the information, as well as Kathleen Martinez from the Department of Health Services. And then there's also a witness on Zoom who is part of the defendant's treatment team from Winnebago, Lisa Portman. I was going to have testimony from all of those individuals in regard to the information that was filed in document 655, the petition to revoke conditional release.
Well, it was signed by the amended petition that they filed most recently. It was signed by Nicole, but by Nicole Whitaker. Is she available?
Yes, she's here, Judge.
Well, we should have her then be the one that introduces it so we have it in the record.
Okay. She did sign that memorandum. The actual petition to revoke the conditional release is signed by Aaron Graff from the Department of Health Services, who's also here. The WCS memo was included underneath that petition as a factual basis. Ms. Graff is also here, as is her supervisor, Ms. Martinez. So however the court would like me to begin, I can do that.
Well, I'll allow you to decide how to begin. I just wanted to get it in to the into the process. I'm just looking for it. I have the statement of probable cause for detention and petition for revocation of conditional release. That was filed in court here on February 27th. And that letter is signed by Nicole Whitaker as well. The reason we're here is they filed a petition.
Right. I did not mark the petition as an exhibit. Because it's already in the court record, and I apologize. Perhaps I should have done that.
Well, we'll use it as Court Exhibit 1.
Okay.
And who, I guess, should Ms. Whitaker be the witness that comes in?
She will be one of my witnesses, yes.
Well, let's call her and she can identify it so we have something to proceed with.
Sure. I'd call Nicole Whitaker.
Ma'am, if you'd come forward, have a seat behind the court reporter. We have an exhibit tag for that. And then, ma'am, if you'd stand, remain standing, raise your right hand. Do you swear that everything you're going to testify to today is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you. You may be seated. And then state your full name and spell your last name.
Nicole Whitaker. My last name is Whiteaker.
No, we're missing, excuse me a moment. We're missing sheets. What I've done is I've copied the petition and marked it as Court Exhibit 1.
Thank you, Judge.
All right, thank you. I'm just going to give you now what's marked as Court Exhibit 1.
Thank you.
And then I'll turn over to Attorney Nicolai.
Thank you, Judge. Ms. Whitaker, where do you work?
I work for Wisconsin Community Services.
And what do you do there?
I am the Conditional Release Program Supervisor.
What does that mean? What are your duties?
I oversee a team of people who are overseeing participants who are released into the community under conditional release.
Did you become involved in preparing a plan for Morgan Geyser in this case?
I did.
And did you begin to prepare that plan in this case?
I did.
Ultimately, did you write a memorandum with some information in it that was filed with the court?
I did.
And you've been handed Court's Exhibit Number 1, is that true?
Yes.
Is that a multi-page document?
Yes.
What's the date of filing on that document, please?
February 27th, 2025.
Okay. And do you recognize that document?
I do.
What is it?
This is the 5177 petition for revocation.
Is there information in that petition that you generated?
There is.
What information is that?
I generated a portion of this that are numbered, and that comes out of case notes that were done after meetings with Ms. Geyser.
Could you refer the court to a page number where your content begins?
Mine is not numbered, but I'm on the 4th page.
Okay. Is there a WCS logo at the top left corner of that page?
There is.
Okay. On the final page of that exhibit, is your electronic signature there?
Yes.
Okay. Why did you compile the information in this memo?
We, as a treatment team...
I'm going to object to her testifying as a treatment team when she's asked what she was tasked with.
Sustained.
Do you want this marked as well? That's number 2.
Sustain the objection. Can we go ahead?
Sure. When I want to back up a little bit. Did you meet Morgan Geyser when you were assigned to this case?
I met her previously to being assigned to this case.
Okay, and specifically to planning the conditional release plan, did you meet with a team that was tasked with creating that plan?
I did.
Who was a part of that team?
There are several members of the team that include myself, a case manager, our partners at DHS, and members of the Winnebago Mental Health Institute treatment team.
And when you say DHS, are you talking about the Department of Health Services?
I am.
And would that include Erin Graff?
It would.
For the record, is that GRAF?
Yes.
And is her signature actually also on Exhibit 1 that you were given by the court?
It is.
And what part did she play in this filing, if you know?
She filed the 5177.
And she's an employee with the Department of Health Services, is that true?
She is.
Okay. But was she also a part of the team that was helping to prepare this conditional release plan?
Yes.
Okay. And how many meetings do you think that this group had in regard to the conditional release plan in this case?
Initially, the treatment team meets as a whole in the beginning when a participant's granted conditional release, and then a smaller group meets with the participant on a weekly basis going forward until she's released.
When the group became smaller, what participants were left in it?
Myself, my case manager, the participant, and sometimes her social worker at Winnebago.
Was the social worker always in those meetings in this case?
Not always.
Why not?
There were times that Morgan had asked her to leave.
Was that social worker someone that was recently brought into Morgan's team?
Yes.
Okay. At some point in time during these planning meetings, did reading material become a topic?
It did.
And why would it be important for you in preparing a conditional release plan to know about a participant's reading material?
In the beginning of preparing a conditional release plan, it's really important for us as a team to build rapport and get to know the participant, coping skills, things of that nature. And the purpose of the conditional release plan is to mitigate risk to the community. When we started looking into things that Ms. Geyser liked to do, reading became a topic. To then we inquired about what types of books and things like that.
Okay. At a point in time, did you become concerned about information you learned about reading material that Ms. Geyser was using?
I did.
Why?
Because it is related to the index offense, I suppose.
In what way?
It's violent.
Specifically, is one of the books that you're referencing called Rent Boy?
Objection leading.
Overruled. It is leading, but we all are familiar with these various documents, and this will move the hearing along, so overruled.
Yes.
And did you have concerns about the fact that Ms. Geyser had read that book?
I did.
Why?
Because it was a dark novel that revolved around murder and the selling of body parts on the black market, along with sexual sadism.
Is that information contained in the material that you put together in Exhibit 1?
It is.
Okay. How did Ms. Geyser react when she was informed the treatment team and conditional release team would be monitoring her reading material?
She was upset.
Did she say why?
She didn't feel it was necessary for the team to oversee things that she used as coping skills and a creative outlet.
Do you consider it an important part of a treatment plan, a conditional release plan, to monitor things like reading material and media usage?
Yes, that's a standard thing that we do as a conditional release team, and it's very individualized to each participant as well as their index offense.
Was that fact relayed to Ms. Geyser?
Yes.
And was she receptive to that?
No, she still thought that it was unnecessary.
Did you talk about monitoring Ms. Geyser's reading material during more than one meeting with her?
We did.
Did her response to that monitoring ever change?
No.
Would it be fair to say she pushed back on that monitoring?
Yes.
Did she ever come around and acknowledge that that would be an appropriate thing for the team to do?
No.
Was that concerning to the conditional release team?
It was.
Why?
Because it shows risk, and the conditional release plan cannot, or the conditional release team, I'm sorry, cannot write a conditional release plan when we aren't aware of the risk to the community.
Was there a point in time when you approached Aaron Graff and Kathleen Martinez with the Department of Health Services about preparing this plan?
Yes.
Why did you do that?
Because things were coming to light that the treatment team wasn't aware of, and I needed to pass that on to other people as she's being released into the community. I can't be the only one harboring that information. The team needs to be aware.
How did you know that the treatment team wasn't aware of these things?
Well, initially I brought it to Aaron and Katie, and they then looked deeper into things with Winnebago.
So that discussion and comparing information with Winnebago was not a role that you took on personally?
Correct.
Okay. Are you aware of an individual named Jeffrey Pagels?
I am aware of him, yes.
When you are creating a conditional release plan, is it important for you to know people who a participant is having contact with outside of an institution?
It is.
Why?
There are a number of reasons, risk being the number one. We have to take in the participants' treatment needs, as they're in the community. And so I asked Ms. Geyser, who are the people that she's communicating with on the outside, and that his name came up.
How recently had she had communication with him?
I'm not sure the answer to that. I know that she stated he did send her a letter after she was granted conditional release, and she stated that she ripped it up and threw it away.
So at the point in time when you discussed this individual with Ms. Geyser, did it seem that she wanted contact with him?
No.
Okay. Is there information nonetheless about this person in the memo in Exhibit 1 that you wrote?
Yes.
Why? What is included in here and why?
After the team became aware of him, it was during that meeting that Ms. Geyser asked for a no contact. We further looked into things to find out if there was such a need for a no contact and what was the reason. And we found a number of things on his Facebook that pertained to Ms. Geyser that we were concerned about.
And before I forget, I apologize for jumping topics here. Ms. Whitaker, I want to ask you one more question about the book Rent Boy that we talked about.
Okay.
Were you able to ascertain how Ms. Geyser got the book to read in Winnebago?
I was under the understanding that she had got it from the library, but then it later came out that it was sent to her.
How?
Via mail from somebody, I'm not sure.
Okay. Now going back to, you indicated that there were things, did you do research on this individual on the internet, or how did you know these concerning things about this individual JP?
I did not personally do the research. My lead case manager did, as well as the social worker at Winnebago Mental Health.
And what was anything that was found significant to your assessment of Ms. Geyser's risk to the community or herself?
I'm going to object to that. She didn't do any research on Jeffrey Pagel.
Overruled. Witness can answer.
Can you repeat the question, please?
Sure. Was there any information about this individual JP that was relevant to your assessment of Ms. Geyser's risk to herself or the community?
Yes, but it was also concerning for Ms. Geyser. And when we talk about risk to the community, she is included in that assessment, and he had things directly relating to her on his Facebook page, so yes, that was concerning.
What types of things relating to Ms. Geyser was on his social media accounts?
I'm going to object on relevance grounds. And I'm happy to make further argument.
In overruling objection, I think it's relative and probative to the issues that have been raised by the petition to revoke the conditional release, from the standpoint that information the person, Mr. Pagels, may have on his Facebook account could be from any place, but it may also involve information that purportedly may have come from Ms. Geyser. I don't know that, but I wanted to be able to hear that, and that should be part of the record. So I'll overrule the objection.
We found that there were letters and drawings that she had sent him, a postcard, and he was selling them. He was selling the items.
Were you able to see the drawings that he was purporting were from Ms. Geyser?
Yes.
Were they concerning to you?
Yes.
Why?
They were very dark in nature. I would describe it as a horror type picture.
Excuse me?
Horror.
All right.
I want to show you what's been marked as State's Exhibit 1.
Yep, thank you.
Thank you.
Do you recognize that?
I do.
What is it?
It is a drawing that Morgan has done.
Where did you get it?
Off of Jeffrey Pagel's Facebook page.
Was that one of the items for sale?
Yes.
How was it being was Ms. Geyser's name linked to that piece of art in the sale information?
It was.
Does that look like a fair and accurate copy of the item that you found for sale in this case?
It does.
I'd move Exhibit 1 into evidence.
Any objections? No. Received.
And Judge, I can either display it digitally or just have the witness hand you the paper copy of it.
You can display it digitally.
Ms. Whitaker, is the Exhibit 1 on the screen in front of you the same as the paper copy that I handed you?
It is.
Okay. And remind the court again what this is?
That's a drawing that came off of Jeffrey Pagel's Facebook page. He compiled a number of items that he was selling as, he called it the Slender Man package.
Okay, thank you, Madam Clerk. Were you able to ascertain how long Ms. Geyser had been a willful participant in communicating with that individual, JP?
I do not have knowledge on how long the relationship lasted or how long they communicated.
Okay. At a point in time, did you learn any information about JP that was concerning as it related to sexual behavior?
Yes.
And what was that?
In speaking, we were very open about this topic with Ms. Geyser during the meetings, as it's a great risk as she comes into the community, and she was aware, and she recalled that he would get sexual gratification from her index offense, and I believe that there were letters written back and forth.
Is that information something that Ms. Geyser told you during a meeting?
She did tell us that, yes.
Okay. Is that, as far as you're aware, is that information something that she had worked on in therapy or with her treatment team to that point?
I was not sure.
Okay. Was that concerning that you didn't know the answer to that?
Yes.
Why?
Because it tells me that there's an unknown risk.
When you first, strike that. The Exhibit 1, you testified that the bulk of the information you included is bulleted with numbers, is that true?
Yes.
Okay. So would it be correct that in terms of creating the conditional release plan in this case, one of your first meetings with Ms. Geyser would have been on or about January 17th of this year?
That's correct.
Okay. During that initial meeting, did you learn what Ms. Geyser's preferred pronouns were?
I did.
At that time?
I did.
How did you learn that information?
At the beginning of the meeting, my greeting or opening statement was, "Hi Ethan, how are you?" And she had responded, "JK, I am going by Morgan, she, her pronouns."
What was Ms. Geyser's demeanor like when she said JK to you?
Very light, aloof, just very casual.
Why did you greet Ms. Geyser as Ethan?
Because I had previous knowledge that she was now identifying as Ethan using him, her pronouns. He, him pronouns, I'm sorry.
In terms of Exhibit 1, the conclusion section and recommendation section, is that something that you authored?
I did not.
Okay, who authored those pieces, if you know?
Katie Martinez from DHS.
Okay. And in terms of the decision to actually file this material as a petition to revoke conditional release, was that a decision that you made on your own?
It was not.
Was it even your decision at all?
No.
Okay. Those are all the questions I have.
All right, thank you. Cross-examination.
Do we have a hard copy of Exhibit 1?
She has it.
That's the February report. You have Exhibit 1 in front of you, ma'am?
I do.
Yeah. Yes, she does.
Okay, can I go?
Sure.
Can I see that, please?
Sure.
Good afternoon.
Good afternoon.
This report that you just testified to is dated what date?
February 27th, 2025.
Can I mark Exhibit 2 down under this date?
Now, are you marking the one that came in on March 4th?
Yes.
I have it already marked as Exhibit 2.
Perfect, change that.
Sure.
So what you just testified to is an exhibit from February 27th. I'm showing you Exhibit 2. What's the date on that report?
March 4th, 2025.
The reason there was a second report is because the first report that you authored contained inaccuracies, correct?
Correct.
In other words, you made mistakes.
Not me. It was Winnebago had not given accurate information to DHS.
So inaccurate information was provided to DHS from Winnebago.
Yes.
Then DHS provided that inaccurate information to the court.
Through the filing, yes, that's why we amended.
Okay, well, we're going to make sure we have accurate information today, okay?
Perfect.
So the March 4th report, Exhibit 2, in front of you has certain things that are crossed out, right?
It does.
And just so I'm clear, ma'am, I only want to ask you questions about things you have personal knowledge of that you did. I don't want to get into what other people did, okay?
I just want to note for the record that Exhibits 1 and 2 are actually Court Exhibit 1, Court Exhibit 2. You may continue.
Yes. So just so we're clear, when things are crossed out in Exhibit 2, it's because that was inaccurate information and you're trying to correct it for the record, right?
Yes, but I did not make those corrections.
Okay, so points 1, 2, 3, 4, 5, 6, 7, 8, are those, did you type those line items?
I did.
But in terms of making the corrections, some other person did that?
Right.
Okay, so as I understand it, your job is, well, I don't know that we got into this. What is your educational background?
I have a bachelor's degree in criminal justice.
Okay. What else?
As far as my education, I have ongoing mental health education through, employment. I've been working in the mental health field over 17 years.
Okay, so you have a bachelor's degree.
I do.
You are not a doctor.
I am not.
Not a psychologist.
Nope.
Not a psychiatrist.
No.
You're not holding yourself out that way at all, I'm assuming, right?
Absolutely not.
Okay. You would agree that, strike that. You are in charge of the condition, you are a WCS conditional release supervisor, right?
Yes.
And so would I be on solid footing if I said that part of your job is to manage the team that will oversee the conditional release?
Yes.
For Morgan specifically, as part of this process, did you yourself ever speak to any of the 3 doctors who did the reports in this case?
I had not.
Okay. You've never called Dr. Lundbaum?
No.
You've never called Dr. Collins?
No.
And you've never called Dr. Robbins?
No.
Have you, as you sit here today, have you even read their reports?
Yes.
Okay, which ones?
I don't have the dates memorized. There were a number of reports. I can't give you specifics.
Okay, well, there are 3, you are aware that there are 3 doctors who have authored reports that have gone to the court in support of Ms. Geyser's release.
Yes.
And it's your testimony that you have read, you're not sure if you've read all of them or you have read all of them?
No, I had at one time. I have not read them recently.
Okay, well, I wasn't asking about dates, but you're sure you read all 3 reports, right?
Yes.
Okay. And did you read those reports before you authored or before you put together the petition to revoke Ms. Geyser's release?
I didn't put together the petition to revoke.
Or before you typed the WCS letter?
Can you rephrase the question, or can you restate the question? I'm sorry.
Did you read those 3 doctor reports before you put together the letter that you authored?
Yes.
Okay. So as I understand it, you've met with Ms. Geyser on a few occasions. How many times?
I'm not sure the number of times off the top of my head.
Okay, is it more than 5 or less than 5?
More than 5.
So you drive up to Winnebago and do meetings there at Winnebago?
We do Zoom meetings.
Have you ever met her in person?
I have.
How many times?
About 5, maybe.
So you've done Zoom meetings and you've also driven up to Winnebago to meet her in person, right?
I have, but that was different conditions, yes.
What does that mean, different conditions?
We do what's called community success groups that we go up to Winnebago and do education. So that's when, I've met Ms. Geyser.
Okay, so you're talking before before conditional release was granted. So since conditional release was granted, were those meetings those were Zoom meetings?
Yes.
Okay, but the other occasions in the past you met her face to face?
Yes.
And to be clear, I think the last question Ms. Nicolai asked you is about the petition to revoke. That's not your doing, the petition to revoke.
Correct.
What you've authored is a WCS letter that's attached to that to provide information for the court, as I understand it.
A portion of the letter.
Right, not even the whole thing.
Right.
Now, you said that it's important to build rapport with a person who's going to be released, right?
Absolutely.
And because you're going to be involved in Ms. Geyser's life going forward on a practical level. If she's released, you're going to be involved in her life, right?
Yes, her case manager would be more so, but yes.
But just so it's clear, WCS as an agency provides support in the community for people who are on conditional release, right?
It does.
So rapport is sort of a two-way street. It's important for you to have a positive report towards her and her to have a positive report towards you.
Yes.
And you're aware, I mean, you've been to Winnebago before, so you're aware of what the facility is like, right?
Is that a yes or a no?
Yes.
Thank you.
It is a secure facility, if you will, is it not?
Yes.
And I know we call it a mental health institute, but there's security and guards and rules at an institution like that, aren't there?
Yes.
And in order for somebody to get a visit at Winnebago, whoever's in Winnebago, they're just sort of there, and another person in the community can request to come visit that person. Is that how it works?
I do not know.
What you do know is that Morgan had some visits with a person named Jeffrey Pagel, because you've testified about his name today, right?
Yes.
And if I go to Exhibit 2, if you have Exhibit 2, I want to draw your attention to paragraph 7, which is your note from February 19th. Did you author that?
I did.
And again, this is information that you had supplied to the court because it's being given to you by Winnebago, right?
I'm sorry. Can I correct something?
Sure.
That number 7 was authored by my lead case manager.
So some of the numbers in here are things that you wrote and some aren't?
Right, they come from case notes. That is a collaborative effort.
So, in other words, you put your name on a document that you've not entirely authored because it's a team approach.
Yes.
Okay. And on item 7, it's indicated that Jeffrey Pagel had visits with, well, I guess they used the initials JP. That's who we're talking about, right? Pagel?
Yes.
Had visits with MG, that's Morgan Geyser, right?
Yes.
At Winnebago 3 times.
Yes.
Initially, it was reported that it was 4 visits, but in fact, it's only 3.
Correct.
And every one of those visits that took place with Mr. Pagel was at Winnebago.
Yes.
There is no suggestion that Ms. Geyser ever met him in the community.
I'm not aware.
You're not aware of any of her outings that she secretly had contact with Jeff Pagel, right?
Correct.
There's no suggestion at all of that.
Not that I'm aware of.
Okay. And the 3 times that Ms. Geyser saw Pagel was inside, as you understand it, was inside Winnebago's secure facility.
To my knowledge.
So Pagel went through whatever process he would have gone through to get permission to go into the facility to see Ms. Geyser.
I suppose.
And those visits spanned 3 visits over the course of 10 days. That's the extent, isn't it?
From the records they provided us, yes.
June 3rd, June 8th, June 13th.
Yes.
Of 2023.
Yes.
So Winnebago supplied you with those records, right?
They did.
So Jeffrey Pagel's name was known to Winnebago in June of 2023.
It was.
In fact, they were aware of the visits because that's the institution that provided you with the records, right?
Correct.
And initially it was reported that Pagel visited her on June 30th, but then that's crossed out because that actually never happened, right?
That's what I'm told.
And in fact, it was Miss Geyser that there was a visit scheduled on June 30th with this Pagel person, and it was Miss Geyser that canceled the visit, right?
I don't have firsthand knowledge of that, but that's what I'm told.
Your report that you supplied to the court says Miss Geyser rescinded permission. That's the language you supplied to the court.
Yes.
So your understanding is that it was Miss Geyser who rescinded the ability of Pagel to visit her further.
Yes.
And there's been no further visits that you're aware of from Jeffrey Pagel.
Correct.
And there's been no contact with him in the community that you're aware of.
Not aware of any, no.
And as part of the release planning process, when you talk to Ms. Geyser about people she's had contact with, she brought up Pagel as a person. It was her that brought that name to your attention, right?
Correct.
It wasn't like she was hiding something and you found some notes or something in her room. She told you about Pagel.
She did.
And she asked, didn't she, to have a no contact with Pagel?
She did.
Because she still, as of the time you were meeting with her in January, was expressing a desire not to have contact with him.
Correct.
I want to ask you something totally unrelated to Morgan because I think it's important. You've been doing this for 17 years in the mental health field, right?
Yes.
And we don't need to get into the details of other people's cases, but you are aware that Ms. Geyser's case, if you will, is of a high-profile nature, right?
Yes.
We all sort of know about it because whether you've been involved in it or not, people have heard of the Slender Man case and people are just generally aware of that.
Correct.
And the reason why that's important is because as part of Morgan's release planning, that's an additional variable that exists in her case that doesn't exist in everybody else's cases.
Correct.
And so thinking about that variable and talking with her about how to sort of constructively handle that is important.
Yes.
Pagel is sort of, feel free to disagree with me if you want, but Pagel is sort of a classic example of somebody who appears to be fixated, if you will, on the Slender Man case, or Morgan specifically, right?
It appears he's fixated on true crime as a whole.
When you looked at his Facebook page?
Yes.
Because you didn't talk to him, I'm sure, right?
Absolutely not.
So do you know that he's a former, has a law enforcement background?
I do not.
Did you know that he used to be in the correction, work in the correctional system?
I do not.
So you know nothing about Pagel?
Nothing.
Other than what you see on Facebook?
That's correct.
And he appears to be somebody who's fixated on, what'd you say, true crime and things like that?
Yes.
And he's the one who's selling things on the internet that he purports are from Ms. Geyser.
Yes.
And you don't know, there's two things that are unclear from when you look at Pagel's Facebook page. One is whether the things he says Ms. Geyser sent him were even sent by Ms. Geyser, right?
I'm sorry, can you say that again?
When Pagel puts something on Facebook and says, here's the Slender Man letter.
Sure.
Do we know as a treatment team that Ms. Geyser even wrote that letter?
No, that was why we were looking into things.
Right, because any person on the internet could claim that I got this from Morgan or I got this from whoever, right? So you don't really know that the things he's saying he got from Morgan even came from Morgan, right?
She had told me that she had sent him things and she was aware that he was selling them, so we did know.
Okay. So Morgan was willing, was just discussing with you the fact that she had a letter communications and had sent him some drawings, right?
Yes, we asked her about it and she was aware.
Okay. Is there any suggestion that Morgan was trying to profit from her crime in any way?
That's unknown.
Okay. In other words, no. There's no evidence that Morgan was
correct
doing that, right?
Correct. Yep.
Okay. And because there's lots of things that are unknown, I just want to focus on what we do know.
Okay.
What we do know is that Pagel is posting things for sale on the internet.
Yes.
And Pagel is apparently fixated on true crime type things.
Yes.
But Morgan herself hasn't had any physical contact with Pagel in over 18 months.
Not that I'm aware.
And has never seen him in the community as far as we know. Right?
Correct.
And has herself asked for a no contact order.
Yes.
And as part of a treatment release, when you're planning someone's release, a person gets rules, right? It's sort of like being on probation. They have a list of rules that they have to abide by.
Correct.
And certainly on those rules, oftentimes there will be no contacts with certain individuals.
Yes.
I mean, one obvious no contact would be the victim of the crime and the family members, right?
Yep.
And then, so it seems like Ms. Geyser is aware of that. So when she uses the phrase no contact, it's in the context of, I'd like there to be a rule that makes it clear not to have contact, right?
Correct.
And in terms of making sure that somebody knows how to, well, let's go back to sort of the nature of the crime. There will be people who probably try to reach out to Morgan if they know where she is or they know how to get a hold of her because they might be obsessed with Slender Man case, right?
That's been the history.
But actually what's going to happen, as I understand it, is judge had ordered conditional release, and so you as part of the planning group, you were going to put together a plan for her to go to a group home, was the idea.
Correct.
And as I understand it, there were 2 group homes that were identified, but one was too expensive and one was affordable, right?
Yes. Well, yes.
Two group homes that would take her, right?
Yes.
And so the one that you had identified would be a location that would be confidential in a way, wouldn't it?
We were going to try to make it confidential.
Okay, I just want to explore that. I mean, the idea was even Morgan shouldn't reveal her own location to start with, right?
Yes.
So and it may not be, we're not saying forever, but to begin, don't even let your mother or anybody know the exact location, right?
Correct.
Because what I think we're trying to do is make sure when she's released that these Pagel type people don't flock to a group home or start writing letters to her as she's transitioning into the community, right?
Correct.
And so in a way, as she sits here right now, anybody can write a letter to Winnebago where she is, and either Winnebago gives it to her or they don't, right?
That a yes or no?
Yes, I'm sorry.
But when she goes to the group home, the idea, your guys' idea, or the team's idea, was keep the location confidential as much as possible so we can help transition Morgan into the community safely.
Correct.
And that can be hard for her to process in a way because it's almost more restrictive in a sense than Winnebago is, isn't it?
Yes.
I know she's worked hard. You would agree she's worked hard to earn her release from Winnebago, right?
Yes.
And so she has release privileges where she can go into the community in a supervised fashion and have visits from family members and friends, right?
She does.
But that's going to change when she goes to a group home. She's actually going to be more restricted to start with.
Initially, yes.
And Morgan specifically and people in general, that can be a hard thing to have to work through, the fact that they're going from having some privileges to now having almost more restriction, even though they're not in an institution.
Yes.
So things like crying and let's talk about the books. Did you ask Morgan to put together a list for you of all the books she's read? Let's pick the last year. Did you say, Morgan, give me a list of all the books you've read in the last year?
No.
You do know that she read Rent Boy, obviously, because you mentioned it, right? But the reason we know that is because Morgan brought it up as part of the release planning.
Yes.
And that's important because it's not like you found it hidden somewhere in her. It's not like Winnebago found it hidden somewhere, right?
We asked her to provide us with a list of books that she would like to read, and she had brought up that she was reading Rent Boy. She stated that she didn't want to tell the conditional release team the kind of book she was reading because she was afraid that we wouldn't allow them because they were kind of dark, I think was the way she described it.
Did you ask, so you were asking sort of prospectively, can we have a list of books that you are planning to read as you are released?
Yeah, what are you interested in reading?
Okay, but you never asked her for a list of books she's actually read, right?
No.
And in something like Rent Boy, there's no evidence that she sought it out. It appears that somebody mailed it to her at the institution, as you understand it, right?
I don't know if she sought it out or not.
Well, but you said before you believe someone mailed it to her.
That's what I'm told, yes.
Okay, so all we know is that someone mailed her this book and she read it, right?
I suppose that's what I'm told.
Yeah, we're told that someone mailed her the book.
Yes.
She read the book, and then she disclosed to you, or the team, that she had read the book.
Yes.
Okay. And so, isn't honesty an important part of one's release plan?
It is.
Morgan should be commended. Morgan should be commended for not concealing the fact that she was reading a book that has some dark themes to it. Agree?
I'm not sure. I'm not a doctor, so I don't, from the clinical standpoint, that's not my role.
Okay, so you defer that question to the doctors who can testify about whether that's a problem.
Yes.
But it gets presented to the court and disrupts her release plan potentially because it's being represented as a problem, but you've never talked once to the doctors about it.
Correct.
Okay, and you could have. Before you filed this letter from WCS that now seeks to revoke her release, you could have called any of these doctors before you filed this letter and asked them, hey, we learned that she read Rent Boy. What's your opinion? Is that a problem?
Objection, she didn't file the letter.
Okay, before you authored the letter, you could have called any of these doctors and asked them, is this a problem?
DHS contacted the treatment team at Winnebago to look further into it. So that's what they were doing.
Okay, and so the answer is you didn't do that, right?
Did I contact the doctors? No.
Now, since you read Dr. Lundbaum's, I want to ask you about Dr. Lundbaum's report. You know you've read the 3 doctor reports, right?
Yes.
And Therefore, you are aware of the fact that even back when Dr. Lundbaum authored her report in December, that it was known to the doctor, it was known to Dr. Lundbaum at least, that there are drawings, letters, and other items being sold on the internet purported to be drawn by Ms. Geyser. You were aware of that, right?
Yes.
So it's not anything new. Dr. Lundbaum knew that when she wrote the report.
Yes.
And in fact, when Ms. Geyser was questioned about it, she acknowledged that she had done that, right?
Yes.
Okay. And this Jeffrey Pagel person, are you also aware of the fact that Jeffrey Pagel was a known person to Dr. Lundbaum as well?
I recall that she had knowledge of him, yes.
In that Ms. Geyser had talked about how the fact that she learned on her own that this Pagel person that her letters or drawings that she had sent to him, that he was involved in trying to sell these things, she brought it to the doctor's attention back in June of 2024.
I don't recall what's stated in the report.
Now, the reason these reports are important is because when a person is released on conditional release, these reports become part of the treatment process, don't they?
They do.
And you've read the reports, but I just want to be clear, you never reached out to these doctors to discuss any of your concerns about the book or Jeffrey Pagel,
Objection
right?
asked and answered.
Sustained.
So, with respect to the art that Ms. Geyser does, were you aware of the fact that Ms. Geyser has discussed her trauma therapy and the therapeutic benefit from her artwork, and the fact that a lot of it is disturbing but helps me cope with the trauma I've been through? Are you aware of that?
That's not my role.
Okay, but we're using her artwork here, this picture that you testified to. What's the point of providing this to the court? What is the intention behind giving this to the state?
What is the intention behind giving it to the state?
Yes.
Because it raises a concern for risk.
But you never took this picture that you've now given to the state and asked Dr. Lundbaum, does this change her risk?
That's not my role.
Okay, whose role is that?
That would be the doctors that are treating her.
That would be the Winnebago doctor's role.
Winnebago, yes.
So you become aware of a drawing, and you then mention it in a revocation letter that is supplied to the court. But you were also aware of the fact that Ms. Geyser has been drawing disturbing things for a long time. And Dr. Lundbaum was aware of that when she suggested that Morgan was appropriate to be released, aren't you?
That's the report.
This is not new. Her doing a disturbing drawing is not a new fact at all. Agreed?
Agreed.
Okay. So we'll put that to the side. And nor is Jeffrey Pagel a new thing at all. He was known 2 years ago in June of 2023 when he was going to the institution.
To Dr. Lundbaum, yes.
Well, actually,
It was in her report.
Right, and to the whole institution, because the records at Winnebago reflect the fact that he was a known visitor to their facility.
Yes.
And the records never showed anything inappropriate between Ms. Geyser and Mr. Pagel during any of those visits.
I'm
I'm going
unaware.
to object on foundation of this witness to testify about all of Winnebago's records.
Overruled. Witness can answer if she can. If she doesn't know, she can say she doesn't know.
I do not know.
So in addition to this one book, Rent Boy, did you ask Ms. Geyser about the other types of literature that she's interested in?
Yes.
You know that she's interested in biographies, right?
Yes.
And you know that she likes historical books, if you will. I might have said Westerns previously. She doesn't like Westerns, but historical books, right?
I am not aware.
But she's talked about her like of Vincent van Gogh, for example, and reading biographies about him, right?
Okay, yes.
And at Winnebago, she doesn't have internet access at Winnebago, right?
I'm not sure what she has access to at Winnebago.
But when you've met with her and talked to her about her hobbies, a central hobby for her is reading, right?
Yes.
It's really been, for the 11 years that she's been in custody, it's really been a crutch for her and something that she's relied on, isn't it?
I know that it's something she's interested in.
And so what Morgan has, and Morgan has an interest in a wide array of reading material. You're aware of that, right?
I'm not aware of a wide array. I know of the horror books that she's described. She mentioned fantasy and the biographies.
Okay. Those are all my questions.
All right, thank you. Redirect.
Ms. Whitaker, why did you think it was important to share this information with the Department of Health Services?
It raised risk, and we needed to be aware that the treatment team was aware of these risks and that they were being addressed in treatment with Ms. Geyser.
When you say treatment team, what are you talking about?
I'm referring to the doctors and therapists at Winnebago.
Why, if Ms. Geyser is getting out into the community anyway, why does it matter what is being addressed with the treatment team at Winnebago?
We take that as a foundation as we go into the community and know how to treat her into the community to mitigate risks. It's a much different, what is allowed in a confined setting is much different than what can be allowed in the community.
Those are all the questions I have. Thank you.
Any further cross based upon the redirect?
No, Your Honor.
All right, thank you. You could put the exhibits just up on the counter here. That would be fine. Thank you. You can step down. Thanks for being here.
Thank you.
Judge, at this time I would like to call Kathleen Martinez to offer testimony on Court's Exhibits 1 and 2 as well.
All right, very good. Ms. Martinez, if you'd come forward.
Do you swear that the testimony you're about to give in this matter before the court should be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you. Be seated. Pull up to the microphone. It's the bar with the red light. State your full name and spell your last name.
Kathleen Martinez, Martinez.
Is Kathleen with a C or a K?
K.
K. All right.
Ms. Martinez, where do you work?
Wisconsin Department of Health Services,
What's your role there?
Forensic Mental Health Section Manager.
Where's your office?
My office is 1 West Wilson in Madison, Wisconsin.
Okay. Do you work with someone named Aaron Graff, Graf?
I do. I supervise Aaron.
Okay. Were you involved in the filing that's been discussed at today's hearing regarding the petition to revoke conditional release for Morgan Geyser?
Yes.
Okay. I believe in front of you are Court's Exhibits 1 and 2. Is that true?
Yes.
Okay. Do you recognize both of those items?
Yes.
Looking at Court's Exhibit 2, and just to clarify for the record, were you just in the courtroom during the testimony that was offered by Ms. Whitaker?
Yes.
Okay. Do you know Ms. Whitaker?
Yes.
Okay. Are there portions of Exhibit 2 that you authored as well?
Yes.
Could you please clarify for the court which portions you authored?
The conclusion portion of the letter, page 5, part of page 6. DHS reviewing these documents is standard practice for conditional releases, and we often make edits or final approval before filing these documents.
Okay, so how does WCS relate to DHS when we're talking about someone that's been granted conditional release?
DHS contracts with WCS to provide conditional release case management to any conditional release person in certain counties in Wisconsin, including the southeastern part of the state.
Okay. Does that mean that the person would only work with a WCS case manager and no one from DHS?
Upon release?
Right. Or would they have both?
DHS also contracts with the Department of Corrections to provide supervision. So the individuals that are conditional release work with their WCS or the contracted case manager, the contracted DOC agent, and any other treatment providers or service providers that are indicated in the plan.
Okay. In terms of preparing a conditional release plan, is DHS involved in that?
We review it when it's complete.
Okay. Were you involved in any of the meetings that occurred in regard to the plan for Ms. Geyser?
No.
Okay. At some point in time, did you become involved in the planning for Ms. Geyser?
Yes.
Why?
I received pictures of Facebook posts that were concerning. I received them from Erin Graff that she received from WCS.
Okay. And are those some of the things that have been discussed during Ms. Whitaker's testimony and are detailed in Exhibit 2?
Yes.
Okay. Ultimately, were you able to review the information compiled by Ms. Whitaker in Exhibit 2?
Yes.
When you learned that information, what did you do?
I alerted the department administration because it is a practice to complete high-profile notifications if we believe that there may be attention or media drawn to a specific case, and that's what I did.
Okay. Did you have contact with Winnebago Mental Health Institute about some of these issues that were raised, or risk issues that were raised?
Yes, I did.
Why?
To ask them about their perspective from their from their end.
When you approve a conditional release plan, is it important for DHS to have an understanding of what is in place with the current treatment team at the facility the person is in?
It is.
Why?
Because if somebody is making progress in treatment, we would like to continue it in the community, and when we write conditional release treatment plans, those plans should be informed by the assessed needs and risks that are done by various people in the current treatment team.
Now, would doctors who are court appointed to make evaluations about appropriateness for conditional release be the same as doctors that are in someone's treatment team in a facility?
No.
What's the difference?
The court-appointed doctors are independent examiners, not affiliated with DHS, and meet with conditional released clients or prospective conditional release clients for purposes of offering an opinion about whether the conditional release poses a threat to the individual or community or property. People at the institution treatment team would be people that interact with an individual at whatever frequency they determine is needed to address treatment concerns.
Did you try to ascertain whether information was known to the Winnebago treatment team regarding Ms. Geyser in this case?
Yes.
What specific information were you trying to learn, whether they were aware of?
Had they seen the posts that I had received from around Jeffrey Pagel, including the contents of the postcard and the specific drawing, and if they knew the extent of the content of the current book, Rent Boy?
Why did you want to know that?
Because I would be interested in incorporating their opinion about what interventions would be needed to address any risk associated with those items, or perhaps they might say that they were aware and that they had no concern with it, and so since they're treating her, I was interested in understanding more about that.
Ultimately, was a decision made to file a request to this court to revoke the conditional release as opposed to finalizing and offering a plan?
Yes.
What entity's decision was that?
Department of Health Services.
Okay. And why? Why is that the position of the Department of Health Services?
Because when we asked if the treatment team were aware of the extent of these issues and the content, they said the Winnebago social worker.
I'm going to jump on hearsay grounds.
No, I'll overrule it. I'm satisfied. To some extent, it's offered for the truth of the matter asserted, but it's also offered to it's offered to show what, after receiving the information, what the witness in the department did. So I'll overrule the objection. Witness can answer.
I can answer.
Yes.
The social worker indicated that she had not told the treatment team that the specific details of the posts and the specific details of the drawing and the specific content of the current book, Rent Boy. That was in a meeting with Aaron Graff, Nicole Whitaker, and the WCS case manager, where that. So, to answer your question, so because the treatment team had no knowledge of these, they could not indicate whether they thought it posed a risk or they thought it was great or whatever. They couldn't answer that question because they didn't know about it.
Were there aspects of these concerns that had direct relation to the index offense that caused the department concern?
Yes.
Like what?
The material being horror related is similar to the content of the Slender Man content, and that was similar enough. The material being related to killing people and violence was similar enough to ask a question about risk.
Did the department have concerns about Ms. Geyser's self-reporting tendency to disassociate when stressed?
Yes.
What was that concern?
That in a report by Dr. Lumbaum, there was indication that Ms. Geyser was aware that she sometimes disassociates, and that was what was happening during the index offense when her environment is stressful. And releasing to the community is often includes elevated stress for the individual. And so we were interested in knowing what her treatment team thought about that in relation to her current reading material.
Was the decision to request revocation made before you checked in with her Winnebago treatment team?
No. But we would have liked more time to get more information. That's part of the problem, is that we didn't have the information we needed, and our job is to write a plan that mitigates risk to the community. It's hard to do that if the risk is unknown.
Is the information contained in Exhibit 2 that you authored still true and accurate as you sit here today, as far as you're aware?
As far as I'm aware, yes.
Okay. And is the position of the department continue to be that the court revoke conditional release at this time?
At this time, yes.
And you're aware that one way the department can seek revocation is when rules are violated, right?
That's correct.
Does that apply here?
No.
Why not?
Ms. Geyser did not violate any rules of conditional release.
Right. So then why
I'm aware.
Why is the department seeking revocation at this point then?
It's based on concerns about safety to the community and to Ms. Geyser.
You were in court when State's Exhibit 1 was offered, the drawing, is that true?
Yes.
Is that something that you had seen before?
Yes.
Is that something that you inquired with the Winnebago treatment team prior to filing the request to revoke?
We asked, had they received or aware of any of the posts that were done on Facebook, and they said that the Winnebago social worker indicated that the treatment team was not aware.
What about in terms of, was the treatment team aware or worked with Ms. Geyser on her tendencies to enjoy violent artwork or something like that? Was that something that was known and aware?
I believe that it was, but I don't know that for sure. But I think so, based on the reports submitted by the independent examiners. And so, yes,
okay.
I think so.
So what aspect about the posting was concerning to the department and unaware to the treatment team?
They indicated they weren't aware of any visits. They weren't aware of the fact that he'd indicated sexual arousal based on the index offense. They were aware of the general themes, but not the details of the specific posts or drawings or the particular book.
From what you were able to review, did it appear that there was well, strike that. How do you know that this person, JP, was sexually aroused by the index offense?
I don't know that he was, but Morgan, the Wisconsin, the WCS conditional release team reported that Ms. Geyser told them that he was, and that was why she part of why she asked for the no contact.
And at that point in time, she hadn't had contact with him since June of 2024, right?
It says 2023 in the records. Exhibit 2, paragraph 7.
That was the June of 2023 is the last reported visit. I have no idea when the last contact they had was.
Okay. But from what you were able to gather, her treatment team, she never told her treatment team, hey, I'm writing letters to this person who's sexually aroused that I committed this crime 14 years ago.
Not that level of detail, but I believe they knew about him. You know, they knew his name. I asked if this was, that specifically, the sexual piece has been addressed at all in treatment, and I was told that they weren't aware of it, so.
Are there any other risk concerns that the department has that you think that the court needs to know about?
I'm going to object on notice. I'm going to object on notice grounds. If they file a petition to revoke, they can identify the grounds, which they've done, so that we have notice and can investigate and respond.
Overruled, if the witness has additional information for the benefit of the public and the court, the witness can disclose that.
I would just say that generally the conditional release program places people in the safest environment possible. However, and we have the ability to write rules for people to follow, but obviously those rules are broken, and group homes are not locked. People can leave group homes. People can cut off GPS bracelets. So we try to make the best placement possible, the safest placement possible, and we understand that we have rules, and those aren't necessarily safeguards, but I wouldn't. I guess that's just more general information about conditional release generally, not Ms. Geyser specifically.
That's all I have. Thank you.
Okay. Cross-examination.
Good afternoon.
Good afternoon.
You and I have talked one time before, haven't we?
Yes.
I think you were on a Zoom conference that we had about a week or so ago, right? Right?
Yes, correct.
Okay. So I just want to ask you some questions about what you testified to.
Sure.
It doesn't sound like there was any additional concerns that you had beyond what was expressed in your filing. Do I have that correct?
Yes, I think so. Yep.
Okay. And we all know rules can be broken. You mentioned people, I think you just said people could choose to, a person could cut off their GPS bracelet, right?
Correct.
A person could theoretically leave a group home if they wanted to get out somehow, right?
Yes.
And there's mechanisms in place that when people break rules, there's mechanisms in place to address that, right?
Like, for example, pursuing revocation, or
Sure.
do you mean something?
Yeah, a person could be arrested, right?
Yes, if they were, if we could find them,
Yeah.
they could be arrested, or we could put them in, we could petition the court to, or ask the DOC to place essentially a hold on them if they were willing to come in and
Right.
go to jail or something like that.
Yep. So
We could also adjust treatment if we needed to.
Sure. And so as we sit here today, Morgan has broken 0 rules, right?
As far as I know, yes.
Okay. Well, I only want to know what you know. So
Yep.
she's broken no rules.
Yes.
All right. So she's not facing revocation because she broke any rules.
Correct.
She's now, in fact, you've never even given the judge the conditional release plan for her to go to the group home, right? You pursued revocation first.
Correct.
Okay. And you said, I think I have your words correctly, the sexual piece wasn't addressed in treatment. Are those your words?
Yes.
Morgan has never expressed any sexual interest in her crime.
When I said sexual piece, I'm referring to the current reading material of being sexual sadism, plus her interactions with him around being interested, sexually gratified or aroused by her crime, exploring that in therapy to see whether or not that presents a risk to the community. That's what I meant.
Okay. What I heard you say before was that Morgan broke off contact with Pagel when she found out that he was sexually interested in her crime. That's what I heard you say 5 minutes ago. Right?
Are you asking me?
Yes.
Yes.
Okay. So Morgan,
she rescinded his ability to visit her in person.
Right. Which is what you would want a person to do in her shoes.
Absolutely.
She finds out that the guy is creepy, he has sexual interest in her crime, she cuts off contact.
Revocation is not about punishment or saying.
I'm not asking about. First, ma'am.
Sure.
I just want to ask you very specific questions.
Okay. Sorry.
What you want someone in Morgan's shoes to do is if someone reaches out to her and starts expressing sexual interest in her crime, you want her to cut off contact with that person.
Yes.
That is what she did. Correct?
Correct.
In June of 2023. Right?
June of 2024.
No, June of 2023.
She rescinded the release on June of 2024.
Right, but the last time she had contact with him at the institution was June of 2023.
It was 24 that I rescinded it for that reason in June 24.
Oh, she became aware of it in June of 2024 and then rescinded the contact, right?
I don't know that.
Okay, all we know is that she rescinded it in June of 2024, right?
Correct.
But we know for sure that the last time she had any contact with him in the facility was June of 2023, right?
The last visit he came to Winnebago was in June of 2023.
Okay. Now, have you ever yourself met with Morgan?
No.
Okay. And you are what is your educational background?
I have a bachelor's degree in psychology and a master's degree in social work.
Okay, so you're a LCSW.
APSW, Advanced Practice Social Worker.
So you're a social worker by training, right?
Yes.
And you talked before about Dr. Lundbaum's report, so I'm assuming you yourself have read the doctor reports that were filed about Ms. Geyser, right?
Correct.
Because that's an important part of your job is to read those reports and know what the doctors are aware of, right?
It's not part of my job, but I did in this case.
Okay, why'd you do it in this case?
In order to understand the situation better.
Because of the high-profile nature of it?
No, because of the concern brought to me by the team. Okay.
So with respect to Ms. Geyser's artwork, you're aware of the fact, aren't you, that Dr. Lundbaum that Winnebago itself was aware that Morgan has, part of her therapy is her artwork. You know that, right?
Yes.
In that it's been a method that they've used to help her cope with her trauma, right?
Yes.
In that, in fact, it's been known for quite some time, it was known even to Dr. Lundbaum, that the artwork is disturbing. That's not new information.
No.
And Dr. Lundbaum, despite that and knowing that...
Well, that was a double negative.
Okay. Then let me be precise with it. I think I should ask the question. You know that Ms. Geyser has drawn artwork of a disturbing nature in the past, right? You know that?
I read that, yes.
Okay, you read that in Dr. Lundbaum's report?
Yes.
Okay. Now, with respect to the book, Rent Boy, are you aware of how Ms. Geyser got that book?
I was told that it was mailed to her.
Is that all you know?
Yes.
Okay, someone mailed it to her. Yes. And the reason you know about it is because she said that she read it, right?
Yes.
She brought it up. It wasn't like it was discovered. Right?
I don't know.
Oh, you don't know. Ms. Geyser stated she just finished a book titled Rent Boy by Gary, Indiana, which she stated was about prostitution and black market organ trading. Are you aware of that sentence in the WCS report?
Yes.
Okay. So Ms. Geyser was the one who disclosed that she read the book.
Yes.
Don't we want, as part of DHS, don't you want honesty?
Yes.
So it would be a concern if somebody wasn't honest about reading a book like that, but it's also a concern when they are honest about it.
If the concern was that upon further investigation and looking into the themes of the book, when they asked her about it, her response was, "Oh, I forgot that part," which is also indicated in the memo.
She stated that it was darker and disturbing, right?
I mean, I wasn't in that meeting.
Okay. And really, you don't have any personal familiarity with Ms. Geyser as an individual because you've never met her, right?
Correct.
And when you talked before about the sexual piece that wasn't addressed in treatment, what we're talking about is Jeffrey Pagel, whoever that is, his sexual interest in whatever, right?
And sexual sadism, the combination of that.
That he's interested in sexual sadism and?
No, the book related, the Rent Boy book had themes of sexual sadism.
Right.
So
the concern is, as I understand it, the concern is one book that she read, one book in 11 years, one book.
Okay.
Had some themes of sexual sadism.
Okay.
That's a concern, right?
Yes.
And then there's another concern that someone named Jeffrey Pagel is sexually interested in her crime. That's another concern, right?
The concern is the combination of that, and
right.
Whether or not the treatment team has addressed that and what they think about it. The concern is a question of risk. It's not a determination of risk.
What is there to address about Jeffrey Pagel's sexual desire over a crime that happened? What can Morgan do about Jeffrey Pagel's problems? Other than contact.
I do not believe Morgan has any responsibility to address Jeffrey Pagel's concerns.
Okay, so all the stuff he's posting on the internet about his own behavior, that has nothing to do with Morgan, right?
I don't agree with that because the content of what is posting does have to do with Morgan, but that he's posting is not Morgan's fault or responsibility.
Right. And what would be your role, ma'am, in Morgan's future when she goes to the group home? Do you play a role in her life, or would you play a role in her life?
I oversee the forensic specialists that work at the Department of Health Services that oversee the contract for conditional release case management and supervision.
So when a person is, in other words...
Go ahead, sorry.
So when a person is released to a group home and they have their rules, if they violate the rules, then you oversee the treatment providers who would address that. Is that what you're saying?
Me?
Yeah.
No.
Okay. So really you would play no role in Ms. Geyser's life going forward. You wouldn't be involved in treatment or anything?
Very rarely would I be involved in any conditional release person's day-to-day life.
Did you ever ask Ms. Geyser to provide you with a list of books she's read over the last year?
No.
To see what topics no? Did you ever reach out to this Pagel person to ask him any questions of her?
No.
And you did say before that the treatment team did know about him. You're aware of that, right?
They knew his name. They indicated they did not know about the visits or any other details.
Yeah, so the visits at the facility, right?
Do you have an answer?
Yes, sorry. Yes.
Thank you.
And between the time that the judge ordered So I'm sorry, you're a part of DHS, right?
Yes.
And so it was actually your job to make sure that a conditional release plan gets filed with the court for the judge to either approve or not approve, right?
Personally?
Yeah.
No.
You're not involved in the drafting of that report?
No.
Or that plan, I should
Correct.
say?
No. I mean, yes, you are correct that I am not involved directly in the drafting of that plan.
And Morgan, between the time that judge ordered that plan to be drafted and now, she hasn't done anything violent, right?
No.
And neither to herself or others, right?
I think that's true. I believe Winnebago would have reported that.
Right. If she was doing something violent to herself or others, you'd know about that.
I think so.
And before you put together, when Ms. Nicolai was questioning you about Exhibit 2 that you have in front of you, you are the one who wrote the conclusion section. Was that your testimony?
Yes.
So starting with conclusion and recommendation, did you write all that?
I did.
And you say that Ms. Geyser only provided the information about the book when prompted, but that's because she was asked about it, right? The specific question was asked what she's read recently, and she brought up Rent Book. Is that right?
That refers to the
Rent Boy.
Right. That refers to the detail of the detail of the content of the themes of Rent Boy. But Morgan did bring up the book name itself. That's how WCS knew to Google the contents of it.
Right. And you said in your conclusions that reading horror and murder-related books is not by itself necessarily a risk to the community.
Yes, I did write that.
And you feel that there wasn't full disclosure of the book, is that what, or the contents of the book, right?
Correct.
That's what that comes down to.
That's true. Sorry, can you repeat that question?
You're concerned that there was, in your opinion, a lack of full disclosure about the contents of that book, right?
Yes.
There's no other book she's read that you're raising today as a red flag for the court, right?
Correct.
That's the one.
That's an example, yeah.
Well, that's the only one you're aware of that's the concern, right?
The concern is about, I'm talking about that specific book, so yes.
Okay. You mentioned that in your conclusions that living in the community through conditional release, there is inherently less structure and supervision when compared to a state mental facility, meaning she theoretically has more freedom to leave if she wanted to, right?
Exactly.
And Morgan hasn't tried to escape from Winnebago that you're aware of, right?
No.
And you say that group homes are not locked, typically not staffed by individuals who understand complex mental health problems, and even with GPS, could not guarantee prevention from absconding, right?
Correct.
That's true for everybody. That's nothing unique to Morgan.
Correct.
And that somebody could form a bad relationship that would exacerbate a risk, that's not unique to Morgan. That's anybody.
True.
And that's just something we have to deal with, isn't it? That's part of the nature of somebody going into conditional release, is that it is a gradual process to give that person more freedom, and there will be potentially more things that could happen, right?
That is true. The recommendation was to monitor social contact, social relationships from one of the independent evaluators. So we monitor different things depending on individual needs and risks.
And treatment doesn't stop for a person once they're released from the Winnebago Institute.
No, it doesn't.
In fact, it might change because that person now has a different set of challenges that they have to confront, right?
Yep.
And so part of the job of DHS is just making sure that as part of the contract, if you will, is to make sure that those treatment providers are in place and available to the released person, right?
Yes.
And treatment remains something that if there's a concern about a book, for example, a rule can be put in place that a person not read a particular type of book, right?
A rule could be put in place, that's true.
And then if a person violates that rule, then, as you know, petition to revoke gets filed with the court, right?
Yes.
So if we...
Well, possibly.
Right, it doesn't have to result in revocation. You could choose to do some alternative approach.
If we found out about it, yes.
Right. So, and so the way you work through things is to establish rules, right? Rules get established for a person when they're released.
Yes.
And in this case, no rules have even been really, other than the ones that exist at Winnebago, there's really been no set of rules that's been provided to Morgan to say, here's what you can read and here's what you can't read, right?
I don't know that.
Well,
I have no idea actually of that.
Well, you said before she's not here because she violated any rule. We already established that, right?
Yes.
Meaning,
because there's a standard set of rules.
Right. Meaning there's no rule that prohibits her from reading Rent Boy, for example.
Yes.
There's no rule that prohibits any type of reading against her.
Right. Yes, correct.
She discloses what she's read as part of the release plan, and she gets served with revocation papers. Do I have that right?
Objection argumentative.
No, that's...
No, overruled. It's cross-examination.
Right? That's what happened. She has no rule prohibiting her from reading any genre at all, right?
Correct.
She then reads Rent Boy, that someone sends her, and discloses it, right?
Correct.
And then she's served with revocation paperwork and told she won't be released for 6 months. That's how
the revocation is not based on rule violation.
Based on
safety concerns.
Safety concerns over something she read that wasn't prohibited.
Yes.
Okay, that's all.
Any redirect?
You were asked a lot of questions just now about why the petition to revoke was filed, and those questions seem to suggest the only reason was because of one book that Ms. Geyser read. Is that true?
Yes.
That's the only reason that this...
Oh, sorry. Sorry, go ahead.
Is that the singular only reason that she said, I read this book, and so you said, I'm going to file this petition?
Oh, no. No.
Is it fair to say that it's a much more complex analysis that was done before the determination to file this was made?
Yes.
The discussion that was had regarding this Mr. Pagel person, you agreed with defense counsel that he certainly seems to have some issues, right? And that they're not Ms. Geyser's problem.
That she shouldn't be punished for, right, or responsible for dealing with his issues.
Right. But there's still a concern that the department has, because this is a person that Ms. Geyser decided to have a relationship with for some period of time, right?
That's true, but I would say the crux of the concern is that her current treatment team was not aware of the extent of their relationship, the extent of the content of the post. It's that they might have been aware on some level that he exists, but they weren't aware of the detail. The same with the book. They weren't aware of the extent of the details of the book, and that without their perspective on what that looks like in terms of risk mitigation or treatment intervention, we had no choice other than to file a petition for revocation, because we cannot write a treatment plan that addresses risks that we're not aware of, that we've asked about, and the treatment team said, well, we haven't addressed it because we were not made aware of this level of detail.
And when you talk about level of detail specifically with this Pagel person, did the detail include the fact that some of the content of correspondence Ms. Geyser sent to him?
Yes.
What specifically?
The postcard that indicated a desire to be intimate with him.
Was that information that the Winnebago treatment team had?
No.
Do you think that it's a distinction for the treatment team to be aware of someone's name versus to be aware of a fact like that?
Yes.
Why?
Details that around the specific details around the nature of their relationship could exacerbate risks to the community, and I think it would be important for them to have explored that in order to indicate what current interventions are in place and how we might be able to address that in the community.
If the department became aware that there was someone out there in the world who seemed to be fixated on Ms. Geyser and was sending her things and wanted to come see her, but there was no evidence that she ever reciprocated any communication, would the department have filed revocation papers?
Probably not.
Again, there are some things inherent about this case that are going to be outside of Ms. Geyser's control, right?
Yes.
Are those aspects the reason that the department has filed the motion to revoke here?
This has been asked and answered numerous times about why they filed their petition.
No, overruled.
Can you repeat it? Sorry.
Sure. These aspects of things that are outside of Ms. Geyser's control, just based on the nature of this case, are those the reasons that the department has concerns about risk in this matter?
No.
Okay. Are the concerns about risk specific to Ms. Geyser's actions and behaviors?
Yes.
That's all I have. Thank you.
Further cross.
You said a postcard that Miss Geyser wrote Pagel, where she expressed a desire to be intimate with him, right?
Yes.
One postcard, right?
You're asking, sorry, what is your question?
You're aware of one postcard, one time.
One postcard, yes.
Where she wrote someone who had visited her and said she wanted to be intimate with him.
Yes.
She's an adult woman, right?
Yes.
Wanting to be intimate with someone is not a risk factor, ma'am.
Wanting to be intimate with someone who is sexually aroused by an index offense may be, and that is the question that I had to the treatment team.
And there's no evidence that when she wrote him that postcard saying she wanted to be intimate, that she was aware that he was aroused by the index offense. Agreed? There's no evidence of that. Agreed?
I have no idea.
Okay, thank you. And it was Miss Geyser who cut off contact with Jeffrey Pagel, not the other way around.
Objection asked and answered.
Sustained.
You can't write a treatment plan to control for risks we are unaware of. That's what you said?
Yes.
You can, if to be clear, you can put any, in theory, you can put any rule in place you want. If you want to prohibit Morgan from having contact with someone, that can be a specific rule that gets put into her plan, isn't it?
The treatment plan indicates treatment interventions and is distinct from the rules of supervision for conditional release.
Okay, but it's already, but
yes, we
right?
can put any rule we want, I guess.
And
it would be subject to review by the court, but yes.
Right, because she doesn't get released until the judge reviews the plan, right?
Correct.
So, okay, so when you said treatment plan, you weren't talking about a conditional release plan. That's a separate thing.
The conditional release plan does not indicate the rules of conditional release supervision, but it indicates treatment interventions and also placement, location of placement and that kind of thing.
Got it. Those are all my questions.
Any further direct?
No, thank you.
All right. Thank you, ma'am, for being here. Have a good day.
Thank you.
Thank you.
That's what I was thinking.
indicated that Ms. Groff was present.
She is here, yes.
Is any significance to her testifying?
I was not going to call Ms. Groff, no.
All right, all right. Any further witnesses at this stage?
There is, I'm just trying to find her name, I'm sorry.
You asked for someone to appear by Zoom.
Lisa Portman is on Zoom. She is appearing remotely with the permission of the court.
Are you calling her?
Yes, please.
So is Portman in the Zoom arena?
I believe she was.
Ms. Portman, are you there?
If I wanted to. Yes, I'm here.
Okay, we've got to connect you up to Zoom so we can see you. That may be on your part to connect up the camera.
Sorry, I'm trying to turn on the camera and I'm not quite, it's not, oh, there it is. Okay.
Oh, there we are. Okay. Good afternoon.
Hello.
So I can see you and I can hear you. Can you see and hear the court?
Yes, I can.
All right. Do you, Attorney Nicolai, do you recognize Ms. Portman?
No, I don't.
No. All right. Well, we'll assume you are Ms. Portman then, true?
Yes.
Until further examination. I'm going to ask you to stand if you can. Raise your right hand. Our clerk's going to swear you in.
Do you swear that the testimony you're about to give in this matter before the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you. Please be seated. And then state your full name and spell your last name.
Portman, Portmann.
And what's your first name?
Lisa.
All right, thank you. And where do you work?
I work at Winnebago Mental Health.
All right. And you're currently out of state, true?
I am.
And because you're out of state, the court authorized you to appear by Zoom today.
Thank you.
True? I mean, that's true, correct?
Yes.
All right, very good. Then I'll turn to Attorney Nicolai.
Thank you, Judge. Ms. Portman, do you work with Morgan Geyser at Winnebago?
Yes, I do.
And how, in what way?
I am assigned as an individual therapist to work with her.
Are you aware that the Department of Health Services has filed a petition to revoke conditional release in regard to Ms. Geyser?
I am.
Were you part of any of the conditional release plan meetings at all in regard to Ms. Geyser?
Just one.
Okay, would it have been the initial one with a bigger group involved?
Yes.
Okay. I have some questions specifically about pieces of information that I'm interested in knowing whether Ms. Geyser's treatment team was aware of that I would like to ask you about. The first involves a book. How much work in therapy was done regarding addressing Ms. Geyser's preferred reading material, if any?
Can I express I have some concerns about disclosure?
Yeah, I was going to raise
therapy sessions.
Yeah. Sorry, I was going to address that issue as well.
All right, so we should address it.
Right, I would think that there would have to be a release signed or some sort of waiver for, I think what she's concerned about is testifying to information in therapy that has not been subpoenaed by the state.
So she needs a release to do that.
They would need a release to have.
So what's your client's here, you're here, what's your client's position?
I need to speak with I didn't know they were calling the therapist, so I haven't even discussed that with Ms. Geyser. I would need to speak with Ms. Portman privately, and then I can come back and advise how we want to handle that.
All right, well, that's reasonable. We'll take a recess at this time for about 10 minutes. I think a recess is reasonable.
and then we'll give you an opportunity to do so. Now you'll have to, what we're going to do is we're going to, we have some options available. One is we could clear the courtroom, but for the security, and allow you to confer. We can also permit you to go into one of the visiting rooms, or we can have you stay there or take a break. You stay there.
I was just going to step out and call Miss Portman on a cell phone. If she could give the number to Jessica, I could just call her by phone.
I thought you had to confer with your client.
Well, I need to speak with Miss Portman and Miss Geyser. So I guess with respect to Miss Geyser, I would only speak with her after I've had a chance to speak with the therapist. I don't know what she's going to testify to.
All right, that's reasonable. Do you, we have, that we'll have to, I assume then we're going to have to, we'll take a break, number one. Number two, Ms. Portman's going to have to disconnect from Zoom. I'm assuming she only has one phone with her. And,
yes.
And then that contact can occur. There's no need to broadcast your phone number over the public airways, but you could text it to someone. Have you provided your phone number to Attorney Nicolai?
No.
Have you provided it to the court?
Yeah, I can respond to the email with my phone number that I was sent the subpoena.
Okay, so that would be to Attorney Nicolai. Yeah, let's do that. We'll take it. Let's go. We'll take a break for about 10 minutes. Let's say 10 minutes, and we'll do our best.
And then, Judge, if they're going to converse in here, I'll just have everybody in the gallery go outside and close the door.
How do you want to handle then your conversation with your client?
We'll just go right into private area and talk.
That's a jail area. There's no access on. Those are just cells.
No, I thought there was a communication capability.
Yeah, she can go in that room and I can go in the other room.
Okay, yeah, you do that.
Yeah, so we'll do that.
All right, so we're going to take, let's be in recess to 4 o'clock.
All right. Put you in a room, we just chat.
Yes. Okay, court's in recess.
All right, so this is pretty interesting stuff. So this, hold on. Fast forward through here so we don't get caught up in that. All right, hold on. So this JP has entered the conversation, Jeffrey Pagel. I was on his Facebook page, and he has been he's been interviewed by a couple true crime folks. So apparently, Morgan was sending postcards and letters to JP, saying she wants to be intimate with him, and then she was sending her drawings, which I have a picture here, and then he was selling these drawings. He was selling these drawings on his Facebook page, which I tried to find. They crumble as they crawl. So he was selling these drawings on his Facebook page. And I couldn't find that. I guess that's maybe under Marketplace or something like that. And he was having gratification from her offense. That's pretty interesting. So that's sort of the where we are right now. And and based on all of this, they denied that. Well, it's a petition, right? It's a petition to revoke her conditional release. And then this, I love this, under direct, people could break the rules, and they could cut off their GPS, either monitoring. Like, I just wonder, and then under cross, Mr. Cotton's like, she's broken no rules as of right now. It's just amazing how I'm just fascinated that we're watching this now that we have all this other knowledge of what happened. She's escaped. She got caught, arrested, whatever, brought back. And how does it all play out? Is Mr. Cotton still her attorney? We'll play all of that. We have her body cam of her arrest. We have her being in court. So we'll get to that. So he was selling them, Pammy. He was selling them. Gordon, that's capitalism. That is true. Sorry, let me do this here. That is capitalism. That is true. That's absolutely true. Sharon, she was responding to him, then reports him. What about her correspondence, right? Mike, that picture is enough to keep her where she is forever. I know you guys don't like it. Brian says, who would buy that trash? I actually don't mind it. I mean, I don't know. I mean, it's not, if I didn't know that was coming from Morgan Geyser and that she stabbed Payton 19 times, if I didn't know that, I'd be like, all right, that's pretty interesting. I wouldn't purchase it, but I'd be like, all right. If that was my kid who did that, I'd be like, all right. I personally, I like that kind of stuff in the sense of, the whole Dungeons and Dragons and all that kind of stuff. So I think to me, that's like interesting. But knowing that she, stabbed her friend 19 times, and I'd be like, well, that's definitely a red flag. But just looking at it, on the surface looking at it, I'd be like, okay, you probably let's have a talk. Where's this coming from? But again, if that's for like a movie, if you're an artist and you work for whatever company you work for, and they look at all the horror movies that are out there that have disturbing drawings and stuff, because that's what the character does. So I knew this one guy. He was a visual artist, and he had friends that would do what are they? I want to say evidence, but it's not evidence. Set pieces. They would do set pieces. So if the main character was writing in a diary, and they were writing all these, you've seen the horror movies where they're writing in a diary, or they're drawing pictures on the wall or paintings on the wall. My friend had a friend who did that. So somebody's got to do it, but that's for a movie, right? That's for a movie. That's not for for real life, obviously. Yeah, of course, it's disturbing. Yeah, no, I 100% agree. 100% agree. So it's all about context. If that was for a movie, if she was, this set designer, and this was a horror movie about some kid that was drawing or seeing these visions, then everything would be fine. But it's all about context, right? Linda, okay, you watched the interview with Jeffrey on the Murderabilia. That was one hood. Oh, that was good. Okay, that was good. Okay, I was gonna like, you're calling him a hood? Okay, that one was good. All right. Yeah, there's a couple out there. Yeah, I thought, fantasy drawings of monsters and, things like that. So I would think it would be a fun job too. Drawing fantastical creatures. It doesn't always have to be horror. It could be elves. It could be dwarves. Hobbits. Whatever. It's just drawing fantastical figures and such as that. So anyway, I don't know. It doesn't bother me. I mean, again, knowing what she did, it bothers me. But just looking at it, taken out of that context, I'm like, all right, that's pretty creepy. Pretty creepy. I'd be like, okay, what's going on with that person? But that's all. Stephen King, right. Yeah. Stranger Things, exactly. Yeah, exactly. Yeah, Stephen King wannabe. Yeah, maybe. Maybe. All right, let's continue on. And we have so after we're finished with this hearing, we're going to go to we're going to continue on. She has another hearing apparently, and then her escape, and then her news on that. I got body cam for you guys. News with Charlie. I've got I think a little interview with him, and then after her arrest, she's in court. So we still have a ways to go with the Morgan Geyser, the saga of Morgan Geyser. All right, let's continue on.
The Geyser case. May be seated. Thank you. We're back on the record in the Geyser case, same appearances and case number. We were reviewing the status of Ms. Portman's testimony. Let me ask Attorney Cotton what the status of the situation is.
Yes, Judge, I don't know if you want to do a colloquy with Ms. Geyser, but she would orally give her release for Ms. Portman to speak about their therapy.
All right, Ms. Geyser, you understand that Ms. Portman, your contact with Ms. Portman is subject to rules that make it confidential.
Yes, sir.
So if she talks about it here in court, it's not only between Ms. Portman and me and you and the attorneys, but all the people in the courtroom hear it, and it's the proceedings are can be broadcast and it can be outstanding.
Yes, sir.
And so whatever is said will be out in the public domain, as they say, people will know about it. And sometimes confidential information you don't want out. It's between you and the doctor, you and the professional, you and Ms. Portman.
I give my permission, sir.
You do. You understand you could say no.
I do, sir.
And you talked to your attorney about that?
Yes, sir.
Satisfied with Attorney Cotton's advice?
Yes, sir.
Satisfied with him as your attorney?
Yes, sir.
All right, well, that's fine. Thank you. I'll then authorize that I'm satisfied then, Ms. Portman, that Ms. Geyser has released you from any rules of confidentiality with regard to your testimony today. You can proceed. So we'll go ahead.
Thank you, Judge. Ms. Portman, I'm just going to ask a few pretty specific questions. And to clarify, you would be considered part of Ms. Geyser's treatment team with Winnebago Mental Health Institution, right?
Yeah.
Okay. As part of the treatment team, were you aware that Ms. Geyser enjoyed reading material that had themes involving sexual sadism?
No.
Is that interest something that has ever been worked on in therapy with Ms. Geyser?
Not with me.
Okay. Was the treatment team aware that Ms. Geyser's interest in reading material that had themes of murder and organ selling on the black market was something that was occurring?
I can't speak to what the treatment team knew.
Okay. Did you know these things?
No.
Okay. So that was never addressing the affinity for these types of themed literature. It was not something that you've addressed with Ms. Geyser in therapy?
No.
So if the conditional release planning team wanted to try to mitigate risk in some way and come to you, you would have no insight in terms of treatment that's been done with Ms. Geyser about those topics?
Correct.
Okay. In terms of this individual, Jeffrey Pagels, were you aware of Ms. Geyser's relationship with him?
I've heard his name mentioned before in therapy.
Okay. Was information relayed to you that Ms. Geyser wanted to be sexually intimate with this person?
No.
Was information relayed to you that this person was sexually aroused by Ms. Geyser's index offense?
No.
Were you aware that Ms. Geyser was sending this individual letters or cards?
Yeah, I want to clarify, I did find out recently since the filing of the petition.
Okay.
But prior, yeah.
Okay, so in terms of in a therapeutic clinical setting, these are not things that would have been addressed between you and Ms. Geyser?
Correct.
Okay. What about, has there been work done between you and Ms. Geyser in terms of her affinity for violent or dark artwork?
Ms. Geyser has shared her artwork with me.
Okay, and are you aware that pieces of art that Ms. Geyser drew were sent to this person, Mr. Pagels?
I've since learned that some of her art was sent out.
Were you ever shown artwork that Ms. Geyser did that depicts a decapitated type figure with blood coming out of the neck area? Does that sound like something that you've ever seen?
No.
Does that type of style or material sound consistent with artwork you've seen that Ms. Geyser has shown you?
No.
Is Ms. Geyser's interest in creating that type of artwork something that you've worked on with her in therapy?
No.
One moment. Those are all the questions I have. Thank you.
All right, thank you. Cross-examination.
Good afternoon, Ms. Portman. How long have you been Ms. Geyser's therapist?
About 1 year.
Okay, and you work inside Winnebago Mental Health Facility, right?
Yes, I do.
And you remember testifying at the conditional release hearing a couple of months ago, right?
Yes.
And as Ms. Geyser's therapist, it's your job to provide her with one-on-one and as well as group therapy. Is that correct?
Yes.
And those are two different types of therapy. Group is with other individuals, and then one-on-one is more of a private experience, right?
Yes.
And do you have any concerns as you sit here today over Morgan's behavior in therapy?
No.
Even now, as you sit here right now today, knowing everything you know, are you concerned at all about Morgan's attitude or behavior in therapy?
No.
What about just in general, speaking about Morgan as a person? Are you somehow now alarmed that there's risk factors now that you were unaware of? Is that how you feel?
No.
Okay. So, as I understand it, the judge had ordered a conditional release plan to be put into place, right? You're aware of that after the last hearing?
Yes.
Well, and isn't it true that part of the therapy that you were working on then with Morgan was working with her on that transition to the community?
Yes.
Because that's something that you wanted to have happen for her, right?
Yes.
And in fact, as you sit here today, it's something that you still want to happen for her, right?
Yes.
There's no new red flag that's so alarming to you as a therapist that you think you need more therapy with Morgan at Winnebago, right?
No.
So, and that's knowing this information. The state asked you about Morgan's reading themes. The book we're talking about, this Rent Boy book, you are now aware she read that book, right?
Yes.
Has there ever been a rule of therapy or that she can't read certain material?
No.
Are you aware of is she subject to any such rules that she can't read a particular genre or a particular type of book at Winnebago?
No.
So there's no restrictions, right?
Not that I'm aware of.
And you would agree that you and Morgan have a good relationship, at least you would see it that way, right?
Yes.
And now that is part of the therapy that every time she comes in to meet with you, Morgan talks about the last book she read in the last couple of days, or how do you guys handle her choice of reading material?
If she chooses to share what she's reading, she might share what she's interested in or what she's reading. I don't specifically ask about it.
You've gotten to know her very well over the last year, right?
Yes.
You know that Morgan is a very bright young woman, right?
Yes.
And you know that she's very well read, isn't she?
Yes.
You also know that at Winnebago there's no internet access that she has, right?
Correct.
So she's not on the internet, on Facebook or any other site, interacting with people who are posting stuff, as far as you know, right?
Yes.
And Ms. Geyser is interested in all sorts of reading material, from historical fiction to current fiction to Catcher in the Rye and Van Gogh and all sorts of things. You're aware of that?
Yes.
Because you guys have talked about that as part of your getting to know each other. One way to get to know someone as a therapist is ask them what they're interested in, right?
Yes.
And that's a normal part of therapy, isn't it? That as a therapist, you try to develop a rapport with the person that you're treating.
Yes.
So if somebody that you're treating is really interested in movies, you might want to know, you might talk to them about movies or things like that, right?
Yes.
And have you ever felt like Morgan withholds information from you in this year that you've treated her? Do you feel like you have to pry information out of her in therapy, or would you describe her as somebody who discloses and reports what she does?
Yes, she discloses and reports. She comes in ready to talk regularly.
And I think it's important to cover this topic, ma'am. After reading this book, Rent Boy, that has these concerning themes, or these gory themes, did you notice a regression in Morgan such that you were alarmed that perhaps she had read something disturbing and was now experiencing trauma in therapy, or no?
I have not seen any regression from her since I've been working with her. I don't know when she read the book.
Okay, so in the year you've been working with her, you've not noticed any regression based on anything she's read. Is that what you're saying?
Yes.
Now, a person named Jeff Pagel, who you said you were aware of because his name has been mentioned in therapy before, right?
Yes.
This is not a current person that Ms. Geyser is having contact with, as you understand it, right?
Yes, correct.
His name came up as somebody that she didn't want to have contact with. That's what you recall, isn't it?
Yes.
And it was her bringing up Jeffrey Pagel to you, right?
Yes.
That's how you learn about it in therapy, because Morgan, as the patient, is disclosing something that she's concerned about that she wishes to talk through with you, right?
Yes.
And then you talk through it and figure out whether it's something that requires more discussion or more treatment, right?
Correct.
And have you had ma'am, I don't know if you've had a chance, but have you had a chance to read the petition that was filed to revoke Ms. Geyser's conditional release?
No, I haven't read it.
Okay. And is there anything as you sit here now that causes you to recommend to the court that she needs more institutional therapy?
I don't believe I can make that opinion. I don't, make an opinion on whether or not she's ready to leave or should stay longer.
Okay. Is there a new treatment plan that you think needs to be developed with her because she had some historical contact with Pagel, or because she read this Rent Boy literature?
No.
Nothing.
Correct.
That's all.
Thank you. Cross-examination.
Thank you, Judge.
All right, you should say this is
Redirect.
Right, it's actually redirect. Excuse me.
Ms. Portman, I think that you testified that really there was not a lot of discussion about Ms. Geyser's interest in terms of reading material during therapy. True?
Not a lot, just casual conversation about Van Gogh. We talked about Van Gogh quite a bit.
But Ms. Geyser never offered to you, hey, I'm reading this book and right now the characters are selling human organs on the black market. That was not a casual discussion that you had, right?
Correct.
And you've now testified that that's not a concern. You don't believe that that's concerning, right?
Correct.
You're aware that historically, Ms. Geyser has been fixated on fictional characters, right?
Yes.
And the index offense was directly related to a fictional character named Slender Man. You're aware of that, right?
Yes.
And you're aware that in Ms. Geyser's history, she was also fixated on literary characters, right? From Harry Potter books.
Yes.
And you know that the index offense was, at least for a part of time, reportedly due to adherence of the wishes of those fictional people, right?
I'm not real clear on that remote past. I've really worked with her in the present time. I can speak better to what work she's done in the past year and where she's been at mentally in the past year.
But don't you think that someone with that history, it would be very, very important to monitor what types of fictional characters they are relating to and interested in?
I was more attuned to her mental status, her mental health, how she was presenting, whether she was delusional or psychotic or anxious. We coped with grief and family and relationships in her present environment in the past year.
And you testified that you, for the most part, felt like Ms. Geyser was an accurate reporter with you and appeared stable, right?
Yes.
You're also aware that at a point in time, Ms. Geyser reported that all of the symptomology surrounding her schizophrenia was things she had made up.
I'm sorry, this is so far beyond the scope at this point, Your Honor.
Well, it's beyond the scope of the cross to an extent, but yet we're going into detail on therapy and on contact with Ms. Geyser, so I'll overrule the objection. I think it's necessary to go forward. I find it's within the scope of cross.
Do you need me to restate the question, Ms. Portman?
Please.
You're aware that Ms. Geyser has reported that she feigned symptoms of schizophrenia and never suffered from a mental disease or defect at the time of the index offense.
We talked about that in therapy.
Do you think that it's possible that there's a risk underlying the stability that you see from Ms. Geyser in your therapy with her?
Do I think that there's a risk? Can you restate that?
Sure. Now knowing that Ms. Geyser has an interest in the types of artwork that we've talked about, decapitated figures, and the type of fiction we've talked about, murder and sexual sadism, do you have any concern that the presentation that you're seeing from Ms. Geyser in therapy is not accurately reflecting what's going on?
I don't. I saw somebody who was, who I interpreted as being very authentic and processing authentic emotion and thoughts and relating to her environment and bringing that into the therapy session and processing it. I saw, that's what I saw.
Okay, thank you very much for your time, Ms. Portman. That's all I have.
Any recross?
Yes, briefly. Is there a rule of therapy that she's supposed to bring up every one of the books that she reads and talk to you about it?
No.
Okay. And you've now had a chance to look into the book Rent Boy, and it's not something that raises any concerns to you as her treatment provider, right?
Right.
That's all.
Any further direct?
No, thank you.
Ms. Portman, what is your educational background?
I'm a licensed clinical social worker. I have a master's degree in social work.
And how long have you been working at Winnebago?
15 years or 14 years. 15 years with the state.
So have you been you said you've been a part of Ms. Geyser's treatment team for the last year?
Yes.
Before that, were you involved in other treatment teams involving other individuals at Winnebago?
Yes. Yes.
How many other individuals have you been involved in as a treatment team member with?
Oh, hundreds and hundreds for 15 years, so.
All All right, I have no other questions. Any questions to the witness based upon my questions from the state?
No, thank you.
Attorney Cotton, anything from you?
No.
All right, thank you. And then Ms. Portman, thanks for being here. I appreciate your time. Have a good day.
Thank you. You too.
How should we proceed at this point?
Judge, at this time, I don't have any other testimony or evidence on the state's burden for the petition, and I believe I've moved the only exhibit I marked into evidence, Exhibit 1.
I think you did. We received, we received State's Exhibit 1.
Those were court exhibits, you said, Judge.
Yeah, we have 2 courts exhibits. Are you moving those in?
I would move both reports in.
So I'll receive both. So ordered.
Yeah.
And then, do you want the exhibits, Attorney Cotton?
I was just going to grab them, yeah.
I'll give them to you. How are you then? The state's resting. How do you wish to proceed?
Call Dr. Ken Robbins. He's waiting on Zoom right now.
All right. Do you want these exhibits?
Yeah. Thank you.
Thanks, Judge. Yeah. Excuse me?
I just let him in now.
All right. Dr. Robbins, you're appearing by Zoom. Can you see and hear the court? I cannot hear you, so you're muted.
Can you hear me now?
I can. I can see you and I can hear you. Can you see and hear the court?
I can.
All right, very good. Thank you. I'm going to ask you to stand if you can. Raise your right hand. Our clerk will swear you in.
Okay.
Do you swear that the testimony you're about to give in this matter before the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And you've testified previously in these hearings concerning Ms. Geyser?
I have.
Thank you. Then Attorney Cotton.
Judge, given your familiarity with this doctor, would you take judicial notice of his qualifications?
I will. I'll take judicial notice of the qualifications for Dr. Robbins as well as the other 2 doctors that are to appear if they appear today. So ordered.
Dr. Robbins, good afternoon. Thank you for appearing.
My pleasure.
You are in receipt of the amended or the petition for revocation of conditional release that was provided to you, right?
Correct.
After that was given to you, did you take any action or take any steps?
I did. So I'm in California, so I couldn't go to Winnebago to see Morgan directly in person, but I did have a remote interview with Morgan, and then I spoke with Dr. Kayla Pope, the medical director of Winnebago.
And what, if anything, did you talk to Kayla? You said Kayla Pope, Dr. Pope is the medical director of Winnebago?
Correct.
Why did you speak with her?
I wanted to know, because I was surprised that the report from Ms. Whitaker suggested that the staff who were working with Morgan weren't aware of what was going on with either the books or with this man who had been contacting her, and that wasn't my understanding, so I wanted to find out what the truth was. So I called Dr. Pope to get more information.
And what did you learn the truth was?
I'm sorry, that one didn't come through clearly.
What did you learn when you spoke with Dr. Pope?
Objection, hearsay.
So Dr. Pope told me...
It is, if it's offered for the truth of the matter concerned, as I understand the question, so it is hearsay.
It's to show why he did the things he did, why he took the next steps and pursued the opinion that he ended up concluding.
Well, that's true, but then we don't receive it for the truth of the matter asserted. We receive it for what he heard and what he did in response to what he heard.
Right.
All right, I'll receive it on that basis.
And so thank you, Judge. So, Dr. Robbins, you spoke with Dr. Pope, and what did you learn as you spoke with Dr. Pope?
Dr. Pope told me that the staff were well aware of the books that Morgan had read, including the specific book that Ms. Whitaker mentioned. I think it was, Rent Boy. I'm not sure I have that quite right, but something like that. And that they were well aware of this man, Mr. Pagel, who had visited Morgan. So they were aware of all of this and had discussed it, and were not uncomfortable. Did not feel like any of this put Morgan at increased risk of behaving violently.
Did you have an opportunity to speak with Morgan then?
I did.
Was it by Zoom or by phone?
It was by phone. I'm in a very rural part of California, and Zoom wasn't. I couldn't access Zoom.
And based on your discussions with Ms. Geyser, do you, in your knowledge of what she has read, do you have an opinion about her suitability for conditional release?
Yes, so I was aware of some of the books. I wasn't aware of this particular book, but after talking with Morgan and after doing some search myself about this book and speaking with Dr. Pope, it doesn't change my opinion about her suitability for conditional release.
Why not? Should the court be alarmed that she read a particularly gory book? Does that make her more susceptible to violence, for example?
So I went through, I was sent a list by Morgan and by you as well of the books that Morgan has read over the last year, and the vast majority are not violent books. She's, she reads a wide range, mostly of sort of classic literature. And when I myself looked up this book, Rent Boy, what it was described on the internet was that it was I wrote this down because I wasn't sure I'd remember it. It described it as a hysterical romp through the worlds of contemporary culture and crime. It doesn't advertise it as particularly gory or particularly sexual. It describes it as a comic book, that it's focused on comedy. I don't mean comic book. And I guess I didn't find the description to be alarming. And when I spoke with Morgan, she was very clear that that's not what attracted her to this, not the sex, not the violence. She just found it an interesting discussion of culture and comedy. So no, I think she reads a wide range of books because she has a wide range of interests, and she has such limited access to entertainment that I can imagine she wants to experience a wide range of books and try to understand what's happening in the culture. So no, there was nothing about this that made it sound to me like Morgan is focusing on gore or violence, or that anything about what she's been doing would put her at increased risk for violence.
Thank you. When you read through the list of books that she's read over the last year, some of those books include, for example, she reads the Bible every day. Did you become aware of that?
I did.
And certainly there's violent themes even in the Bible, aren't there?
There are.
She's read the Catcher in the Rye, for example, right?
Correct.
Books about the Vietnam War and about Vincent van Gogh, memoirs about other people, right? So it's a whole wide array, as you said, of books. Isn't that true?
It is a wide array with all different topics, and certainly going through that list doesn't suggest that she's focusing on books about crime or violence.
As you used to be the medical director of the Mendota Mental Health Hospital, weren't you?
That's true.
Isn't it important that, and isn't Winnebago sort of the sister institution? We only have two institutions, Winnebago and Mendota, right?
That's correct.
And does an individual in the institution have any control over the books that people send into them? Do these institutions restrict books from coming in?
Well, to some extent they do. They look to see what the books are. They inspect what comes in. to see if they believe it's suitable. So yes, they do play some role.
Okay, so anything, would be fair to say anything that Morgan reads is something that came through, as far as you know, the proper channels to be sent into Winnebago, and she would read it inside the institution, right?
Objection, foundation for this witness to know that fact.
Sustained.
When you learned about the various books that she read and thought about the conclusions you had offered previously, do you have a different opinion today, or do you think that Ms. Geyser should continue to be released under conditional release?
My opinion hasn't changed. I continue to believe that Ms. Geyser should be released under conditional release.
And knowing what you know about her having contact in person in June of 2023 with Jeffrey Pagel and some of the other information that was contained about him, does that change your opinion?
So I think Morgan is going to unfortunately have to deal with people who are attracted to her because of her criminal history. And I think this is one example, but I think she became aware that that's what he was doing, and she herself recognized that she should be shielded from meeting with someone who had that motivation, and she asked that something be done to prevent him from being able to see her back in June of 2024, and that has continued.
Was that an inappropriate way for Ms. Geyser to address it?
I think that was a perfect way for her to address it.
That's all. Those are all my questions. Thank you.
All right. Thank you. Cross-examination.
Dr. Robbins, I guess I'm a little bit confused by something that you said in response to Attorney Cotton's question. Is Dr. Pope someone that would be considered to be part of Ms. Geyser's treatment team that sits in on her treatment?
So she has been. She was her psychiatrist for quite a long time, and she has continued. She oversees all the clinical care at the institution. So she apparently has sat in on some of the clinical team meetings.
And you indicated that when you spoke to her, that she indicated the information that was filed with the court was just all incorrect about what the treatment team knew.
What she told me was that so there was apparently a social worker who sat in on the interview that Ms. Whitaker had with Morgan, and Ms. Whitaker asked this particular social worker some questions about what the team knew, and that they had not anticipated that there was going to be this kind of give and take, and the social worker was a relatively new social worker and was not knowledgeable about what the team knew and didn't know, and so she had a hard time answering the questions.
And that's what you recall Dr. Pope telling you?
Yes.
Sir, Ms. Whitaker testified today, and she said that she never confirmed with anyone in Morgan's treatment team about these things. That was done by a DHS representative. Does that sound familiar at all?
Yeah, I don't know. I guess all I know is that whoever the representative spoke with, apparently, according to Dr. Pope at least, wasn't as knowledgeable as would have been ideal.
Well, the court also just heard from Ms. Geyser's therapist, who agreed with all of the lack of information that's cited in the report that was filed. She agreed that these are things that the treatment team was unaware of and that hadn't been worked on in treatment.
Yeah, I can only tell you what Dr. Pope told me.
You'd agree with me that it seems like we've got a lot of conflicting information right now for the court, though.
Yeah, that may be true. I don't know that.
Okay. You'd agree with me that historically, Ms. Geyser has had issues becoming fixated on fictional characters.
Yes, in the distant past, that was true.
And so fixated that it led to the index offense.
Yes, I believe that's true.
So don't you think it would be really, really important for someone who's trying to assess risk to the community to know all about what kind of fiction characters Ms. Geyser's interested in?
So believing that fictional characters are real is very different from wanting to know what books she's reading. Yes, I think it would be important to know if she thinks there are current fictional characters that are real, if that's true today. But I don't know that it's critical that they're aware of every book that she reads.
Do you think that the treatment team at Winnebago Mental Health should know that Ms. Geyser enjoys reading about the sale of human organs on the black market?
I'm sorry, that completely misstates the record. She read a book. To say that to make it broad and to suggest to the doctor that she is interested broadly in the concept is far different than reading one book, Your Honor.
Well, this is cross-examination, so I'm going to overrule the objection.
Do you mind repeating that question?
Do you think it would be important for Ms. Geyser's treatment team at Winnebago Mental Health to know that she enjoys reading material with topics about trading human organs on the black market?
So certainly if that were true, I think it would be important for them to know. I don't see evidence that that's true.
Do you think it would be important for Ms. Geyser's treatment team at Winnebago to know that she enjoys reading materials surrounded on themes of murder?
I guess I'd say the same thing. If it were true, I would agree that that would be an important thing to be aware of, but I don't see evidence that that's true.
Have you ever seen evidence that Ms. Geyser enjoys creating artwork that is depicting decapitated figures?
I'm not aware that she enjoys artwork depicting decapitated figures.
Are you aware that Ms. Geyser created such artwork and sent it to someone outside of the facility?
So I am aware that she sent some gory pictures to the man that we talked about. Again, I don't know how much enjoyment she truly got from that. I think some of that was influenced by what he asked her to do.
Do you think it would be important for Ms. Geyser's treatment team to know that she's engaging in creating gory artwork?
I guess if that were a consistent thing and that's what she was focusing on, yes, I think that would be important to know about.
Are you aware that Ms. Geyser was creating dark-themed artwork around the time of the index offense?
I am aware of that.
Do the similarities in these themes not cause you any pause?
If I believed that she was in a similar emotional state, if I believed she got similar reinforcement by doing it, yes, I would be concerned. I don't believe that to be the case, however.
Thank you. That's all I have.
Any further direct?
Yes. Why don't you believe that to be the case?
Based on both talking to Dr. Pope and talking to Morgan herself, she was very clear that she doesn't take pleasure in gore or in violence, that she's trying to experience a full range of what's going on in the universe, and including what's going on in culture. And certainly there's a lot of violence in our culture, and I think that's part of what she's trying to understand and make sense of. But do I think that she takes particular pleasure in violence or in gore? No, I don't see evidence to suggest that.
And you've studied hundreds, if not thousands, of pages of historical records in this case, right?
I have.
And in fact, one thing you examined and read is Dr. Lundbaum's report that she authored in support of conditional release. Do you remember that?
I do.
And in fact, Morgan's artwork was specifically mentioned in that report, wasn't it?
It was.
The fact that Morgan even said, I use my art as a way not to self-harm. I put everything bad in me out in my art and writing so I don't do that. It's a way to cope with my trauma. You remember reading that?
I do.
That's a healthy thing, isn't that?
I think it's a healthy thing. I think Morgan has had very limited ways of expressing herself, of experiencing culture for the last 11 years while she's been institutionalized. And I guess I'm not surprised that part of what she has done is read books about crime and culture and drawn artwork involving crime, culture, and violence. I don't think that suggests that she's about to become violent.
Right. The state introduced, so you know, Dr. Robbins, today, the state introduced one photo, one drawing that Morgan did of some sort. Can we show this exhibit to the witness, Your Honor? Exhibit 1.
It's in a Zoom. You can share it over Zoom.
Okay. She drew one drawing with what appears to be not even a person, but some sort of thing with its head cut off, okay? One drawing they've introduced. Does that give you any cause for alarm that she did one drawing like that?
It does not.
And when Ms. Geyser, and this is something you've known, even before you authored your original conditional release report, you knew about her artwork, didn't you?
I did.
Because she said and Morgan has said that her artwork, sometimes it's dark, right?
She does.
And she's in trauma therapy. That's part of her therapy, isn't it?
It is, and she's around, many perpetrators, many people who've committed crimes. That's really her social group, and that's what she's hearing about.
Right. What's important is whether there's any indication. Would it be important to talk to Ms. Geyser's therapist at Winnebago and hear the therapist's opinions? Would those matter, do you believe?
Yes, I think that would matter.
And if the therapist testified that she sees no additional need to continue providing any new therapy at Winnebago as a result of this. She's not concerned about it in the least. Okay?
Okay.
Does that surprise you, or do you differ in that opinion?
I don't differ, and it's consistent with what Dr. Pope said to me.
Thank you.
Any further cross?
No, thank you.
All right. Well, doctor, thank you for being available today. You have a good day.
Thank you. You as well.
Have a good afternoon.
Thank you.
Thank you.
Further witnesses?
Defense rests.
How about Dr. Collins? Is she here?
I think you have both of the doctors available by Zoom if you care to.
Okay, but the defense rests.
Yes.
Okay. Well, I'd like to hear from the other two doctors.
Okay.
So I'll call Dr. Collins as a court witness. Dr. Collins, you're appearing by Zoom?
Yes.
I can see you and hear you. Can you see and hear the court?
Yes.
All right. I'm going to ask you to stand and raise your right hand, and our clerk will swear you in.
Raise your right hand, please. Do you swear that the testimony you're about to give in this matter before the court should be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. Thank you. Please be seated. State your full name and spell your last name.
Deborah Collins. DeborahCollins.
All right. Thank you. Okay. Who wishes to ask questions of Dr. Collins initially?
I think procedurally it should be the court. You chose to call her and the parties have rested.
Well, I'd like one of the attorneys to do it. Is there an objection to the court asking the questions from the state?
No.
All right. Objection from the defense?
No.
All right. Dr. Collins, you're familiar with Morgan Geyser?
Yes.
And you wrote a report previously that was dated December 9, 2024 with regard to her conditional release.
Yes.
You're aware of the petition that was filed to
revoke the conditional release order of the court?
Yes.
Have you been, you've been part of the court proceeding that you've heard the other witnesses who testified?
Yes.
Do you have an opinion as to the risk involved, the dangers involved with what's been disclosed in the petition for revocation of the conditional release that affects the court's decision on conditional release?
Well, I certainly recognize conflicting information that's been presented to the court and contained in the petition for revocation. It doesn't cause me to undo the analysis or opinion set forth in my report.
Okay, why is that?
Because in large part, the information that's been provided isn't new. It's been known. The reading material that Ms. Geyser has access to or seeks out is known at Winnebago. Now, whether or not someone reads the books that Ms. Geyser reads is unknown. But there's nothing about what I've learned since knowing that the state was attempting to revoke Ms. Geyser's petition that would suggest to me that she now suddenly poses a significant risk of bodily harm to herself, others, or serious property damage if conditionally released, with all the supports, accountability, supervision that entails.
All right, thank you. Any questions for Dr. Collins from the state?
Dr. Collins, was there information that you heard that causes you concerns today or in the report you reviewed?
Certainly at first blush, hearing that the accusation that someone is obsessed with gore, it gives one pause. When I explored that with Ms. Geyser, when I met with her for a follow-up interview virtually on Monday, when I talked to her social worker, when I look at the records that I have and hear the testimony, I don't see that to be true. I don't find it to be credible, given what others close to Ms. Geyser, who have known her best during the past year, how they describe her or characterize her in the clinical records.
Have you requested additional records from Winnebago since you last did a review of records for Ms. Geyser?
Yes, I did. My office requested earlier this week her available clinical records that have accrued since I met with her in November to the present. I've not received those records.
Okay. Have you had the opportunity to speak with Dr. Pope, for example, from Winnebago at all?
I did not speak with Dr. Pope, though I did conduct a collateral interview with Ms. Geyser's current social worker, also via video conference.
Did that interview offer any insight into kind of what has become this question of what was known and unknown to the treatment team?
What I learned is that the petition for revocation, the best I could gather, took the treatment team by surprise. That they had wished that some of the concerns that the half-hour weekly virtual meetings with Ms. Geyser in anticipation of conditional release had been brought back to Ms. Geyser so that she could explain or put context on things that had come up. But I learned that it's largely a surprise to staff, as best I could tell. Ms. Geyser herself mentioned that I think she had witnessed at least 4 Winnebago Mental Health Institute staff members become tearful about learning about the revocation of her petition and the curtailing of her rights and privileges currently because of it at Winnebago.
In terms of specifically And you testified that you have been able to hear the hearing that's been going on all afternoon. Is that true?
Yes.
Okay. There seems to be some conflict between the testimony Dr. Robbins offered and the testimony that was offered by Lisa Portman in terms of the treatment team's awareness of some of these risk factors. If you'll recall, Dr. Robbins testified, well, Dr. Pope said the treatment team was aware of all of these things listed in the petition, whereas Ms. Lisa Portman testified, no, I'm her therapist, I wasn't aware of that, we didn't work on that. Did your discussion with that member of the treatment team clarify any of those issues?
No, and I frankly can't, I simply am befuddled by the apparent differences or the clear differences in the testimony offered. I just don't know the answer.
Okay. Thank you. That's all I have, Doctor.
Attorney Cotton, any questions?
So you've not changed your conclusions from your report filed December 30th, right, Dr. Collins?
No, the information that I've learned has not caused me to alter either the analysis or conclusions in that report, although I would acknowledge the practical problem that the court now faces, or challenge the court now faces.
Right, the practical problem being that the treatment team, rather than go to Morgan and work on this for a bit of time and get her side of it, it's immediately sought revocation, and that's what you're referring to.
In part, that's what I'm referring to. The other part is that now, at least as presently stands, pending the outcome of the court's decisions, that the treatment team moving forward, if Ms. Geyser is granted conditional release, has expressed concerns about how they would do that safely. That, however, doesn't cause me to change, the data that I have doesn't cause me to change my opinion about her amenability for conditional release, her accessibility to supervision and accountability, her expressed willingness to comply with any and all terms, albeit with some emotional upset as she learns that moving forward she'll have less liberty than she, at least initially, than she does in the institution.
And you touched on that too, Dr. Collins. She actually, Morgan, it sounds like, has suffered some consequences now at the institution for this. Is that right?
Yes.
Even though she didn't do anything wrong.
Correct.
Didn't break a rule, didn't do anything wrong, but she's now had some of her privileges rescinded because they're seeking revocation. Is that right?
I think most of them are now all on hold.
And it moved at least 4 people to tears, the idea that she wouldn't be allowed to be released, potentially.
According to Ms. Geyser.
Okay, that's all.
Any further questions from the state?
Just very narrowly, Doctor, you mentioned that overall your opinion about Ms. Geyser's willingness to comply with the terms of release hasn't changed. And I just wanted to ask you about the testimony that you heard from Ms. Whitaker in terms of there seemed to be some pretty extreme pushback of the idea that the conditional release team would be monitoring Ms. Geyser's reading material. Is that something that you discussed with Ms. Geyser at all?
Yes.
And did there appear to be more willingness to comply with that rule, that reality, that is going to be part of the monitoring?
Yes. What Ms. Geyser said is that while she did express dismay, upset, was tearful when she learned that for the first time in 11 years, her access to reading material, choices about what she read could be curtailed, she said that while she was upset, she never said she wouldn't comply with that.
Okay, thank you. That was all the questions I had.
Attorney Cotton, anything further?
No.
All right, thank you. And Dr. Collins, thank you for being available today. That's all. I have no further questions for you. Thank you. Then, is Dr. Lundholm still available?
She's still on.
All right.
Dr. Lundholm, are you able to see and hear the court?
I can.
Okay, well, I can see and hear you. I'm going to ask you to stand, raise your right hand, and I'll ask our clerk to swear you in.
Do you swear that the testimony you are about to give in this matter before the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you. Now, you're familiar with Morgan Geyser?
Yes.
You've written other reports concerning her situation, true?
Correct.
Your most recent report is a report that was dated December 30, 2024, true?
True.
Are you aware of the petition that was filed for revocation of the conditional release order that the court granted previously?
Yes, both the amended and then the original.
All right, thank you. Now, you've been connected by Zoom to the hearing this afternoon.
Correct.
So you've heard the testimony of the various witnesses that have occurred.
I have.
Have you had contact with Ms. Geyser with regard to the issues today?
I did. I had an opportunity to speak to Ms. Geyser via Zoom Pro video conferencing that took place on, I believe it was Tuesday of this week.
All right, thank you. In the report, do you recall what your conclusion was in your report from December 30 of 2024?
I do.
And what was that?
I offered support for her petition for conditional release, specifically that I did not believe that she posed a significant risk of bodily harm to self, others, or to property.
Is what you've read in the petition for revocation of the conditional release and from the various witnesses who testified today, has that opinion changed?
I would say that with the conversation that I had with Ms. Geyser, in addition to the testimony here today, as well as I did have the opportunity to review her contemporary institutional records, as well as had collateral contacts with a variety of different folks, both through the Winnebago Mental Health Institute, as well as through Department of Health Services and Wisconsin Community Services. After reviewing the entirety of the available data, my opinion has not changed.
So from what you've said, then you've seen Winnebago records with regard to Ms. Geyser that were developed after your initial meetings with her in 2024 up through most recently.
Correct. I had asked for and received her institutional records that have been generated since December of 2024, which is my last contact with her.
All right. Thank you. Okay, I have no other questions. State have questions?
Dr. Lundbaum, you indicated that you were able to review the updated Winnebago mental health records. You also indicated you spoke with some staff at Winnebago. Would that be people from Ms. Geyser's treatment team?
So I had the opportunity to speak to her current social worker, as well as I had the opportunity to speak to administrative staff, both the Winnebago director, Jesse Andrews, as well as the deputy director, Maria Kunin.
I guess I have some similar questions for you as I did for Dr. Collins, just given that there's some disparity in the information that's been presented to the court. Do you have any clarity in terms of whether the treatment team for Ms. Geyser knew about these topics of information or was unaware about these topics of information that are listed in the petition to revoke? Because the court's heard kind of two different things today, and I'm just wondering if you have any insight into that based on your discussions with the director.
So as I understand it, there
the people working with Miss Geyser on a day-to-day basis in general were aware that she has read horror theme books over time. Maybe not necessarily specifically the book that has come up during the course of the conditional release planning process and the ins and outs of what that book entailed. But they have expressed some familiarity with the fact that she's read different kinds of horror theme books over the course of several years. The information that I had also suggests that they were generally aware of the relationship with that particular individual. It obviously has been discussed in my previous evaluations to the court and have raised concerns about not just him, but other people that place potentially Miss Geyser in and of herself at a higher risk for exploitation or manipulation. And I have specifically recommended that the people working with her remain close, in close attention to those particular folks, and it warrants ongoing consideration and monitoring to ensure that she's essentially not preyed upon.
Is there a difference between the staff that are with, attending to Ms. Geyser on a daily or semi-daily basis versus what has been referred to today as her treatment team at Winnebago?
So there are treatment professionals that would include her psychiatrist, social worker, Ms. Portman, who we heard from here today. There's also line staff that work with her on the day-to-day that aren't necessarily a part of that treatment team, but they do work with her closely. Then there's administrative staff, and I will be honest, I did not speak to them in particular about her adjustment, but rather I had questions about essentially policies and procedures at Winnebago and wanted some clarity from some of the questions that these allegations brought forward.
Those are all the questions I have. Thank you.
All right. Thank you. Questions from Attorney Cotton? All right. Thank you. Dr. Lundbaum, I have no further questions for you. Thank you for appearing today and being available. You have a good day.
Thank you.
All right. Thank you. Does the state have any other witnesses or evidence to offer?
No, thank you, Judge.
Does the defense have any other witnesses or evidence to offer?
No.
All right, then all evidence is closed. Then I'll hear arguments.
Thank you, Judge. The state obviously bears the burden here today. We are in support of the petition that was filed to revoke conditional release at this time. Pursuant to Wisconsin statute section 971.17, subsection 3, subsection E. As we discussed at the last hearing, this court needs to consider, in this case specifically, because there's not been a plan created yet, there's no conditional release rules that Ms. Geyser could have violated already. And so when looking at the statute, sub 3, sub C, the authority under which the department has filed this petition I'm sorry, give me one moment. The authority under which the department filed the petition is not specific to a rule violation. It's the other piece of the clause of that sentence. If the Department of Health Services alleges that a released person has violated any condition or rule, or that the safety of the person or others requires that conditional release be revoked, and then it continues on. They may be taken into custody, file a petition showing probable cause, and a petition to revoke. So the piece of this statute that we're operating under is that the safety of the person or others requires that conditional release be revoked. that's the basis under which the department filed the petition. That's the basis under which the state is asking you to revoke conditional release today. I'm relying primarily on the petition, but also on the testimony that was offered today. I think that there are unknown risks, as was indicated by Ms. Martinez, that cannot adequately be prepared for. And when you have the units that are tasked with supervising these individuals telling you they don't feel that they can adequately supervise this person, that must give the court pause. And then I think you need to dive into why those entities are saying these things. And frankly, Judge, the similarities between the concerning items detailed in the petition and testified about today and entered into evidence are very, very concerning to the state because of the similarities to the index offense. The issue of the fiction material that Ms. Geyser chooses to be reading on its face in some cases may not be an issue at all, but the problem the department sees with it here is that she wasn't completely forthcoming about it, and this affinity toward this type of material wasn't something that had been addressed with the treatment team in a way that they could rely on that treatment team to adequately assess the risk and create a plan that addressed it. Similarly, this artwork that I submit to the court, no one was aware that Ms. Geyser had an affinity for, that I've entered into evidence, is extremely concerning, not only given its graphic nature, but given what we know about the index offense and what was occurring around the index offense. The state has real concerns that these things are just, frankly, red flags at this point, and that more time is needed for these issues to be addressed in Winnebago with the treatment team, so that when conditional release is appropriate, the team can prepare a plan that will adequately protect the community. And so that's why I'm in support of the petition, and that's why we're asking that you grant the petition to revoke conditional release. And that's all the argument that I have. Thank you.
All right, thank you. Appreciate the statements. And I'll turn to Attorney Cotton.
You know, Judge, we were here in January 9th of 2025, and I remember it like it was yesterday because we had the same three doctors testify, Doctors Lundbaum, Collins, and Robbins, which the state, for some reason, doesn't mention whatsoever today. And all three of those doctors testified that Ms. Geyser fits the criteria for somebody as a person who should be conditionally released. And what I heard the court order was within 60 days that a conditional release plan would be presented to this court so that you could review it and make some decisions about what is or isn't appropriate in terms of a group home, electronic monitoring, no contact orders, and other such provisions. And we're almost 60 days out from that. What DHS did in response to your order was to serve the court with a petition to revoke conditional release. That's how they chose to handle it. They didn't talk to any of the three doctors who just testified today that none of this changes their analysis. They jumped the ship. They jumped the gun. They went right to revocation. Why did they do that? One can only guess. What they should have done is what you ordered. They should have given you the plan for her release, and we should be here right now talking about that. We should have been here on Monday talking about that. There's no scenario where the state has met its burden to prove that Ms. Geyser, who has violated no rule at all, or done anything other than answer the questions that are posed of her, that now she sits here today more dangerous than she was back in January when we were here, Your Honor. The reason you appoint doctors Lundbaum, and these aren't any doctors that we've chosen in this case, Your Honor. These are people with extended familiarity with Ms. Geyser, people who have worked with her, unlike the people we just heard from today, who meet her now, for the Ms. Martinez, who never met her, and comes in here and says she should be revoked. These doctors have known Ms. Geyser for years. They've evaluated her, they've watched her progress, they've seen how she's progressed, they've seen the strides that she's taken. All of them after years, support her release into the community and continue to do so even in the face of these two things, which I agree with Dr. Collins, Your Honor. On first blush, you look at it and maybe you think, well, is there something to be concerned about here? I'm glad when we were here a few days ago that you did exactly what you did and you said, I want the doctors to review the amended petition and offer their opinions. I didn't even know, frankly, what Dr. Collins or Lumbaum would say. But I wasn't particularly surprised to hear that it doesn't change their analysis, because even Ms. Geyser's therapist, who the state called, they called her therapist, Lisa Portman, even Ms. Portman doesn't see any reason here to continue keeping Morgan in custody to work through anything else. The time has passed for the plan to be brought to this court. We have a narrow a situation here where that ought to have been done already, frankly. Morgan is not more dangerous today. She has not done anything other than work with the release planning group on her release. That's the only thing that she's done, is answer every question asked of her. She didn't secretly read something she wasn't supposed to. She didn't lie about something she read. She didn't lie about contacts with people in the community. And it's almost a perverted situation where she's being punished for her answering the questions that are asked of her. Now she has less liberty. Now she's brought back for a revocation hearing. And the same arguments that are being made by the state about unknown variables. That's what they told you back in January, and you rejected that. There's always unknown variables. This was the central argument that's been made. We don't know if Morgan's released what the future will look like. You addressed that squarely back in January, and what you said, Judge, was that that's true. There's unknown variables in this world, but that's why the plan gets presented to you and you evaluate it and you decide whether that plan is appropriate. There is a group home, as I understand it, it's been testified to today, that is ready to accept Morgan. This is wrong, what they are doing. This is wrong what DHS has done. It's not right. There's not anything that Morgan did. She wasn't violent. She didn't self-harm. She didn't lie about anything. And to really rake her through the mud in these proceedings and bring up the fact that somebody who's been in for 11 years, who's never had any restriction on her reading material, that somehow because she cried when confronted with the fact that it was going to be reviewed, that's somehow a red flag. Really, all of this is just sort of a hit job against her, and an unfair one at that, Your Honor. I think you should rely on the three doctors. I think that's what this comes down to. Three clinical experts who have years of history with Morgan, who have reviewed hundreds and thousands and thousands of pages of records, that know her history, that know the offense, that understand the dynamic that happened back when Morgan was 11 and 12, that understand the trauma that she endured as a child. Those people coming here today and telling you nothing is different now. She is not, our opinions are unchanged. That's all you need. And I would hope that you order them to get the plan here. I wouldn't say within 60 days. Frankly, they've had enough time to get the plan together. It ought to be here before you leave the bench. Thank you.
All right, thank you. Then any rebuttal argument from the state?
No, thank you, Judge.
All right, thank you. While it's important, as Attorney Nicolai pointed out, to look to the statute to begin with, that's what sets the really the parameters and the environment of what the court's rulings are today. So in Section 971.17 addresses the not guilty by reason of mental disease or defect pleas and how they're handled. The court initially found, based upon a stipulation of the parties to the various reports that were filed, that Ms. Geyser was not guilty by reason of mental disease or defect. And then I entered a commitment order for a long period of time. I think it's 40 years. During that period of commitment, however, Ms. Geyser and other people in her position have a right to ask for a conditional release every 6 months. It happens all of the time. She didn't ask for conditional release for a period of time, but she's asked for several. 2 were denied. Now the court granted the third one. So that's what brings us here today. The conditional release, at least to those who are neophytes in the area and inexperienced in what all of this means. It sounds like, oh, she's out on the street and she's out on her way. That's not what it is. There's substantial supervision placed over the person on supervised release, as was testified today. Supervised release that is in many ways more strict from the rules and restrictions on the person than it would be when she was at the institution from the standpoint of freedom within the confines of the institution. But going to so that's what we're talking about now. What happens? I'd authorize conditional release and ask the state to prepare, or the institution, the department, to prepare a plan for release, which should go in to set the stage for the parameters of rules, regulations, and where she would live and how it would be, how she should conduct herself. So what the rule says then, going to section 971.17, sub 3, sub E, in pertinent part. Now, I should also add that at the last time we were in court, the court did an analysis of the status of the case and the procedural status of the case. And that was on February 28th. So at that point, I determined, from my view of the statutes, is that the classic petition for release, or rather the classic petition to revoke a conditional release order, is done after the person's been on conditional release and the plan is in place. And we've talked about that for rule violations. In this case, the statute also provides for the state to bring, or the institution to bring, a claim for revocation of conditional release based upon safety issues. So what the statute says in the sub E, in pertinent part, if the Department of Health Services alleges that a released person has violated any condition or rule, or that the safety of the person or others requires that conditional release to be revoked, he or she may be taken into custody under the rules of the department. The department shall submit a statement showing probable cause of the detention and a petition to revoke the order for a conditional release to the committing court. That's where we are today. Now, what's important to note yet, that the final conditional release document hasn't been signed or approved. That's the plan. Right before the plan, I ruled, and at the February 28th hearing, that although it doesn't quite fit with the classic position, it's something that the court should consider. The safety issue is so important to the court and to the community that the court decided to hear the case and hear the petition. Attorney Cotton alleged that because the very technical routing of the case had not occurred, that the court shouldn't even consider the petition. So then the statute goes on. The court shall hear the petition within 30 days unless the hearing or timeline is waived by the detained person. The state has the burden of proving by clear and convincing evidence that any rule or condition of release has been violated, or that the safety of the person or others requires that conditional release be revoked. So we're really at that safety provision, that last clause, that the state proved by clear and convincing evidence that the safety of the person or others requires the conditional release that then be revoked. That's where we are today. Now, today, I heard testimony from a number of individuals, from the individuals who were involved in submitting the petition to the court with regard to the various allegations. The court heard from the therapist that has dealt with Miss Geyser for last year, but herself has had worked at Winnebago for 15 years, and I think she said she's had hundreds of people that she's been a therapist for. So she's experienced. What's important, and when any of these individuals testify, is that they not do it out of they testify not out of a book or some formula that they read, but they actually have experience in addressing these particular issues and how the court should address it and how society should look at what's happening. So I'm satisfied that with Ms. Portman's testimony, that she testified as an experienced therapist addressing the needs of the public and the needs of certainly of Ms. Geyser, and what the institution's reaction to the allegations in the petition were. I'm satisfied from what Ms. Portman testified to that there was no reason to stop the process on conditional release and to go forward with the conditional release program and to have the plan developed. What I looked for in the testimony was, did Ms. Geyser lie? Was there subterfuge? Was there manipulation? Was there game playing? People we're always told that Ms. Geyser is smart and intelligent. Intelligent people have the ability to game play, to play the system, if you will. Even in tense situations, they understand how to proceed. And they know they have developed techniques and strategies to manipulate those people that supervise them and watch them. Now, none of that came out today, that any of those circumstances exist. So I'm satisfied Ms. Geyser's communication with people in the institution and who she talked to about the conditional release team to was truthful and accurate. She reacted to questions that she was asked. I saw no hidden agenda on her part, no lying, no misrepresentation. That's important from the court standpoint. With regard to much has been said about books, the nature of the book, no one testified about what the book was really like except for Dr. Robbins. I was somewhat taken aback when he said it was a humorous book. I don't know whether it is or not. I'm assuming people on the supervised release team had looked at it and knew what it was. But he basically put the book in context. Nobody challenged that context. With regard to the contact with Mr. Pagel, which is a matter to be concerned with. First and foremost, nobody disagrees that based upon the nature of the case, the nature of Ms. Geyser's involvement in the case, that she's going to be subject to, if you will, public scrutiny, the public notoriety, public curiosity, and there are people out there who obsess over cases such as this. I don't know whether Mr. Pagel necessarily is that, but there are people out there that will take advantage of the system for their own purposes. There is nothing in the information that we have brought forward that when Ms. Geyser developed a sense of what the person was really about, she stopped contact. There's nothing in the record that shows that she did anything to encourage the person beyond sending him some pictures and doing things like that, which she probably shouldn't have done. But I don't see that in and of itself as a reason to find that she's at risk for herself or at risk to harm the community in a conditional release plan. We can't stop other people from contacting her, from doing things that they shouldn't do. But what we can do is regulate and monitor Ms. Geyser so she doesn't encourage that. Now, there's nobody testified today that she encouraged any of this stuff. Now, she was participating, she communicated with him, she saw him, but that doesn't mean that she encouraged it or did anything to place her in an unsafe position. Now, I have to rely upon what's testified to. I don't have other information. I can make assumptions and draw inferences, but I need a basis to draw inferences. I don't see anything out there to draw any inferences that other than what's been presented. The picture is clear, it's transparent. I don't see the risk to the public. I don't see the risk to her in what other people do. Now, there's another twist to that, of course. If there was evidence that she called Mr. Pagel or communicated with him and said, come on, sneak in, get this stuff in, and we're going to get together, that's a different story. The postcard that talked about the intimate contact was, I can't I can't comment on it other than the court recognizes, as one of the witnesses talked about, that what happens when somebody's in their 20s and they have sexual interests. But I don't see that the sexual interest went beyond just that, and it was stopped by Ms. Geyser. What do I do with that? I'm reminded of a TV commercial years ago that had a little lady going up to a hamburger counter and saying, "Where's the beef?" You know, we can laugh and smile about that, but there has to be substance to it. Supposition, accusation has to be followed by proof that convinces the court, according to the statute, by clear and convincing evidence that she's a safety risk, a risk to herself or the risk to the public or to property. I don't see that in any of the testimony that's been offered in support of the petition to revoke. I'm satisfied that, as terrible as the facts of this case are that brought Ms. Geyser in the court, I'm satisfied that under the statutes, she's followed the statutes. People may not like the fact that the conditional release is available, but it's there. And if somebody meets the statutory criteria, then conditional release is appropriate. The court followed the statute, did it initially on January 9th. It does so again today. I look for the proof. Proof is in the pudding, and these other little cliches one can talk about. But that's what the court has to look to. I see no lying, no subterfuge. I see no risks brought forward. Everything seems to be in order. Ms. Geyser appears to be rule-abiding. If somebody tells her not to do something, it appears from the testimony throughout the entire case, including at the hearing in January, that she follows the rules. Now, that's good. That's what we want people to do. People don't always like the rules that they are told to follow. Sometimes people get upset and they yell about it and they scream. They may cry, but they still follow the rules. It's when people don't follow the rules and they lie about it and then they go and sneak behind your back and do something different. That's where the concern is. I don't see that in this case. It hasn't been established. So I'm satisfied that the state has not met its burden by clear and convincing evidence to show that Ms. Geyser is a risk of safety to herself, danger to herself, or danger to others, or danger to property. On that basis, I'll deny the petition to revoke the conditional release. I will dismiss it so ordered. Now, I'm going to order that the conditional release plan be filed. The question is, when can it be filed? Now, I should be the judge that hears it because of all the anecdotal knowledge that I have about the case. But I have certain limits involved. So my limits are to do it, I have two limits. One is to do it before March 21st. The other limit is there have to be a waiver of time limits. And I do it on either April 25th or April 28th. So I need to know what the time frame is for the department.
We'll defer to whatever I don't have an answer. I think the state is trying to figure that out right now.
Judge, I had an opportunity to speak with the members of the team that are here, and they would certainly try to have it prepared before the 21st. They're just not sure if that would be possible. Would it be possible to perhaps schedule 2 dates, and then as soon as the plan was ready, they would certainly file it, but I could let the court know whether we could have the review hearing on that March 21st date or not?
Well, to have it on March 21st, which is 2 weeks from tomorrow, we'd have to have the conditional release plan filed probably by the 18th or 19th. There'd have to be time for the court to read it and digest it, as well as for the parties to do so.
I mean, the team's committed to trying to accomplish that.
Well, what we'll do is we'll set it for the hearing in the morning of the 21st. We'll have to move some cases, other files that I have, but we'll set it at 9 o'clock on the 21st. We'll schedule it for an hour at that time. I'll anticipate on that basis that the report would be filed on by the close of business on Tuesday, March 18th. So it's a Tuesday. There'd be Wednesday and Thursday for everyone to read and digest the conditional release plan, and then to go forward with the hearing. If that doesn't work, the court will schedule the matter for 9 o'clock on April 28th.
Could we schedule it on the 21st for 9:30 instead of 9?
Yes, make it 9:30 on the 21st of March. So ordered. If I'm told the report, and we want the conditional release plan to be from a procedural substance standpoint, to be a good plan. If there's people are rushing it, that's not a good idea. And I want it to be done well. And so if it can't be done, I acknowledge the time frame. And so then if there's no objection from Ms. Geyser, we go to the April 28th date.
Well, we'll see what the report looks like.
Well, we'll see if it's here.
Right.
I agree. If it's filed on the 8th by the close of business on the 18th, we'll go forward on the 21st.
Okay.
I trust they'll get it done.
Then that's the order. The court so ordered. I did one aspect that I didn't mention in ruling with regard to the petition was it was significant that the 3 doctors who testified in the case and had recommended or had not objected to the conditional release going forward testified again today that what they saw in the petition for revocation didn't change their view. The court can listen to experts. The court doesn't have to rely on any experts. But in this situation, each of those doctors have participated in this case from almost the beginning and gave opinions when the court made its first rulings with regard to the case and found the Ms. Geyser not guilty by reason of mental disease or defect, and then went and used them, and they've testified in they've presented reports in all the other petitions for release. So they're knowledgeable, they're credible, they understand, from my point of view, they understand Ms. Geyser's psyche and background, and in particular on the issue of subterfuge and manipulation. I'm relying upon them, and I'm satisfied it's good reliance that they did not detect subterfuge and manipulation, which is important. And that certainly weighed in my decision-making process. So ordered. With that, then we've set the pattern and set the schedule. Thanks everybody for being here. I appreciate the short notice involved in this hearing. Appreciate everybody being here, and thank you all.
And I would just ask, Judge, that you order her to be returned forthwith.
Yeah, I'll order that she be forthwith returned to Winnebago. So ordered.
All right. I'll be in touch right now.
Court's in recess to tomorrow morning at 8:30.
Mr. Cotton looked all proud of himself there. Did you see him? He was like pumping his fist. I don't know who he was talking to, but I guess Morgan's parents, or her dad has passed away, but maybe her brother and her mother. All right, so Judge Boren just granted he denied the petition to revoke, and he granted the petition for the release plan. So he orders the release plan to be filed. Now, again, this was in they're saying March, but this was not March. Oh yeah, March 6th. Okay, so then they were talking about they have like 30 days to get that together. Then he retires. So he retires April 30th. But before we do all that, let's back up. Let's back up a second. All right, Rent Boy. If you guys go to Amazon, put in Rent Boy or just type in Rent Boy Amazon. All right, so here's the back of the cover. Danny is a rent boy, an architectural student, a waiter, and hot with an exclamation point. And I'm going to have to redact like every other word. Working his way through school seemed pretty easy. He serves ego-obsessed writers their cocktails at the Emerson Club. He has his toes and other appendages by businessmen. He escorts anyone, male, female, or otherwise, who can afford him. But then his liaison with another rent boy gets him involved with an organ theft ring centering around a crazy old doctor and crackpot nurse. Here's where the synopsis or what Dr. Robbins read, and this is on the back of the book. A relentless stream of social commentary careening between S, comedy, and M. Rent Boy is a hysterical romp through the worlds of contemporary culture and crime. And then there's a high risk stamp on the back of the book, and then in the in the copyright. Not in the copyright. So it's for Lynn Tillman. Then in the there's another high risk. It's from High Risk Books. I'm sorry, it's from High Risk Books. That's who puts it out. High Risk Books. All right, and then it's got it has a definition of the Greek word writing of harlots, to write, akin, depiction of behavior, excitement, material. You guys get the message. So that's like not even on page 1. All right, page 1. Saturday night, a famous writer comes into the Emerson Club with his wife and another couple. He's already drunk, and before they even order dinner, he starts insulting his friend's wife. The trouble with Joni is Joni's a C word. Quite, Roger. And in that C word, she's got the teeth of a great white shark. Whatever you say, old boy. Famous Roger stews for a second in his bile. There's a champagne bucket next to the table. A crisp linen napkin looped through the handle. He wants a refill. A lot of people don't know anything about the French Revolution. How true, Roger? Do you know where the Jacobins were? Haven't a clue, the man said. Well, actually, Roger, I do, Joni says. You think you know who the Jacobins were? I don't think I know. I do know. Let's hear your opinion about the Jacobins, Joni. A beat. Wouldn't you rather hear my opinion of you? Joni is screaming. She throws down her napkin and starts to get up. You're a boorish, pathologic, narcissistic, and, excuse me, Diane, she says to the writer's wife, you had your best years a long time ago. There was a threatening silence at the table, Joni half standing, trapped inside the banquet. Their faces all looked waxy, like actors in a Vincent Price movie. Well, Roger said, dipping his head, his silver curls caught in the light. Nobody's perfect. All 4 of them roared at that one. So that's page 1. Not that bad. Not that bad. All right, here's a little. Okay, I have a feeling this took place in New York City. That's just my vibe. I'm getting the vibe that this is from New York City. After work, I took a cab up to Showplace. Matt Hartman, the P-star, bumped around on stage for 5 minutes, rubbing his appendage inside a leopard skin jockstrap. At the end of 5 minutes, he took it out and stroked it at the audience. I thought he'd keep going till he, but he didn't. You're not supposed to do that on stage. Other people would have to step in it. Next was Gino Suave, a bulky Italian guy with a fat, not very long nozzle. Jesus. His emphasis seemed to be on his, more than his, yeah. He kept bending over, shooting his to the audience and wiggling it and pulling his cheeks apart with the fingers. His are too big, not muscular enough, although he has a nice rippled stomach. After he made it clear that his such and such was open for business, he shifted sort of half-heartedly around to show his partly stiff. it kept going soft, and he'd spin around, get churning again all the time, frantically. His song "Changes" by David Bowie, "Time Will Change Me," and he finished off. So that's a little bit of Rent Boy. So go check it out if you want. Hopefully we won't get smacked by YouTube. Good Lord. All right, so that's Rent Boy. It's like I don't know. Whatever. It's like yeah, whatever. I'm not gonna I'm not gonna opine on that one. All right, so that's Rent Boy. Not appropriate for mental health institution reading. Why on earth was that? I'm not one for censorship. All right, I'm definitely not one for censorship. But my goodness, Northwest. Yeah, what is that doing in a mental health institution? Wow. Yeah, Joyce, one hot mama. What did you come back to? Exactly. Hopefully YouTube won't. Joanne. What did you wake up to? Exactly. Yeah, Harlequins. Yeah, Harlequin romances. Yep, you remember those? Book would be interesting. Trash by page 2. Yep. So yes, hopefully the will protect us from YouTube. All right, let's move on. Mary, I should read a chapter a day. We won't be on YouTube if I read a chapter a day. Not well written, just vulgar. Yeah, whatever. Joyce, I mean, I read some spicy books, but goodness, might look into that one. It isn't comedy. This isn't comedy. Doesn't seem anyone looked at this free sample. All right, let's head on. Okay, so he's granting her a conditional release. And then he retires, right? So Judge Boren retires. So now let's get to her actually being released. Let's see what happens here. And this is the new judge. This is Judge Warner, I think.
Under was set.
Sorry. I hate when that audio comes in like that. All right, so this is Judge Scott Wagner. Scott Wagner. This is the new judge. All right, so this is the new judge. So Judge Boren he's retired, and then this is the new judge. All right, so here we go. Oh, this is from, hold on, let me get this date. This is July 17th. So this is her release. This is her release hearing. All right, and thanks you guys for hanging with us throughout all of this. It's been we're gonna after this we're gonna walk the path until December 23rd. That was the last time she was in court. So hang with us, and we'll follow this path. Gordon, he retired. Wait, I gotta pull that up. He retired because he read Rent Boy. Nice. All right. Yeah, remind your grandparents to talk about stuff they didn't want us to understand by humming and clearing their throats. Well, if this was for members only and we didn't care about being smacked by YouTube, I'd be reading it, but can't do that. Can't do that because YouTube will be YouTube. All right, so this is from July 17th, 2025.
971.174E to review the conditional release plan that was prepared for Ms. Geyser for her conditional release. Just by way of history, the recent history, on October 11th of 24, there was a petition for conditional release filed for Ms. Geyser. Judge Boren held an evidentiary hearing on January 9th of this year and granted the petition for conditional release, concluding, for the reasons stating in the record, that the release of the defendant would not pose a risk of bodily harm to her or others, and Judge Bourne directed the DHS complete a release plan within 60 days in accordance with the appropriate statutes. On February 27th of this year, the DHS filed a statement of probable cause and a petition for revocation of conditional release. On March 6th, the court had an evidentiary hearing on the petition for revocation. After taking testimony, denied the petitions for the reasons stated on the record, and Judge Bourne again ordered the DHS prepare a conditional release plan and file it with the court. On April 14th, the DHS filed the conditional release plan. There were some issues with it that were discovered at the April 28th hearing, but in particular regarding the location of where Ms. Geyser was going to be placed under the plan. Judge Bourne also directed there were certain things he would like to have judicial oversight of, and in the plan that was submitted to me after a May 27th request for additional time to prepare an amended revised plan, those issues were not addressed. There was nothing talking about court supervision, or it did not also include the standard DHS conditions and some other conditions that were modified and appeared in the earlier plan for conditional release. While I was set to discuss those issues in great detail this morning, I received addendum this morning which addressed my concerns, at least in those regards. And in particular, it includes the DHS standard conditions of release along with some customs conditions for Ms. Geyser that I believe should be incorporated into the plan. I also received an addendum to the confidential release plan, and that addendum indicates that all changes relative to GPS monitoring, to GPS on our placement, are subject to review of the court. I'm going to open the plan up to comment generally. I can tell you I would change that language to say all changes relative to GS monitoring and or placement require court approval, because I want to be on the front end of that as opposed to some kind of later review of the process.
Fine.
I assume there's any objection from state or defense on that?
No objection.
Okay, and then with that, those were my thoughts, but I welcome both the state and the defense's opinion of the plan, and I think we confirmed before the hearing started that both sides have had a chance to review the additional materials that were submitted recently. Is that correct?
That is correct, Judge.
Yes, Judge.
Ms. Nicolai?
I have had a chance to review the plan as well as the additional materials, and I believe that it does address certainly the concerns that were raised at the last hearing that we had, given the location that was found and is proposed in the confidential plan. And so I don't have any specific comment to offer to you in terms of a victim impact statement or anything like that. And we are in compliance with victim rights, and certainly there are specific conditions contained in docket number 692 that are appropriate as well in terms of victim rights. I would agree with the court's change in docket number 691 in terms of court approval being required if at some point in time the team deemed it appropriate to remove the GPS, and if at some point in time the team deemed it appropriate to change Ms. Geyser's placement. And so I just want to make sure that those are two separate and distinct things. I think that that sentence could be read a couple different ways, that the word placement, we're referring to Ms. Geyser's physical residential placement, not the placement of a GPS device. That's how I read it, that the court would need to approve any change in her residential placement.
That's how I read it as well. Okay. I don't think there's any dispute from the defense on that, is there? It's two conditions, not one?
Right. I'm not reading it as the location of where the GPS
where we put the GPS on her body. Okay. So, all right. So we understand that it's two different things. Both require court approval. Anything else, Ms. Nicolai?
The only other concern that I had about potentially something that I was going to ask require court approval was in regard to medication monitoring services. However, I've had a chance to discuss that with DHS, and I no longer have a concern about that because it is directly tied to her residential placement, and that monitoring will occur. And so if there was a change in placement, that would be addressed in the court. So I don't have a concern about that. And so those are really the only comments that I have about the plan.
Okay, Mr. Cotton?
I've discussed the plan with Ms. Geyser. She obviously has signed the rules, and they've been discussed with her, so we don't have anything else to add.
Okay, then it's my intent with the minor modifications we talked about to approve the plan. With the representative from DHS, please come up for a minute.
Judge, would it be okay if she just sits here?
Yeah, okay. Absolutely. If it's okay with her.
Thank you.
And you are?
My name is Nicole Whitaker. I'm Forensic Program Supervisor at Wisconsin Community Services.
Excellent. And the plan is if I approve the plan as we described with the minor modifications, how soon do we think we can turn that around?
Yes, Your Honor. By the end of the week.
Okay. And we won't need a prior hearing. We'll just distribute it. I don't think this is that difficult, what we've just discussed. And is it still the plan on or about August 4th for the placement?
Yes, Your Honor.
Okay. And nothing in this modification would delay or derail that?
Not that I'm aware of.
Okay. Then subject to the addendum or the additions we discussed, which include the DHS conditions and specifically requiring court approval for any changes to GPS monitoring or the physical placement of the defendant, I approve the conditional release plan, subject to receipt of same. I would say if I don't have an objection within 3 days of receiving the modified plan, I'll enter an order approving. Is that fair?
Yeah, that's fine.
Okay. Anything else I can do today?
I don't think so.
Yeah, right, I know. Okay, just from our perspective, I need the court just to enter a verbal order directing the Sheriff's Department to send Ms. Geyser back forthwith to the hospital, to the Winnebago facility.
So ordered.
And we'll monitor that, and if we need to submit a written order, we'll do that.
I think we've already taken care of it, so I think you're okay.
Great. We just don't want her to sit in jail.
No, I agree, and I believe we've already arranged for that.
Okay.
Okay. So we're just to confirm, we're going to get the plan with modifications in the next 3 or 4 days,
That's correct.
and then if no objection received within 3 days, I'm going to enter an order approving it.
Great.
Okay. Thank you all very much.
Thanks, Judge.
Have a good day.
Yeah, just tuck in here, okay?
All right, Northwest, I'm not seeing that. About location of group home, I'm not seeing that. There was a hearing. Home was 8 miles ago. 8 miles from the victim. I'm not seeing that. It may you see it on YouTube. I'm not seeing that. Yeah, I'm not seeing that. Ooh, I did find a thing on James Cotton. On I'm definitely going to play this. We'll play this later. This was 1 month ago. All right, hold on. All right, hold on. Okay. Sorry, I just found this. This will be good. This is her lawyer. Definitely want to play this. Her lawyer talks after she escaped. All right, so let's keep walking the path here. Hold on, just give me a second. Doing this on the fly, so just bear with me for a moment. All right, so where are we up to? I'm not seeing that, Northwest. Yeah, Karen, I found it through another source. Thank you, though. I found that from December 30th. So thank you for that. Let's just hang tight on that. No spoilers, guys, because we don't know what happened. So let's just keep chill on the spoilers. If you know what happened, just please keep it to yourself, because a lot of us, including myself, don't know what happened other than she escaped. So even that's giving away too much. Let's just keep walking the path. All right. So here's some news. Let's just keep walking the path as if we don't know what happened. But if you guys have any information that you think I'm missing, let me know.
Other news topics.
You can email me. Make it quick, though, because we're moving fast here.
We turn now to other news topping the headlines. 10 years after the infamous Slender Man stabbing in Waukesha, the case may finally be put to rest, at least publicly.
And Morgan Geyser was a child when she and a friend viciously attacked a classmate. Now, as 12 News' Zoe Henry reports, she's entering a new phase of mental health treatment.
After years in the criminal justice system, Morgan Geyser, now 22, is poised to be released from a mental institution. Thursday morning in Waukesha County, she was in court virtually, sidestepping the online camera during what her attorney hopes is a final court hearing.
DHS has found a great spot for Morgan, so it was a very substantive hearing and a good result for her.
In 2014, Geyser and Anissa Weier nearly killed their classmate, Payton Leutner, stabbing her 19 times as part of a twisted plot involving a fictional character known as Slender Man. Weier was released in 2021, and a judge approved Geyser's release just weeks ago. The decision to send her to a Sun Prairie facility was met with objection by that city.
Our residents, if they find out about this, will be outraged, and I understand that the plan is confidential, but unfortunately, due to the notoriety of this case, I think if our residents see Ms. Geyser outside of the home or taking a walk in the neighborhood with supervision, they will be aware of who she is.
Judge Scott Wagner ultimately deciding Sun Prairie would be the next move.
And I think this plan, and it took us a while to get here, don't get me wrong, I think this is a good balance of all of those concerns, and that's why I'm approving it, and we're going to move forward.
Attorney Anthony Cotton pleased with the outcome for his client.
I think what everybody wants is that she will readjust to society. She's been in custody for 10 years now. I mean, imagine being 12 years old and now in your early 20s and you've never left confinement. It's horrible. So this facility really will allow her to grow as a person and I think be a safer and better member of the community.
Geyser will be on GPS monitoring once released. In Waukesha, Zoe Henry, WISN 12 News.
Morgan Geyser's attorney says that she could be released as early as next week.
So where was that? So that's the hearing. That's the hearing. I can't follow. Can't find that. So where was she released to? I was Sun Prairie? Is that where it was? Where was she released to? Sun Prairie.
Judge Scott Wagner ultimately deciding Sun Prairie would be the next move.
I think this plan.
All right, so Sun Prairie.
Don't get me wrong. I think this is
All right, so Sun Prairie. Yeah, I would love to watch that hearing. I can't find it. Let me see if I can find Morgan Prairie. Let me see. Sun Prairie? See if I can find that. Transfer to Sun Prairie. Convicted, approved. I'm just finding news clips. Yeah, I'm just finding news clips. I'm not finding a full. I'm just seeing news clips. Here, let me pull this up. Maybe this is. Okay, this one's 2 minutes. Yeah, I can't. I'm not seeing that full hearing. Judge disappointed. Judge disappointed. All right, let me play this real quick, and then we'll go back to that. This is another news thing. Maybe hold on. This is just a news. Well, while I play this, I'll look for that. Hold on.
people convicted in the Slender Man stabbing is moving to Sun Prairie. Thanks for joining us at 5. I'm Mark McPherson.
And I'm Lee Mills. Morgan Geyser and another girl stabbed their classmate multiple times back in 2014. Now, people in the city are expressing concerns that Geyser will be in their community.
WMTV's Nicole Herzog was in Sun Prairie today to talk with residents and the police department about their plan for Morgan Geyser's arrival.
Sun Prairie police tell me they don't have an exact date yet for Geyser's arrival, but when she does make the move to a group facility in Sun Prairie, authorities say they're prepared to keep people safe.
It's scary, and we want it stopped.
Gabrielle Alturk says she's always felt safe living in Sun Prairie.
My son goes and rides his bike. They both go out. They go to other parks and neighborhoods.
But that feeling changed when she learned Morgan Geyser is becoming her new neighbor.
We were even considering moving out because of this. We were going to look at homes in another city. The community that I know of is extremely concerned because, you know, she was a kid when she planned a premeditated, cold, calculated murder.
Geyser is moving to a group facility in the area where her attorney says she'll have to wear a GPS monitor. But Alturk says that's not enough.
It's horrible. We're afraid. Like, we don't know. They won't tell us where she's going to be. That's the worst part. This is a safe community. This is a community filled with children.
We understand why that type of release would raise concerns amongst our community.
Assistant Police Chief Ryan Cox says authorities are listening to those worries.
But your police department is absolutely prepared for it. We have all the information that we need in order to respond accordingly.
He couldn't tell us where she'll be and when she'll be in the area.
There's not a lot that I'm able to release. There are certain things that are protected information, but I can tell you that a plan is in place.
But says they're just a call away if anyone needs it.
I will assure you that this police department is informed and we will respond accordingly.
Now, Geyser is currently living in a psychiatric hospital in Oshkosh, but her lawyer argued the Sun Prairie group home will have more resources and treatments for her, allowing her to transition back into the community. For now, live in studio, Nicole Herzog, WMTV 15 News.
Nicole, thank you. Anyone with concerns can reach out to the Sun Prairie Police Department. That number right there on your bottom of your screen, 608-837-7336.
All right. So thank you to Northwest and thank you to Jenny G. And then I found it as well. So we're going to back up a hair. We're going to back up a hair. And just bear with us for a second. We're going to back up a little bit. I did not see this when we were doing our research. So thanks, guys, for bringing this to my attention. So this is the release. This is them talking about the release plan. So we're going to back up just a little bit. We're going to go back to April. So we're going to go back to April. So, and then we'll get to her. Then we'll get to her escape. So we're a little out of order. Sorry.
Court will call a matter of State versus Morgan Geyser, case number 14 CF 596, appearances.
The State by Ted Sapakowicz and Abby Nikolai.
Thank you and good morning.
Morning. Morgan Geyser is here in person with Donna Kukler from Kukler and Cotton.
All right, thank you and good morning. Court's here today to review the proposed plan of release that was submitted on April 14, 2025. Has the state received it?
Yes.
Has the defense received it?
Yes.
Has the defense had an opportunity to review the report with Ms. Geyser?
Yes, we have.
I note that the court had previously submitted an order that authorized that Ms. Geyser be approved a supervised release for her. Under the statute, then the state ultimately prepares the plan that's been submitted. The petition for supervised release was under
Section 971.17 sub 4 of the statutes. And then under sub 4 sub E, it sets forth the basis for the plan that's to be submitted to the court. It's been submitted to the court, and now we're here on a hearing with regard to that. Sub E sets forth various items and criteria that addresses the content of the report. I've read the report as well. Further, I had submitted to Ms. Trinkner, the drafter of the report, some questions. She responded to those questions by email that was submitted on April 23 and placed in the file. Has the state had an opportunity to see that?
I've seen that, yes, Judge.
All right. Defense had an opportunity to see that as well?
Yes, Judge.
All right. And is Ms. Trinkner in court today?
She is.
All right. Where is she? There we go. All right. Thank you. So what's the state's view?
Judge, my view is we have a large problem. And I don't mean to speak for Ms. Trinkner, but I believe they would like an opportunity to redo this plan. When I first read the plan, Judge, I was shocked that there was no mention whatsoever of the victim, or where the victim might reside, or where this proposed residence for Ms. Geyser was in relation to where the victim resided. The authors of the plan never consulted with the victim in this case, and I have learned in the last 5 or 10 minutes that literally these two locations, the victim's residence and this proposed location for Ms. Geyser, are in less than 8 miles from each other. The entire state of Wisconsin, Judge, we have a plan that has her 8 miles away. The department and the authors of the plan didn't know that. They don't believe it's at all appropriate anymore. The victims are here by Zoom, and I know victim's mom wished to address the court. We knew generally that they were very close by, and now, like I said, in the last 10 minutes, I've been provided the exact address of where Ms. Geyser is proposed to be, and literally less than 8 miles apart, Judge. So we object to the plan. We're asking that the court adjourn this hearing and give the authors of the plan more time to see if there isn't somewhere else that may be more appropriate under the circumstances.
All right, thank you. Ms. Thickner, could you come forward and just have a seat at the table in front? She should be able to sit at the front table.
I know I saw it in here. Maybe not in content. I saw that in here.
Then just identify yourself, please.
Yep. Grace, Grace, Trinkner, Trinkner.
And what role do you have in this matter?
Yep, I am the case manager assigned to Morgan Geyser.
All right, and you prepared the supervised release plan?
Yes, I did.
All right. So what's the status of the plan from your perspective?
At this time, we would ask for more time to look for a new location for Ms. Geyser to reside. Originally, we felt it was appropriate for Ms. Geyser to reside in Milwaukee County, as we believed it was removing her from the location that the events occurred. At this time, now that we know that the location is close to the victim's residence, we no longer feel it is appropriate for Ms. Geyser to reside there.
All right. Just on the status of 8 miles, what distance do you believe would be appropriate to separate the victim from Ms. Geyser?
I don't know at this time.
Well, are you looking at 8.5 miles? Are you looking at 10 miles, 20 miles, 50?
We're definitely looking at more than 10 miles.
All right. Would that be outside of the, well, it's one, you've made a determination that placement would be outside of Waukesha County.
Yes.
So you're looking perhaps at a location outside of Milwaukee County as well?
If it is appropriate, yes.
All right. What's the defense position then?
This is first we're hearing about it.
Yeah, I'm sort of surprised there wasn't a discussion about that before the case is called. It's usually a professional courtesy that's extended just to clear the air and be able to go forward. So what's the...
I didn't have a chance to formulate, my thoughts exactly, but I don't know when we say 8 miles if they're in the same county. Is that what... I haven't heard that the victim is living in Milwaukee County. Is that what I understand?
No, Judge...
No, nobody asked for you to respond yet. And Attorney Kukler, you can't address questions others than the court.
I'm addressing it to Your Honor.
All right.
My question would be whether or not they're both living in the same county. The 8 miles could be, you could be in Waukesha County, Jefferson County. You could, couldn't be Jefferson for 8, but I don't think 8 miles just per se is a problem. I would also point out that there is a no contact that's part of the plan, of course. So to suggest that there's been no consideration of the victim isn't true, because that is part of the plan, that Morgan have no contact with her. I would also point out that the plan provides for Morgan to be on house arrest. She's not allowed to leave where she's going to be placed. And she, I think that what we could do is allow her to be placed where the place has been provided for her. She'll be on house arrest, and if the state wants to work on finding yet another place to move her to, then they could move her when they find that other place, but she can't leave where she's going to be residing anyway. So that would be my thought.
All right. Ms. Thickner, apparently up until this morning, you had not, I was going to say proximity, but I don't see that 8 miles is in proximity to the victim. It's less than 10 miles, I understand that. But what was the criteria that the state used in developing the recommendation that it did?
The recommendation of the housing?
Right, well, the plan.
Yeah, well, we consulted with Department of Corrections and Department of Health Services to develop the plan. We met several times to go over different restrictions that we felt might be appropriate for Ms. Geyser, based on the offense itself, based on her current treatment needs. And we determined that a group home would be appropriate for her at this time, as there would be increased supervision, as well as GPS monitoring, so that Ms. Geyser's location could be tracked and different areas would be restricted.
So what is the district attorney reported, and you've reported, and what you've said is that based upon the 8 mile distance between the victim and the group home, that is inappropriate. Why? I guess I'm somewhat struggling with why it's inappropriate.
We would like there to be distance between Ms. Geyser and the victim due to the victim's safety, and providing the victim space to continue to reside where they are without worrying about Ms. Geyser's location.
All right, any response from Attorney Kukler?
Well, again, I'm just wondering if they're within the same county or not.
Well, that apparently the view of the conditional release writer is that there be greater distance between the victim and Ms. Geyser's residence.
Ms. Geyser isn't allowed to leave her county.
No, I understand that concept. I also understand the argument that's being made as a justification for a renewed report. It may be that Milwaukee County, if Milwaukee County is a location, is a big county.
maybe that they'd look elsewhere. It certainly is a factor that I'm satisfied that that it's appropriate to review. In other respects, I'm satisfied the report is appropriate. What's the state's view with regard to the report, other than the distance?
There are some things, Judge, that were left open-ended, like GPS restrictions, and much of what's indicated in the report is left to the discretion of the treatment team. We think there should be some further judicial oversight on some of these factors, like location, like GPS restrictions. Like those things can't get moved without notice to the court, and the court can decide whether it wants to have a hearing or not. But at least that notice be provided, and perhaps the court would decide this is something the court should take a look at, and it should be the judge's decision when some of these changes to the plan get made. Back on the living situation, Judge, I thought there was some effort here to keep both locations confidential. In fact, that's why the location for Ms. Geyser was submitted in camera to the court this morning, I believe. So on the issue,
well, we have nothing. By the way, I have nothing that was submitted to the court this morning.
It may be that Ms. Trinkner has it with her. I'm not sure if that. I assume that's been submitted to the court. But
Jessica, have we received anything?
I don't see anything.
Maybe Ms. Trinkner can speak to that, Judge, but it does have the exact address, and we were just provided with that this morning. Also, Judge,
wait now.
Okay.
I don't have. You said I had it. I don't have it, and I'm looking now at Ms. Thickner to see, do I have it, and it's just not been transmitted electronically, or what happened?
It has not been submitted electronically. Our contractors at DHS wanted us to provide a paper copy today at the court hearing, and it was provided this morning to Attorney Nicolai.
Was it provided to the defense?
No.
We brought along a singular copy. We were told it was to be reviewed in the judge's chambers.
Of course, then you give it to the DA. You don't give it to the judge.
I apologize.
It's an odd way to operate.
And I thought it was provided to the court, Judge.
And not provided to the defense. That's not appropriate at all.
I do apologize.
Now this is what some people may refer to as a high-profile case, which would generally mean that in particular T's are crossed, I's are dotted, to be sure that all rights are protected and that notice is appropriately given. It's not meant to be a subterfuge or somewhat trickery involved or ambush type of thing with new issues being raised at the last minute and other people involved don't know about it, and that's somewhat what's happened here. I'm really surprised. If I need another comment, I'll ask for it. I'm just reviewing the report. Present. All right, the victim's mother wanted to make a statement.
She does, Judge.
All right. And just identify the victim's mother.
Stacy Leutner, and she's appearing by Zoom.
So, Ms. Leutner, are you present by Zoom?
Good morning, Your Honor. Yes, I am.
Say you wish to make a statement, you may.
I do. Thank you. Good morning, Your Honor. My name is Stacy Leutner, and I am the mother of Payton Leutner. I speak today on behalf of our entire family regarding the proposed conditional release of Ms. Geyser. Last week, we reviewed aspects of Ms. Geyser's release plan with the District Attorney's Office and were immediately and deeply concerned to learn the proposed community for her placement. This community is the same community where Payton currently resides, pursues her graduate studies, maintains her social connections with friends and family, and works as a mental health provider. As Your Honor can appreciate, this news has caused significant distress for our family. This is not the first experience with the conditional release process. In spring of 2021, Ms. Geyser's co-defendant was released. During that process, the conditional release team engaged with our family to understand Payton's residence and schooling. The resulting release plan considered these factors, offering us a measure of reassurance that the efforts were made to ensure Payton's safety. In stark contrast, the Department of Health Services made no attempt to contact our family while drafting Ms. Geyser's release plan. They made no effort to ascertain details of Payton's daily life that would be pertinent to this planning. While we understand the complexities of this case and the need to consider Ms. Geyser's safety given the public and media attention, we must ask what consideration has been given to Payton's rights and her need for safety. It is difficult for us to comprehend why, in this instance, the rights of the offender appear to supersede the rights of the victim. Payton has worked incredibly hard to heal from the profound trauma she endured and has established a meaningful life within this community. She deserves the fundamental right to continue living her life in peace. She deserves the right to engage in everyday activities, such as grocery shopping or visiting the library, without the agonizing fear of encountering the individual who held her down and stabbed her 19 times when she was just 12 years old. It feels unconscionable that the Department of Health Services seemingly failed to consider the profound re-traumatization these actions could inflict upon Payton. Therefore, Your Honor, we respectfully request that you order the conditional release planning team to identify alternative placement facilities for Ms. Geyser in a community where Payton can continue to live her life without this constant and understandable fear. Thank you for your time and careful consideration of our concerns.
All right, thank you. I appreciate you being here and appearing and your statement as well. Any further statements from the District Attorney?
Judge, I can't put it any better than that. That is the concern, and that's why we're asking that you reject this plan today and allow more time for a different possible placement. Like I said, we didn't learn until moments before the hearing how exactly close the two placements were. There had been an email from Ms. Erin Groff to the defense and to the state indicating the department's plan was to provide a written notice of Ms. Geyser's proposed address for an in-camera review, as again, these locations, everyone's doing their best to try to keep it confidential.
All right, again, it's always amazing. An in-camera review would have been with the court, and the court's not part of the communication. That's an interesting way to operate. Not the DA's responsibility, but interesting how the state operates, how the planning operates. And I'll look to Attorney Kugler. Anything further from Attorney Kugler?
I understand the concern here. I didn't realize that there was a discussion last week about the victim's family's concern. Wish that had been brought to our attention. We could have potentially talked to Department of Health Services and maybe made some headway on that before coming here today. I again ask that in the interim, that you allow Ms. Geyser to reside at the group home under the restriction of being remaining in the home while the state looks for a different placement for her, if you think that's appropriate.
All right, thank you. Well, I read the report, the conditional release plan, before coming to court, and I took some time now just to review it once again. Ms. Thickner, anything further from you?
No, Your Honor.
If I do order that there be an amended plan submitted with regard to placement locations, what is your time frame?
We would need at least 30 days.
All right. To finish, to do the amendment. All right.
Correct.
All right. Well, I'm satisfied that the issue of location is an important matter. Proximity maybe isn't the well, it could be a good description, but location of the defendant's placement, location of the victim are significant factors. There are no contact orders as part of the plan. There's monitoring as part of the plan. All those are significant. What happens, even in the best of circumstances, is that oftentimes there's inadvertent contact that occurs, not meant to happen, but it happens. The closer people are to each other, the more likely inadvertent contact, the more likely that type of inadvertent contact can occur. We don't want that to happen in any type of case, certainly in this case with regard to the particular history of it. So that's a significant factor for the court to consider. The court presided over the earlier conditional release plan of the co-defendant, and I recall the carefulness with regard to contact with the victims and victim's family, and the defense at that point to be sure that all was proper and appropriate. There seemed to be some. Well, there's some. I don't know. I don't quite know how to describe it, but I'm disappointed in the states in the plan, in the conditional release team, in how they've appropriated and how they came up with the plan, not taking into account the location, but then this type of really communication with only one side of the situation, and then that they communicate with regard to things the court should do without letting the court in. It's a secret, and unfortunately, the court can't be secret from the court. And it wasn't until this morning, and when it's brought up in the court on a number of occasions. So that's I'm hoping that'll be rectified. So I'm going to order that the conditional release plan submit an updated report that addresses location. And I think the state's comment with regard to the GPS monitoring, the type of any travel outside of restricted areas should be subject to at least court review, and that should be part of the hearing. With regard to the co-defendant, when there was a petition filed to eliminate the GPS monitoring, and that was then held in court. We conducted a hearing on it, and I think that's appropriate for those type of situations to occur as well. So I'll order that the plan be modified in all material respects to take into account the location of the defendant relative to the victim, that court supervision of any changes to one of the substantial factors such as GPS monitoring be set forth so it can be reviewed by the court, and that any other material aspects of the report which should be modified can be modified at that point. I'm going to order that any additions and modifications be completed within 30 days of today's date. That today is April 28th. So if you file it by May 28th, can you do that?
Yes, I can.
All right. And then we'll set a hearing then in June, probably the mid-June, with regard to that. And I allow 2 hours.
I'll grab my calendar just a second.
As part of looking for the date, I want to be sure that any material aspects of the report, communications of the report, have to be communicated to both parties, both the defense and the state. This isn't the conditional release team is not an agent of the district attorney's office. You're actually probably an agent of the court, if nothing, as I appointed you and requested that you do the report. That means you have to communicate with both the defense and the state, and where the court's particularly involved, the court should be told and communicated with as well. The court should not be in a position to learn about things the court should know from one of the attorneys in the case because they had a conversation with the conditional release team.
June 20th at 9:30.
Do you need another date, Attorney Kukler?
Yes.
All right, we'll give you another date. That week or another week?
Are we going to be looking later?
Well, we're looking for a date.
Okay. Would you have anything the week of June, like June 9th or June 10th, possibly?
Could you June 9th at 8:30?
Thank you.
Morning, 8:30.
Good for you then?
Good, thank you.
Good for the state?
It's good for us, Judge. We would need some confirmation, if possible, from the victims if that date's available.
Do you have how do you want to have that confirmed? We'll do it just on the
Miss
Zoom
Leutner,
appearance. Ms. Leutner, are you there again?
I am, Judge.
Is that a good date for you?
Was the date June 9th?
Yes.
June 9th at 8:30.
Yes, that date works for me.
All right, very good. Anybody else have a significant issue with that date that we ought to know about? No.
I think that's good, Judge.
All right, then in looking at the case, the conditional release port, in other respects, from the court standpoint, is appropriate and fair and reasonable to all parties involved, the state, the public, as well as the defendant. The defense suggested that pending a modification of the report that Ms. Geyser be permitted to be placed at the location that has been suggested by the state, which is part of this closeness issue. Well, on the one hand, that on first blush could appear, well, it's reasonable, we'll make the transition, and then another transition at some later date. On the other hand, and I'm more satisfied with the court should maintain stability in a case such as this, and that before we the court approves any moves, any plans, that all should be in order. That there's nothing hanging out there that has to be adjusted down the line. Sometimes adjustments down the line on one part can have a big impact on other parts of it. So under those circumstances, then it's important that when the court reviews the plan and approves a plan, that it be the plan and that it cover all bases that's appropriate. So on that basis, I'm satisfied that I'm going to order that the plan be modified as I've indicated, be filed by May 28th with the hearing then on June 9th, so ordered. It'll be in front of Judge Wagner at that time.
Anything further from the state?
No, thank you, Judge.
Anything further from the defense?
Just that Ms. Geyser would like to be returned to Winnebago today if possible.
I'll order that she be returned forthwith.
Thank you.
Thank you. I want to note that I had authorized civilian attire today.
Pardon me?
I had authorized that she could wear civilian attire.
Oh, okay.
You didn't know that?
They didn't say anything. I apologize.
Really? Well, your attorney knew. It was in the court file. Well, good luck. Have a good day then, everybody. Thank you. The court will be in recess.
They never remember that. And then every time I ask, it's like a whole situation.
Bring them along with you next
I
time.
did.
I know, and they didn't. All right. Here, this is for you, Morgan.
All right, do you guys want to watch Judge Wagner again, or because we watched that before, so we were just a little out of order. Do you want to watch that again or no? We've already watched it once, yeah. All right, that's what I think too. I think we've already watched it. Yeah, we've already watched it. We already know what happened. All right. I mean, it's only 10 minutes, but we already watched it. We know what happens. So, all right. So next up is, okay, so she's been released, right? All right, we'll move on. We can move on because we know what happened, right? Okay, so she's been released. Now, she's been released. So here's what happens after she was released. Let me just make sure. Let me just check this out real quick. All right. All right. So she's been released. Eight miles is so close. 8 miles is so close. And the reason I said, you've got...
this afternoon.
If you live in a city, that's one thing, but living in the country, yeah, you can public transportation, hitch a ride. All of a sudden, if you have your nearest neighbor is, 100 yards from you, half a mile from you, and then all of a sudden, here's your person who, tried to take your life knocking on your door. That's one thing. If you're in a city and you live in an apartment and you've got neighbors up and down, and then, you walk out the door and then there's somebody, it's easier. It's a little bit easier to run and hide or call for help, but still, just way too close. Way too close. Yep. Yeah, Dina. Way too close. I don't know. You guys were saying just put her. I mean, Wisconsin's a big state. It's not like it's, Rhode Island. Wisconsin's a big state. Put her at the other end of the state. I don't get that. Don't understand that. But anyway, so she ends up going to Sun Prairie, and we saw those reports about people were not happy that she was at Sun Prairie. So, all right. So she was taken to Sun Prairie, and then that was in July, right? July, August, September, October, November. You guys were saying September she was taken to Sun Prairie. What's the exact date? What is the exact date? Is there anything I need to read over here? Okay, when was she actually? What was the exact date? No, Sherry, we're getting there. We're getting there. We're right on the cusp of her. This is going to be her escaping.
Well, this afternoon, a woman convicted in the Slender Man stabbing case is now back in custody after escaping from a group home this weekend. Morgan Geyser was 12 years old when she and another girl stabbed and nearly killed a classmate in Wisconsin, reportedly to please a fictional horror character called Slender Man. Both girls pleaded guilty but were sent to state mental health facilities. Geyser, who is now 23, was on conditional release when she cut off her monitoring bracelet and then left a group home Saturday. She was found the next day at a truck stop outside of Chicago and was taken into custody.
All right, so it was September. Let's get that exact date. When was Morgan Geyser placed in release? Well, we know when she was released. She was granted in July or August. This was revoked. September 9th. September 9th. Oh, come on. September 9th. September 8th. The documents, new rules. Okay, it looks like September 9th. Details, documents detailing the release were outlined Monday, September 8th, but they are sealed. So can we go with, we'll go with September 9th? Does that sound about right? This is from Milwaukee, September 9th. Documents detailing the release were outlined Waukesha County Court on Monday, September 8th. Placement was signed on September 17th. This is from WPR. WPR. Okay, final plan and placement for her release to a group home was signed September 17th. All right, so we'll go with that one. So that's when it was signed. Whether or not that's when she went over, but we can. So September 17th. Does that sound feasible? Can we go with that one? We'll go with that date. And then November 22nd, she busts out. So September 17th, October 7th. So basically like 2 months. And then she escaped on November 22nd. Yep. So she was put into the home on the 17th of September. She broke out on the November 22nd. And she was arrested the 23rd. So 2 months, right? I'm sorry, yeah, 2 months. All right. All right, so now this is some body cam. Oh, you know what? Hold on. Let me do this first. Hold on. Let's do this one first. Hold on. Okay. All right. Well, I'm going to show this first, then we'll do her body cam. Oh, you know what? Let's do her body cam. Let's do body cam first. I always like to see the raw data. What a saga, though. My goodness. Just unbelievable.
Okay, that's fine.
Just unbelievable, this saga. All right. Here we go.
I advise them that Robins, I don't know if they're able to like sleep in their lobby because they used to do that before, but they said that they're just going to move it.
Yeah, I had called to see. I didn't know what it looked like. I fed them. So I was calling to see, and they did somewhere for the night.
Yeah, and the thing is, there ain't a lot of shelters. That's what's crazy is.
Yeah.
They find shelters for other people, but
Yeah, because I'm out here for food. But I couldn't leave them out here. So I was like, I didn't know what to do. So I was like, just let me call and see y'all know
I
something.
told them that I believe Robinson, a lot of the very good seat there, but they said it's very good.
where you guys from?
We're from south.
South?
How far?
Like how far?
Not that far. We're not living anywhere. We'll be fine tonight.
Okay, I just want to make sure you guys are warm.
We're fine.
You sure?
I appreciate it.
No problem. I just want to make sure you guys have some place to warm to stay.
No, we're always.
How old are you?
I'm 23.
23?
Yeah.
How old is he?
She's transgender. She's
Oh, how old is she? 23? Okay.
I don't have my ID, but
All right, well, give him your name and date of birth, because we just got to make sure you're saying who you are, you say you are, okay? You're not missing them and stuff, okay?
Thank you, Mama.
No problem. Thank you for calling. Because I don't believe you're 23. That's why. Okay? And we got called here for a call. So just be honest. I want to make sure that you're not missing. As long as you're not missing, you can go on your way. Are you missing from somewhere? Then just give me your name and date of birth, and you can be on your way.
okay, I'm 19.
Huh?
I'm 19.
19?
Yeah.
That's fine. You're still an adult. So
Yeah, so what's your last name? No one.
I don't want to give you my name.
okay, well then we're going to arrest you and take you an ID. We're going to hold you an ID at the station for fingerprints. So you don't want to obstruct an officer. Give me your name and date of birth. You're not wanted for murder, right?
Right.
Well, then you ain't gonna have a problem with us. I promise you. Okay? You're making it a bigger deal than it is. It is. Transgender. So just get her name, his name.
Do you have your ID with you? No. Were you ever issued an ID? Or anywhere? You were? Okay. What state were you issued an ID out of?
Sorry, I'm just cold. Mine was issued out of Wisconsin.
Okay, and what's your last name?
Robertson.
Can you spell that?
You have a middle initial? Okay, what's your date of birth?
Robertson.
Oh, Robertson, okay.
His son. I think his son's great.
Your last name is G-R-I-E-S?
Yes, please.
You said you what? It's your real name, right? Right. It's not a big deal. You'll be on your way, okay?
L-E-S.
Okay, do you have a
First name George, Robert, Ida, Edward, Sam. First name Stephanie, Sam, Tom, Edward, Paul, Henry, Adam, Nora, Ida, Edward. Date of birth April 16, 2002. Female.
One run yours in my car. My car. Right there.
It's out of Wisconsin.
Still running in Wisconsin. Name and date of birth. Man, unless you want to do it over there, that's even easier. Hey, what's up, man?
Can we do something wrong?
No, we just got called here for a service call. So well, now you did something wrong because it's come back no record on files, and that means you're lying to us about your name. Okay. So now that's obstructing. I'm gonna give you one more chance before we're gonna take you in custody and fingerprint you. Okay. So just be honest. It's not a big deal. You're making it a bigger deal.
Boy, Edward, Robert, Tom, Sam, Nora. First name is Charles. Third initial, I'm married. Date of birth 12/17, 1983. Should have a
Give me your real name.
ID for her. Really.
Okay. Because if he comes back, no record on file also, which I hope he doesn't, because that means both of you are lying, then I'm going to take you both in for fingerprints. Okay? Don't make us do all that. We just want to send you on your way. No, you can't. You guys wanted for something?
Charles unmarried.
Why are you hiding your name? I don't understand.
Well, you didn't come back either. Even out of Wisconsin.
I just don't want my identity out there.
Okay.
It's just personal preference.
Okay, you can have that preference, but we're going to have that preference of taking you in and fingerprinting you. Okay? That's what we're going to do.
Is there any way to avoid that?
Yeah, give us your right name, date of birth, and then we can go on our way. We don't want to mess with you. We don't want to take you in and fingerprint you. But if that's what I have to do, I have to make sure you're not wanted for anything, no homicides or anything like that. That's it.
I can promise you
okay.
that. And I know
I don't know you and you don't know me.
I know.
Okay? So,
just gotta identify
give your name, make sure you ain't wanted for no warrants, and then you're good. Stephanie, one last chance.
Don't forget that last opportunity.
This is your last opportunity.
Okay, let's try this again.
I don't know what you're so scared about.
Here, what's your last name?
Please, I didn't break the law.
Please let her go.
So
you did by lying to the officer.
And you guys are loitering. House statute of false identification at this moment, which is a Class A misdemeanor that's a arrestable offense. Therefore, you can be placed under arrest for that. Both of you, because you lied and you lied. You didn't give me your real name.
And we got dispatched here because you guys are loitering in the back of the business. It's not like we...
And there's signs posted, there's no loitering, okay?
I'm sorry.
Okay, so it's not a big deal. What is your name? Don't make us arrest you and do all this extra stuff that we don't need to do.
We have other stuff to worry about.
I know. We got way more serious things to worry about than this. But we got called here. It ain't like we just walked up and started messing with you.
And not only that, but when we print you, it could take a day,
2 days,
2 days until your prints come back before we can. So you'll be in our custody until we can release you. If you want to sit in the cell all day, that's fine.
And your prints might come back before him. So then that means that he would still stay at the station and you might get released. Might as well just avoid all of that and tell us your real names.
Look, if you want to stay in a cell for 3 days, by all means, we'll go this route.
I'm going up her thing. At this point, we're just going to detain her.
Please
let her go.
Then
Please let her go.
Then give him your name.
I did something wrong.
What did you do?
She doesn't know what I did.
Okay, that's fine. I ain't.
Let me talk to you over here. Okay, I'll put you back.
What is it that you did wrong?
I did something really wrong.
What?
47 and Cicero.
What did you do wrong?
47 and Cicero by the 500 range.
It's not that. It can't be that serious.
Charlie X-ray 3727.
What was it?
We have to identify you. Okay, well, you agree.
And what is your name? What's happening? We don't want problems with you, okay? We just need to ID you. That's it.
Okay. Now,
what did you do wrong?
4 or 5 days, maybe even a week. Until your prints come back. Okay. Unless that's what you
She
want
doesn't know my real name.
Okay. Well, give him your real name. Don't tell him.
I don't care about her right because they're dealing with you. Okay? Can't give you information? Why? Why can't you give me information? What's wrong with that? So he says he just can't give me his information.
Okay, so it's take him in custody.
MORGAN
And then your last name?
GEYSER.
What is it?
GEYSER. I promise she did not know.
GEYSER. And then what's your date of birth?
May 16th, 2002.
That's what you want to do this way? Maybe get your prints early.
So Morgan is your first name, right?
Yes.
GEYSER.
No.
Let me say goodbye, please.
Okay, we will.
I will never see her again.
Yeah, you will.
No, I won't.
304.
Why?
Because I did something bad. Let me say goodbye.
We will let you say goodbye, but just stand by until we figure out what's going on. Okay?
You
I promise. I'll let you say goodbye.
No matter what I did?
Yeah, no matter.
Last name.
That's my word, okay? Okay? You're being honest with me.
I'm being honest. That's my name. Trust me, I didn't want to give it to you.
Okay.
You'll see why in a second. But she didn't know my name. She didn't know my name. Not my
That's all I have.
Didn't call it.
I have low battery.
Huh? Hold on. What is it?
We're not going to custody, okay? So that we'll do all your whatever you have to do, okay?
Is that your real name? That didn't come back.
Just like that.
That's my real name.
What's your middle initial?
E.
E?
Trust me. I
Is that your real birthday?
Yes, May 16th, 2002.
You got E as that Edward?
No.
Okay, middle initial.
I'm giving a 59 for meal, so what about 119 in our house?
You can put them in.
E, right?
Yeah, E.
314. Can you try that again?
Middle initial be Edward. Well, always in these 10-8 situations, so.
I didn't know, I'm sorry.
Number 014, Morgan E. Geyser, criminal record.
Go ahead and put your hands in
You
the
said I could say
I will let you. You guys go into the same place, okay?
I promise you didn't know.
Okay.
We got two across the Number 21.
We'll get you warm, okay? Have you ate?
What?
Have you ate anything? Alright, hold on a second. Is your ID in your purse? Honestly.
It is. I know you will. It's not.
Okay. Well, we're gonna go through it.
Give me, I was a 1037 vehicle.
Try to get mid-low.
You can get the car wash in the 145 block of Cicero. It's Gray Honda. I'll get you a quick minute.
Hey, Ronnie, take these bags since you got gloves. Try to find an ID in her. She said she doesn't have one. I think she's saying that it's really, really bad. So the only really thing bad is you'll never see me again. Is I hope she didn't commit a homicide. Because the way she's talking, she's saying that that's really, really bad.
All right. Homeless couple's guidebook. Okay, well, I think that was the start of it.
I'll be telling you.
I got a flashlight, bro.
Do I got a flashlight? Yeah, I got a flashlight. Go through this one for ID.
The Wolfie 29 works up for here. No, I want.
Let's just do it back at the station so that it's warm. Let's put all that back in the thing.
This is their stuff, right?
Did you drop your pen?
No, that's not mine.
Someone's pen's over there.
Yeah, that's his, whoever it was.
014, can we get a email, sir?
Back at the station.
Put this in your front here, right?
Another man. You want him at the scene or
Station.
at the station?
Station.
So let's just charge them also because of the cannabis, everything.
Yeah, for sure. They had cannabis on them, so they're going for that too.
All right, so now I'm going to read okay, so 3 correction staff are on leave following Slender Man's Morgan Geyser's escape. So 3 Wisconsin Department of Correction staff members are on administrative leave as the department investigates the escape last month of a woman convicted of doing what she did when she was in middle school. Morgan Geyser removed her ankle monitoring bracelet the night of November 22nd and fled from the group home. She was arrested at a truck stop in a Chicago suburb 1 day later, and was later extradited back to Wisconsin. Actually, while I read this, let me pull this up. Don't want that. Hold on. We have let's see. Oh, here it is. All right, so here's her arrest. All right, she had been living at a group home after she was granted conditional release over the summer. A timeline of events from the Madison Police Department said someone from the group home reported Geyser as a missing person to the police department nearly 12 hours after she was last seen at the home. This was the first time the Madison Police Department was made aware that Geyser was missing. A November 25th letter from the chairs of the Wisconsin Joint Legislative Audit Committee to Wisconsin's Department of Corrections Secretary Jared Hoy sought more information regarding the agency's response to the incident. The letter said the reports of the timeline raised serious questions about the ability of the DOC's Community Corrections Program to handle its responsibilities. In an interview with WPR, which Wisconsin Public Radio, that's what I'm reading from, committee co-chair State Senator Eric Wimberger said it was concerning to him that there wasn't a very immediate response from the DOC after it was learned that Geyser had tampered with her bracelet. In his response to the lawmakers, Hoy confirmed the agency began a detailed action review after the incident. He also said 3 staff members who were involved in the response to the incident are on administrative leave due to a personnel investigation. The result of that investigation will determine any further disciplinary actions that are necessary, and if so, how severe. Madison police said Geyser was last seen at the group home at around 8:15 on November 22nd. The DOC Electronic Monitoring Center received a tamper alarm for Geyser's bracelet around 9:38. Response times to alerts depend on a number of factors. That includes the number of alarms, staffing level, and the number of experienced staff at the center. Hoy said the center received 397 tamper alarms from 9 to midnight. So that can't be her, because if she's gone by 9:38, who's tampering with the alarms? Is that her? Did she do 397 tamper alarms? But if she, hold on a sec. Okay, so they received a tamper alarm at 9:38. So anyway, so the center received 397 tamper alarms from 9 to midnight on November 22nd. Staff at the center began looking into Geyser's alarm at 11:10. They called the group home around 20 minutes later. All right, so that was her tampering with it. Resident staff confirmed that Geyser was no longer present, so that would have been about 11:30. So around 11:30, she was no longer present, according to them. And the GPS device had been cut and left at the residence. Staff at the center issued an apprehensive request for Geyser at 12:05 a.m., which would have been the 23rd. Apprehension requests are often the first notification to law enforcement to alert that a person under supervision is wanted. So 12:05, that's when apprehension request happened. Officers see these requests during routine checks such as traffic stops or other encounters. It is treated as a notice to detain an individual and return them to custody. All right, so they alerted law enforcement at midnight, basically, right? They admitted. And the staff at the center also called Dane County Sheriff Department at 7:44. 7:44 a.m. Okay, so they called the next day, 7:44 a.m. That's when they notified the Leutners. So that's when the Leutners were notified, literally like 12 hours later. So that happened around 9, 10 o'clock, and then the Leutners were alerted the next day. So the state has filed a petition to revoke her. Okay, we'll get to that. All right, so she escapes 9, 10 o'clock. They discover her gone at like 11:30. They tell police at 12. Police then pick her up. Oh, then they alert the other police, Dane County, at 7:30. They tell the Leutners around 8, I think. She's already been gone on the run for like 8 hours. Well, 7, 8 hours. Well, no, I'm sorry. 10 hours. Yeah, not quite 12 hours. It's about 10 hours. And then they find her at 9, was it 9:30 or so? Then they find her at like 9:30. 9/11, she's arrested at 9/11. All right, let's continue on here. We've got some more here. All right, let me just make my notes here. All right, now we'll get to some news. So let's get to some news, and then we also have her being transported. Oh, you know what? Let's get to some news, and we have her being transported. We'll get to some news now, and then I have her being transported.
Nearly 24 hours on.
A Wisconsin woman convicted in the 2014 Slender Man stabbing is back in custody in Chicago's southwest suburbs. She was caught in Posen last night after leaving her Wisconsin group home.
WGN's Courtney Spinelli has video of the arrest.
23-year-old Morgan Geyser was caught here in this community more than 150 miles from the place where she was last seen. In body-worn camera video shared with us by Posen police, you can see the moment officers found Geyser last night at a nearby truck stop.
Are you missing from somewhere?
After nearly 24 hours on the run, Slender Man stabbing assailant Morgan Geyser's escape coming to an end Sunday night. An employee called police concerned about 2 people sleeping in the cold at this truck stop off 148th Street.
Okay, what's your last name?
I don't know why I have to do this.
Initially, they were reluctant to give any type of identification, and then they gave them 2 names, but the names that they gave them came back with nothing, no information.
Police Chief William Alexander says that reluctance raised red flags.
You're not wanted for murder, right?
Right.
Okay, then there shouldn't be any problem.
Geyser eventually gave up her real name and told officers once they ran it, they'd know what she did. She claimed her friend was innocent.
I will never see her again.
Yeah, you will.
No, I won't. Because I did something bad. Let me say goodbye.
We will let you say goodbye.
Geyser and 43-year-old Charlie, a trans woman whose government name is Chad Mecca, were both arrested. Charlie, who is charged with criminal trespassing and obstructing identification, spoke exclusively with WGN's Sean Lewis, saying the pair walked from Chicago to Posen after getting off the bus.
We didn't have a real plan, just get as far away as we could. Just vanish.
Charlie says the pair met at church and became friends, and that Geyser shared her plan Saturday to escape from the group home in Madison, Wisconsin. According to an arrest report, Geyser told officers she was treated unfairly at the group home and was upset she no longer was allowed to see Charlie, who on several occasions snuck in by climbing through a window. Geyser told police she cut off her bracelet with scissors and planned to potentially head to Nashville, Tennessee.
I just wanted her to be safe and not go alone.
Geyser and a friend pleaded guilty to luring their classmate into a wooded area in Waukesha, Wisconsin when they were 12 years old. Payton Leutner was stabbed 19 times and survived. The pair says they did it to impress a fictional online character called Slender Man. She was initially committed to a psychiatric hospital for 40 years, and despite opposition from the prosecuting attorney, a judge granted Geyser's request to move to a group home.
So sorry.
Back in custody Monday, Geyser was taken to the county courthouse in Markham. It appears reality hits her at this point as she sobbed for more than a minute while alone in the squad car.
I'm so sorry. I wish I had it.
Geyser is set to face a judge tomorrow for an extradition hearing. In the meantime, the Waukesha County District Attorney today says that she is highly concerned the victim's family was never notified of Geyser's escape by anyone but their office. In Posen tonight, I'm Courtney Spinelli, WGN News.
So she cut off her GPS with scissors? Are you kidding me? Right? That's what she just said. That's what was just reported. She cut her GPS monitoring with scissors. What? All right, we need more verification on that. All right, so here's her transport that they just showed, and I think this is her transport.
Thank you for at least letting me be in the car and warm.
Yeah, no problem.
Thank you for at least letting me be in the car and warm.
I mean, it's cold. These guys are like, it's cold out, I mean, they don't have food. They don't have money. What was the temperature? Somebody, if you don't mind, look up the temperature. If you guys that live, Angelique and Mallory, yeah, kitty scissors, right? You guys, what was the temperature like November 22nd? I mean, it seems like it's probably in the 30s. I mean, it's cold.
Thank you for at least letting me be in the car and warm.
Yeah, no problem.
Yeah, thank you.
I told my buddy to go get you guys your meals, a prisoner meal, okay?
What?
Some Wendy's.
Okay.
I told him to get you some Wendy's so you can eat something.
Thank you.
All right?
Appreciate it. We really do just want to be on our way, and we're sorry to have caused trouble.
No problem. I just got to find out who you are, and then you'll be on your way.
It's not going to
lying
happen.
to the police is not good. You can't do that. I gave you guys plenty of time to just give me your name or get on your way. I mean, I could even try to find you guys somewhere to go.
It's not that simple. I'm sorry, but it's just not that simple. I wish it was.
Sorry. What's that? I'm sorry. I'm sorry, God. I'm sorry. I'm sorry. I'm so sorry. I'm sorry. I'm sorry. I'm so sorry. I'm so sorry, God. God, I'm so sorry. I'm sorry. I'm so sorry, God. I'm so sorry. It's one of the blessings you gave me. I'm so sorry. I wish I had it.
All right, honey. Time to go.
All right, so that's the transfer. Now we're going to hear a little bit about Charlie. So we got 2 news clips about Charlie, and then her attorney talks, and then we'll get to her hearing. So we got 4 more things to play, and then we're going to be done. Then we're going to be done. So just a few more minutes. Then we'll be done with Miss Geyser. Wow, what a journey this has been. I feel like I'm on.
Morgan Geyser is now in custody.
I feel like I'm part of some Greek tragedy or something.
Morgan Geyser is now in custody in Cook County, Illinois, awaiting extradition back to Wisconsin. She was in a group home after a Waukesha County judge granted her conditional release earlier this year.
So on Saturday, Madison police say she cut off her ankle monitor and then left the home with what they're calling an adult acquaintance. The two left on a bus. They were then found loitering outside a truck stop in Posen, Illinois. That is where she was taken back into custody last night. New this afternoon, Geyser's attorney Tony Cotton spoke to Inside Edition earlier.
He says he's concerned about her health now that she's in jail.
Going on the run, so to speak, seems like sort of a harebrained idea that somebody probably put in her head. Morgan has treatment needs that are not best addressed in the jail, and she's in a jail right now, so I don't imagine she's doing well being there.
TMJ4's two Waukesha County reporters have been chasing down this story all day. Kaylee Starro live at the Waukesha County Courthouse with updates from the district attorney.
While our Rebecca Clough is in Posen, Illinois at the truck stop where Geyser was found on Sunday night.
Now, before we get to them, TMJ4's Megan Lee joining us. She has just confirmed new information about the person who was traveling with Morgan Geyser.
And so, Megan, what have you learned?
Yeah, I just confirmed with the Posen Police Department that 43-year-old Chad Mecca from Janesville was with Morgan Geyser at the truck stop in Illinois. According to the police report, Mecca and Geyser were found sleeping behind the truck stop Sunday night. Both reportedly told police that they took a bus from Wisconsin to Chicago. Then from Chicago, they walked to the south side and got on a bus to Posen when they ran out of money. The police report shows the two of them met at a church in Madison. Geyser reportedly told police Mecca would climb through her window at the group home and sneak in since they weren't allowed to see each other. The two then decided to run away with each other, headed to Nashville, Tennessee. Chad Mecca was charged with criminal trespass and obstructing identification. Live in the newsroom, Megan Lee, TMJ4 News.
All right, Megan, thank you.
Ooh, I definitely want to see that interview. I would love to see that interview. All right, I thought there was more with Charlie. All right, hold on. Here's another report with Charlie. I think he talks, or they talk. She talks. Not quite sure.
This is new video of Mecca in the back of the squad car. This is new video of Mecca in the back of the squad car right before police released him out of custody. And tonight, the APC station in Madison reports a person identifying themselves as the person arrested with Geyser, calling their newsroom saying that they're leaving Madison with Geyser and that was the best way to keep her safe. Now, here's part of that phone call.
I did not find this out until mid-morning yesterday, already in Chicago.
Find out what?
He ran because of me.
Well, Mecca, who also goes by Charlie, says the pair met at a church and formed a strong friendship. Mecca says Geyser wanted to escape because she was worried the group home she was living at would not let them visit each other.
She sobbed. She's like, they'll take away our visitation, Charlie. Lose you, and you're my best friend. And you know that before you showed up, I was ready to drink bleach and just all this stuff. And the thing of it is, she already made it clear if I didn't go with her or not, she was still going, and she was not going back to jail. And I know what that means. At the end of the day, I followed what I thought was right, and I stand by it.
Now, the police report says Mecca and Geyser were trying to make it to Nashville, Tennessee. Officers released Mecca with a citation notice. Mecca's court date is scheduled for January 15th.
Okay, so according to Charlie, according to that, Morgan was going to bust out no matter what. And and she wasn't going back. So she was going to bust out no matter what, according to that little report right there. And then if he didn't go with her, then she was going to drink bleach or do something like that. All right. He does have a hearing January 15th. So we will, if they show it, I hope they show it. Hopefully we can stream that and we can check that out. All right, here comes Mr. Cotton. Let's check him out.
Part of me still sees Morgan as the kid that she was when I first started representing her. Got her back.
First at 6, the lawyer for one of the Slender Man stabbing suspects says he will keep representing her once she is returned to Wisconsin. Morgan Geyser was in a courtroom in Cook County, Illinois today. She agreed to be extradited back to Wisconsin.
She left her group home in Madison Saturday night after cutting off her GPS monitor. The Waukesha County District Attorney's Office, which was against her conditional release, says it wants to see Geyser returned to a mental health facility. It will be up to the state to decide if her conditional release will be revoked.
Questions remain about why Morgan Geyser walked away from that group home and whether she should have been allowed there in the first place.
Our Charles Benson asked Geyser's attorney Tony Cotton about advocating for her release and his decade-long efforts to help her.
Tony Cotton has known Morgan Geyser since she was about 12 years old, a shocking crime case that attracted national and international attention because of the reference to Slender Man. He learned from a friend over the weekend that the 23-year-old went missing.
What were your concerns at that moment, knowing that she was now somewhere out there?
So I wasn't concerned that she would be violent. My fear was sort of twofold. One, who is she with? What negative influence might have encouraged her to do this.
The other, he says, the consequences or setback for what happened over the weekend. Cotton will have to address that going forward. But he tells me he has no regrets with the decision to advocate for Geyser's release in September to a community group home after years at a state-run mental health institution.
When you were advocating for help, did you think help could really change her and help her?
Yeah, and I think yes, and I think it did. I think that Morgan, if you look at the maturity that she exhibits at 18, 19, 20, her understanding of mental health, her cooperativeness with treatment, her insight into her conditions, her ability to be her own advocate with the treatment providers, I mean, it's a 10 out of 10.
The Waukesha County prosecutors and the Department of Health Services raised serious concerns Geyser was not ready to be released, despite unanimous support from doctors monitoring her.
I think the doctors were all right at that time and continue to be right now.
So if someone says, see, I told you so.
Told me so what? That people who have mental health struggles are going to have ups and downs. They're going to have good days and they're going to have bad days. They're also going to make bad decisions.
Cotton did have one big concern, and it wasn't really with Morgan, but with people fascinated by her case.
The risk factor I saw was that she could get taken advantage of by an older man. Either because she wanted the companionship or because they want to form a relationship with her or whatever.
His long legal journey with Geyser, at times emotional over the years, will continue as her attorney.
I've known her forever.
How would you describe that relationship?
You know, it's still an attorney-client relationship, and it's, I would say, never changed from that. You could describe it almost as I see her as the same way I see my children, in a way, that she's somebody that I care about on a personal level. I want the best for her. I've watched her grow up before my eyes.
At the time of our interview, Cotton had yet to talk with Geyser about the last 48 hours, but plans to do that as soon as she is back in custody in Waukesha County. Back to you.
All right, so there's two things. A, he's going to represent her. He's going to represent her again. And B, I think he said he thinks of her as his own children. So I think a lot of these providers, these caregivers, these attorneys, these doctors, whatever, you know, they see this young, well, she was at the time young, she still is young. They see her as this young, innocent, frail, I don't know, whatever it is they see in her, and they want to protect her almost to the point of like their detriment, you know, or the community's detriment. You know, I mean, that's when you see somebody as your own, and that's fine, you know, but I think, I don't know, just seems to me these doctors just got a little too close. They just got a little too close, and they weren't able to just take a step back and really objectively look at this after a while. So, all right, one more thing. We got one more thing, and then we will wrap it up for today. And this is about 10 minutes. Now, let me warn you. All right, so I'm going to warn you now that this the audio is terrible, and I think we only hear the judge. So you can't hear the folks on the Zoom, okay? So you can't hear people on Zoom. You can just hear the judge in the courtroom. So be prepared. Audio is just judge, not the Zoom.
CF 596, State of Wisconsin versus Morgan Geyser. Can I have appearances, please?
Abby Nikolai appears on behalf of the state. Good morning, Judge.
And good morning. We also have a DHS representative on the line. We are here to discuss the petition for revocation for conditional release that was filed on November 25th. And in particular, Ms. Geyser's stated intention not to contest the petition for revocation of conditional release and waive the evidentiary hearing on same. Just as a matter of what I think is undisputed, Mr. Cotton, there's no dispute the petition to revoke was timely filed under the statutes. Is that right? All right, and by way of background, just to catch us up, Ms. Geyser was previously found not guilty by reason of mental disease or defect in October of 2017. In February of 2018, Judge Boren sentenced Ms. Geyser through an order of commitment for 40 years. On January 9th of 2025, Judge Boren deemed that conditional release was appropriate and entered an order that she be conditionally released. And while it took a while for the conditional release plan to be developed effectively, the actual conditional release plan was finalized in September of this year. And after certain events occurred, the DHS filed a petition to revoke Ms. Geyser's conditional release on November 25th of 2025, and that's what brings us here. In that petition, the DHS alleged that revocation of Ms. Geyser's conditional release is appropriate under WISSTAT section 971.173E, and the state contends that both the conditions of Ms. Geyser's conditional release were violated and that remaining on conditional release would pose a risk both to her own safety as well as the safety of the community. The allegations include, and I won't go through them all, that Ms. Geyser fled placement, cut off her GPS monitor, and committed other violations of the conditional release order. In support of their petition, the state has alleged, the DHS has alleged, that Ms. Geyser violated the rules for conditional release, and under the circumstances, her release would involve a continued heightened level of dangerousness if she remained on conditional relief, both to herself and for others. In my understanding now, based on Attorney Cotton's earlier correspondence, is that Ms. Geyser intends to waive any objection and will not be contesting the petition for conditional release. Is that right, Mr. Cotton? Okay, thank you. I just have a few questions for Ms. Geyser just to make sure she's making this decision freely, intelligently, and voluntarily. And Ms. Geyser, you've had a chance to review the DHS position for revocation of conditional release? Okay, and you've been able to review it with your counsel, and he's answered any questions you may have had about it? And Ms. Geyser, you understand you're entitled to have an evidentiary hearing on the DHS position to revoke your conditional release? And you understand if we had that hearing, it would be the state's burden of proof to show that the revocation of conditional release is appropriate. You understand that, ma'am? And you further understand that the burden of proof the state would have to face is to prove that by clear and convincing evidence. Okay. And your counsel, for you, waived the 30-day time limit for having that hearing on your behalf, but we currently have a hearing set for February 16th, 2026. You understand that, ma'am? And if we have that revocation hearing, you understand you would have the right to be represented by counsel, is that correct? You'd have the right to see and hear the evidence the state presents at that hearing, is that correct? You understand you'd be able to present evidence and witnesses on your own behalf, is that correct, ma'am? And you understand you'd also be able to cross-examine the state's witnesses, is that correct? All right, and you've been satisfied with the services of Mr. Cotton, is that correct? And earlier on December 16th, 2025, Attorney Cotton provided me with some correspondence indicating that you have elected not to contest the position to revoke your conditional release, and that's true, ma'am? And you are satisfied that you've had ample time to discuss the ramifications of waiving that hearing and the burden of proof the state would have to face if we had that hearing, is that correct? Okay. And your counsel is able to answer any questions you might have about the DHS petition for revocation of your conditional release, is that right? And at this time, is it your decision to waive the hearing on the petition for revocation of conditional release? And you've decided not to contest the merits of the petition for revocation of conditional release, is that right? And you understand that if you waive your right to a revocation hearing, ma'am, the court will revoke your conditional release in order you return to inpatient commitment or other custody under section 971.17, okay, and the state will not have to prove any violations of the hearing, ma'am. You understand that? And you understand that revocation of your conditional release will result in your continued confinement under your NGI commitment, subject to further future review as provided by law. Is that correct? And again, you've had what you believe to be sufficient time to discuss this decision with Mr. Cotton. Is that right? And no one's promised you anything for waiving your right to contest the petition. Is that correct? And no one's threatened you to make you waive your right to contest the petition. Is that correct? And you're making this decision to waive the revocation hearing freely, intelligently, and voluntarily. Is that correct? Okay. And you understand, finally, by waiving that revocation hearing, you're giving up your right to contest the allegations in the state's request for revocation, correct? And knowing all these rights and consequences, do you knowingly, intelligently, and voluntarily waive your right to a revocation hearing under WSStat 971.17.3e? Thank you, ma'am. Do you have any questions at all for me regarding your decision? Mr. Cotton, you've reviewed the petition. Thank you, ma'am. Mr. Cotton, you've reviewed the petition for revocation of conditional release and related documents that were filed by DHS? And you've had an opportunity to discuss the petition and related documents with your client? And are you satisfied she understands the state's burden, legal standards, and other ramifications of her decision not to contest the petition for revocation? Thank you. And you've heard your client indicate she wishes not to contest the state's petition, correct? And you've reviewed this waiver with your client, and you believe she understands the rights being waived and is competent to make this decision. Based on your discussions with your client, is it your belief that Ms. Geyser is making the decision not to contest the state's petition for revocation of her conditional release freely, intelligently, and voluntarily? Thank you. Ms. Nicolai, do you believe any additional colloquy is necessary?
No, thank you.
Based on my discussion with Ms. Geyser and her counsel, as well as my review of the relevant filings made by the DHS in connection with this petition to revoke conditional release and related filings, the court finds that Ms. Geyser has freely, intelligently, and voluntarily made the decision not to contest the DHS petition for revocation of conditional release and waives her right to a hearing on same. Accordingly, the court finds that the petition to revoke conditional release is meritorious, uncontested, and it is granted. The petition to revoke conditional release is granted, and Ms. Geyser is remanded into custody with directions to DHS to house her pursuant to the original commitment order that was in effect prior to the granting of conditional release by Judge Boren earlier this year. Anything else we need to do from any of the parties?
Judge, I do have the CR 276 that I can e-file.
Okay, and we will take care of that. Thank you. Mr. Cotton, anything on your end? Okay, thank you all. Have a good day. Good luck to you, Ms. Geyser.
And that about does it. Let me just see if I can find one more thing. we'll end this with a news clip, because why not? Oh, and then I have something fun to show. Something that Aaron made.
Well, Morgan Geyser, the Slender
All right.
Well, Morgan Geyser, the Slender Man stabber who escaped from her Madison group home last month, appeared in Waukesha County Court today. Today's hearing regarded her privileges for a possible release. Ryan Lynch has you covered on what happened today and what this means for Geyser.
Tuesday in court, Morgan Geyser waived her right to a revocation hearing, meaning she will return to inpatient custody. Geyser did not say much, but confirmed her decision with a quote, "Yes, sir." This follows her attorney's statement last week that she would not challenge the court order to revoke her conditional release. Geyser had been staying at a group home in Madison after being released from a mental health facility. But last month, authorities say she cut off. Both were arrested on November 23rd in Posen, Illinois, south of Chicago. A Cook County judge ruled that since Geyser had no criminal record in Illinois, there was no point in keeping her in the state. She was extradited back to Wisconsin and returned to the Waukesha County Jail. After the escape, Morgan Geyser's attorney requested that she be moved to a mental health facility. And according to our Milwaukee affiliate, Geyser is now back at the Winnebago Mental Health Institute.
All right, so there you have it. Now, this is from December 30th. I don't know if this is anything new per se, but I'm going to read it anyway. All right, so a judge in Wisconsin ordered the woman convicted in the 2014 Slender Man case to go back to state psychiatric hospital after she escaped from a group home in November. Judge Scott Wagner approved the request from the State Department of Health Services to revoke 23-year-old Morgan Geyser's release privileges. She's being held at Waukesha County Jail after being extradited. All right, so I think we've already kind of heard this. So Anthony Cotton wrote, given that she has no new criminal charges in Waukesha County, and given that she has been previously found not guilty by reason of mental disease or defect on the underlying offense, it is our position that she should be housed in a mental health facility, not a correctional institution. Cotton wrote. That's it. So that's it. All right. Ooh, I have one more thing. Let's end it on something silly. Let's end it on something silly. For those that didn't see it, sometimes the squeegee needs a squeegee.
Well, I can leave them out here.
Sometimes squeegee needs a squeegee. Give me a moment. All right. Sometimes squeegee needs a squeegee.
So I was like, I know what to do. So I was like, just let me call and see y'all know something. I told them that I believe Robin said a lot of very good seats here, so they should be. Where you guys from? Well, I can leave them out here. So I was like, I know what to do. So I was like, just let me call and see y'all know something. I told them that I believe Robin said a lot of very good seats here, so they should be. Where you guys from? Well, I can leave them out.
All right, twice is just enough. 2 times is just enough. Sometimes squeegee needs a squeegee. Hole in my lip. Yes, I have a drinking problem. You can clearly see I have a drinking problem. All right, that does it, you guys. All right, so that does it for Morgan Geyser. We can put the Odyssey, the Odyssey, the Greek tragedy, whatever you want to call it, that is Morgan Geyser, the saga of Morgan Geyser. We can put to bed. And then tomorrow we can start in on Anissa Weier, or Weier. I think she goes by Weier. So tomorrow we're going to pick up, we'll start Anissa Weier's journey, and we can put Morgan to bed for now. And we'll pick up on her next year, because she's going to have, I'm sure there'll be other hearings, and well, maybe not. Well, maybe in 6 months from now, we'll hear from her. So. All right, you guys, thank you so much for joining us. Are there any little kittens around? I see I see a little Rafa bean. There's a Rafa and little Cheddar over there, little Roger. Oh, they're like little bookends. Roger. No, Rafa knows his name. And I got little bean down there, little bean down there. All right, you guys, thank you so much for joining us. Thank you to Aaron for putting together the short and the graphics. I got kitties passing in the night. And thank you to our mods. You did a fantastic job today. Thank you guys for joining us. Really appreciate you spending your day with us. And tomorrow, programming note, tomorrow we will start at 9, right? 9 o'clock. 9 o'clock start tomorrow for Anissa. We're gonna start in on her. She's gonna go, I think, 3 days. I think her trial was 3 days. So we're gonna go Wednesday, and then Thursday is New Year's Eve, and then Friday, and then we'll pick up on Saturday. We'll do maybe a Saturday or Sunday stream. And then New Year's Eve, we're going to be live. I will be at the beginning, and then we'll see how it goes after that. We'll see how it goes after that. Nobody else will be on. It's just going to be me, and we're going to be playing music. We have a soundtrack for you guys, and my hope is that we can have video from around the world as New Year's is being celebrated around the world. We'll do that. We'll catch that. So anyway, thank you for joining us, and we will see you tomorrow at 9 o'clock Eastern. Have a good night, guys. Bye.